Hey, good morning, gang. Good morning. If you in the building, hit the like button, gang. Hit the like button. We about to get into this Melly mail trial. Shout out to the game. I'm gonna put a questionnaire in the crowd too as well. All right, here go Mr. Melly Mail in the courtroom, looking as crazy as he can look. All right, shout out to the game, man. If you in the building, hit the like button, man. I see Beverly coming in. All right, we see Beverly, Lady J. Lady J is in. All right, D Tracy investigates. I rock with you, TV. All right, what's up? Let's get up in here, sexy and complete. What's up with sexy and complete? All right, now this nigga walk in the courtroom smiling and laughing, bro. This nigga's going to die. He is going to fucking die. All right, fuck what you got going. He is going to die. They are going to kill this nigga. I do not see him beating this goddamn case. All right, I do not see it. And this bitch on the left, oh my God, I got something to show y'all about this bitch. I got something to show y'all about this bitch on the left. I'm not going to show y'all right now, but that bitch on the left, she's just as much as a criminal as he is. All right, good morning to the gang. All right, for y'all that don't know, we will be live later on. We will be live later on with the jackyje case. Let me put that in the comments too so y'all can see. All right, we will be live later on with the jackyje case. Right now, we are just definitely coming in to witness this bullshit. All right, but I just put it in. All right, but this nigga's going to die, y'all. I'm sorry. He ain't gonna beat this one, y'all. Especially he laughing all through court. I don't see it. All right, look like we about to get started though. They standing up, so look like we about to get started. But nah, this nigga, I don't see it. Good morning to everybody. Go, gang.
His counsel, the assistant state attorneys. My understanding is we're missing a couple of our jurors, so we're not ready to proceed yet. But my office did get a call from one of our jurors, Claudia Campuzano-Mena. She evidently was in the emergency room on Friday. She thinks she had food poisoning, is what I'm told, and she was discharged. Everything seemed to be all right, and then she's back in the ER now as we speak. She called and let us know. She said something about she getting checked out and examined now in the emergency room. She asked my secretary, can she come in the afternoon? But we don't know what her status is. And so I don't know how you want to handle it. So you talk about it amongst yourselves. Let me know all the jurors are not here. We're still missing two. All right. So.
Two in addition to her?
Yes.
Okay.
Judge, can we approach the bench very briefly?
Sure.
Hey, good morning, gang. I think they said one of the jurors is sick. I'd be sick of looking at that ugly ass nigga too. So if I was a juror, I have a stomach ache looking at that ugly, big, dirty grill ass nigga right there too. I can't even believe this nigga made music. I wouldn't listen to his shit if you man. This ain't no murder case. This is I don't know what this is. Good morning, Kim Lee. Good morning to everybody in the crowd, man. Good morning to everybody in the crowd. All right, good morning to the gang. All right, later on, gang, we will be, and I just put it in the crowd, we will be talking about the jackyje case at 11 o'clock Eastern time. All right, so shout out to everybody in the crowd this morning. All right, I guess he think he's gonna beat. We're talking about this in the club battle. I guess he think he's gonna beat this shit. I don't know. Shout out to Silver, man. Good morning, Silver. Silver stepping in. I think that one of the jurors is sick. I think I just heard the judge say one of the jurors is in the hospital. So if that's true that one of the jurors in the hospital, they either gonna have to substitute that juror out or whatever else they gonna do. So they're talking about it right now. They're talking about it right now. Good morning to everybody in the crowd, man. The two unknowns, D and Lee. Good morning. Good morning. Have Frank say lights and master views. We got like 57 people in the room. Let's get in here. Let's get warmed up for this morning. We got a good show later on with jackyje. Good morning to everybody stepping in, gang. It would really take something to make do something like take people I grew up with. Shout out to KP. They said possibly food poisoning. Stomach full of protein. Shout out to Michaela. One of the jurors got a stomach full of protein. This nigga think he finna be the murder trial because the juror's sick, my nigga. I've never seen nobody smile. Nigga don't even smile at traffic court. Nigga get a red light ticket or a speeding ticket, nigga don't be in court smiling. This nigga got a double fucking murder. Like a double cheeseburger. And this nigga smiling his ass off. Can't make this one up. This nigga's crazy, y'all. Yeah, they said he was in the ER. Shout out to Queen Brill. Queen Brill say he's in the ER.
What are the benefits?
He's smiling all the time.
Networking, big bullet point. Learning about different opportunities.
He done already lost his freedom. Now he finna lose. Oh my God! Did y'all see that? Oh, did y'all see that? Bro, don't ever open your mouth that wide, nigga. I just woke up, bro. Don't ever open your mouth that wide, my nigga. Chill out, bro. Do not ever open your mouth that wide. They telling them now, nigga, why you smiling? Look at it. He gonna look at the camera. They telling them now, nigga, what is you doing laughing, my nigga? This a murder trial. Okay, I ain't gonna laugh no more. Don't ever open your mouth that wide, you ugly ass demon. Golly, boy. Look, if you on a murder trial, do not conduct yourself like this fuck boy right here. All right? It's different ways to conduct yourself on different trials. This nigga act like he got a speeding ticket. Nah, nigga, you are going to get the death penalty. They're gonna fry your ass, you dumbass. How old is this fuck boy? Man, you a fuck boy, man. I'm sorry. Excuse me, y'all. I just woke up. Look at him. He telling the turn like, okay, I ain't gonna laugh. Okay, you dumbass, you ugly big teeth bitch. They gonna fry your bitch ass, nigga. Sitting up here laughing with your mouth wide open, nigga, like the camera ain't watching. You a boy. You a dumb for going to trial, nigga. You should have just took a plea, hoe ass nigga. Oh my God, y'all. We wait, and then I don't even think everybody ate in the crowd. If you did eat, you may throw your shit up. Oh, look at that court report. They got another court reporter. I mean, this nigga done opened his mouth up wide as fuck. All right, so they let me see. I think they blocking the camera right now. They blocking the camera right now. This shit is crazy, gang. Shout out to the game, man. I'm narrating some bullshit right now. I'm sitting up here narrating some bullshit. All right, but if you're in the building, come on in the building, man. We in this bitch for this crucifixion. Sitting up here witnessing this big mouth ass nigga about to get the death penalty. All right, nigga about to get the goddamn death penalty. But shout out to the gang. Let me see who in the crowd. Let me come back to the crowd, man. Yeah, he's getting the needle, man. The chair, the needle, the skillet. He getting everything. Chair, needle, skillet. That nigga getting everything, goddamn it. All right, let me see, man. Good morning to the gang. Yeah, he did it. I read the paperwork. Matter of fact, we got the paperwork. He definitely did it. He definitely fucking did it. Damn, he got to be out there, bro. What if he really ain't? What the fuck? Who's this motherfucker waking up this morning with this bullshit? Hold on. Let me block your bitch ass, nigga. Get the fuck up out of here, nigga. Get your bitch ass up out of here, nigga. Whoever you is, nigga. Tell your ass, dumb Diego. Tell me what if he didn't do it? Bitch ass nigga. I got the paperwork in front of me, hoe ass nigga. He did it. Fuck you mean? What if he didn't do it, nigga? He did it. Dumbass. Who the fuck get on trial, my nigga, laughing at nigga? You want me to show you the paperwork? Dumbass Diego. Get the fuck off my page, nigga, before you get mollywopped and internet beat up around this motherfucker. Shout out to the game, man. Niggas be sneaking them in, boy. He should be fighting for his life, acting accordingly, not laughing and smiling like an idiot. Shout out to Queen Brill, man. Good morning, Lady J. Good morning, Levi the legend. Beverly laughing. You see how they be sneaking it in, Beverly? Oh, yeah, we about to have a block party in this bitch. You see how they be Brill? They sneak it in. They think I'm too tired to say, get the fuck up out of here. They be sneaking shit in. This nigga sit here and but you know what? It looks like, I don't know. Yeah, it's too early. Shout out to Beverly. Beverly says it's too early, man. Why is this nigga fucking with paperwork? Nigga, it's too early to be fucking with me, nigga. Nigga, you got blocked before the trial even started, nigga. It's too early, bro. Talking about what if he didn't do it, nigga. I put the poll up. Everybody in the crowd say he did it. Fuck you mean? He's going to get the death penalty. He will be dead in about the next 2 years. Shit. If they don't appeal the shit, that nigga's losing this trial, gang. You know how you watch a basketball game and you know who about to win, who about to lose? That nigga's about to lose. Nigga, we in the first quarter, nigga, and you lose. You in the first quarter and we know you gonna lose. Shout out to Chaz the Don in the house, man. 8-4 verdict, he don't stand a chance. That's what I'm saying. Even if this nigga was to, like, he's going to get the death. That's what I'm saying. He's going to get the death penalty. Like, oh my, I don't even know. I don't even know how to explain it. It's just stupid. This is one trial that never should have went to trial. It's no way in hell this nigga gonna beat this bitch. That nigga gotta throw a Hail Mary. You know how you throw that bitch from one end of the basketball court to the other end, that bitch go out. That's the only way you gonna beat this bitch, with a Hail Mary and that bitch go in, nigga. And matter of fact, you know what? Let me show y'all how I know he ain't gonna beat it. I'm gonna show y'all, let me see if I can pull that picture up real quick. That nigga is not beating shit. I got a picture. Let me see if I can pull it up for y'all real quick before they get back started. Y'all was laughing y'all ass off. Oh, here you go. Here you go, right here. Here you go, right here. Now, I'm finna show y'all a picture. This is one reason I don't believe he's going to beat it. All right, shout out to the game. Appreciate everybody coming in. I got something to show y'all. It's one reason I believe he's not going to beat it. Pull this picture up for the game. Now watch this, gang. I'm finna show y'all something. All right. That's his attorney, y'all. That's his attorney. That's his motherfucking attorney. Raven Liberty is a damn criminal. Bro, you sitting by a criminal-minded bitch. How the hell you gonna beat this shit when your attorney is a criminal? Come on, gang. Come on. Look, y'all know we pulled up all the paperwork. Y'all know we got all the paperwork. How you gonna beat this shit when your attorney is a criminal? Raven Liberty just got out of jail. It's like she got out of jail to do this case. Come on, gang. Y'all didn't know this shit? Look at everybody in the crowd like, damn it, yeah. I'm finna wake y'all up this morning. I'm finna wake everybody up. All right? I'm finna wake everybody up. Look at his attorney, y'all. Look at Raven Liberty. So now when you look at her in court, you're going to look at her a whole different way. You're going to be like, wait a minute. Did she just get out of jail? She just got out. How you going to get out of jail and you represent a fuck boy? Come on, gang. Look at Richard said, damn, Richard, you didn't know that, Richard? Come on, y'all. Y'all waking up with the paperwork party. We ain't got none but receipts on this channel, gang. I ain't worried about lying crime. I'm worried about us. We the ones got the receipts. Look at Michaela. Michaela like, wow. Michaela. Now, I'm not finna drop her paperwork because, you know, we got his paperwork, but if they fuck with me, I don't even think she beat her case. I think she on probation. Either she on probation or bond. Either one. She may be on bond. I think she on bond. All right. I don't even think she beat her case. All right. I don't even think she beat her case. Shout out to D Tracy. D Tracy, I love me some paper. I love you too, D Tracy. Look at the attorney for him. She's a fucking criminal. Silver said, you done made Silver drop her grits. You done made Silver drop her goddamn grits. Silver said, well, damn. What the fuck? Silver, I told you I wasn't playing, Silver. I told you. Michaela said, we can always count on paper. Hey, look at the screen. Look at his attorney. All right, this is a damn shame. It's the blind leading the blind. Shout out to Queen Brill. She's shaking her head. It's the blind leading the blind, gang. Look at this bitch. Look at this bitch. Look at this bitch. Matter of fact, I'm finna type in a poll. Let me do a poll real quick. I'm gonna type in a poll. I'm gonna type in a goddamn poll. Yeah, look at Christina laughing. You got Christina all the way overseas laughing. This don't even make no fucking sense. Silver say criminals, I tell you, that's his attorney. His attorney just got out. She fresh out the pen, and that bitch eating pussy and making honey bun sandwiches. Come on, man, it's going down, man. Say la vie. Say, can we see if I can't not right now? Say la vie. I got you though. Don't worry. They probably finna start the trial back, but trust me, I got you. We got it. Paperwork party, got it. You know what I'm talking about? Blind leading the blind. Some bullshit. Look at this bitch. Yeah, she fresh out. She fresh out. She smell like a jail cell. Let me type in a fucking let me type in a poll. Let me see. Would you hire an attorney like Raven Liberty? Let me see.
Prejudicial evidence that we believe was elicited improperly, either by introduction of evidence that could not be authenticated or through the leading questions of the government or the state. And the court denied the motion on the basis that there was not sufficient prejudice, essentially, to do so. What I wanted to do was to highlight and make a motion to strike the evidence that was elicited, to be accompanied by a jury instruction, essentially letting the jury know that evidence that's excluded and the evidentiary rules are in place to ensure that only properly authenticated and reliable evidence is put before them, and that's the reason for the rules. And when evidence is put before them that do not comport with the rules, it's because it has been determined under the rules to be either unreliable or insufficiently authenticated. The specific items which I was able to identify by recollection that were introduced and ought not have been in the manner that it was done include, but are not limited to, the following. And we move to strike it from the record. Any and all phone numbers that were contained in any document Holmes was
So you're not talking about physical evidence that's been marked, something that's marked for evidence. You're talking about her testimony.
Both.
Well, what was marked in that? Why don't we do this? Why don't you put it in writing? All right, file your motion, put it in writing, give State a chance to digest it, look at it, and I'll take a look at it, and we can get back. You can have a hearing on it. This just picking out certain this, she said this or that. I don't know. Typically I rule on objections as they come. So, and I thought I ruled on everything, all the objections. If there's something that's in evidence that you're seeking to me that's already been admitted, that you want to strike and have excluded from evidence, you know, I'm more than happy to talk to you about it and more than happy to listen to your arguments. But I think I need to have something to digest it. So why don't you put it in writing, give everybody a chance to look at it, and do some research on it and find out what the law is. I don't know what the law is on that.
I'm striking inadmissible evidence.
No, the law on having something that's in evidence removed from evidence. Something the jury already saw.
One
You
thing,
put it in writing.
I understand. One thing, Your Honor, we have another court reporter now, and I think if we're going to put it in writing, it should be complete enough, and we would need a transcript of Ms. Holmes' testimony so that we can be sure to identify all offending references.
I'm sure you can order that, and you know, I'm sure
I think
that
she's out for the week, is she?
my understanding is that she had a calling from a higher authority.
Okay.
4th DCA is looking for transcripts.
I thought there was no higher.
4th DCA is looking for transcripts, and that's what my understanding she's working on. So you tell her what you need, and I'm sure she'll get it to you.
Okay.
All right, so we'll be in recess. I'm going to make a phone call, and I'll have my Jay make a phone call, find out what the status of the juror is. All right?
Yes,
sir.
Judge.
We'll be in recess.
All right, gang. So can somebody tell me what the fuck just happened? I was doing something else. All right, what just happened, gang? What just happened? Are they not going to have court today? Let me know. Texan 33, man. Shout out to Texan 33 in the house, man. Season 1, 2, and 3. My boy Texan 33 waking up with the paperwork party. Shout out to Texan 33. Are they going to have a trial today? We need to know. That go Raven Liberty. Let me check the poll. I put a poll up. Let me see. Hold on. Let me see what people say on this poll. Wait. Would you hire an attorney like Raven Liberty who is fresh out of jail? 20% said yes. Hold on. 19% said yes. 81% said no. Whatever. Whoever that 19% is, let me know in the crowd. All right? Whoever the 19% is, look at motherfuckers. Somebody just took their no away and put a yes. You motherfuckers. I'm going to get y'all, man. I'm going to get y'all. All right, but we ain't tripping, y'all. We ain't tripping. Look at her. That's his attorney. All right, that's his attorney. Shout out to the gang. Now, like I said, everybody, get in trouble every now and then. But this is an attorney. You see what I'm saying? Oh, okay, so good one. You said you would hire her. Okay, I'm not. Hey, good ooze. My bad, good ooze. Shout out to good ooze. Good ooze said you will hire her. All right, good ooze will hire her. All right, we got you, good ooze. We got you. Let me see. Get him, judge. Give him a refresher course in law. Yeah, tell that nigga he better go. He definitely better go do his thing. Let me see. One of the jurors in the hospital, so they're trying to see if the juror will make it to court today. Bro, if that juror come to court today, he's going to throw the fuck up looking at YWM Melly. All right? I'm talking about why I would throw the fuck up if I had to go look at this dude. That's probably why he in court. Looking at this dude. All right, so let me see. If he was a rich crook attorney, shout out to Say La Vie. Say La Vie waking up with us this morning, man. I'm not really supposed to be up. The show started at 11. I was up for this trial. If I knew a jury was fucking in the hospital, I'd still be asleep right now. But as you can see, yeah, a jury's in the hospital. And she's a criminal. What if she the one put him in the hospital? What if this woman poisoned the juror? All right, who think that Raven poisoned the juror? All right, she look like she'll do some shiesty shit like that. find out who the jury is, go poison a nigga. What if Raven is the one that poisoned the juror? What if Raven Liberty is the one that poisoned the juror? All right, so this is a very, very complicated case. All right, very, very complicated case. So that's what we dealing with, gang. That's what we dealing with. Yo, what if Raven poisoned the juror? All right, so look, I guess since I got y'all in here, I can pull some paperwork up real quick. Let me go ahead and go to the YNW Melly folder. I already showed y'all the witness list the other day. Let me show y'all this one again. The warrant suits. For y'all that don't know, yo, what if Raven the one poisoned the jury and put that nigga in the hospital? All right, gang. So the judge has made it very clear in this case. The judge has made it very clear in this case that Melly can only wear 5 suits for the next 2 months. All right, so this is the paperwork showing that YM Melly is only allowed to wear 5 suits for the next 2 months of his trial. So I think we did the math on that. That's what, 2 months? That's 60 days. 60 divided by 5 is 12. He got to wear each suit 12 times. That's nasty, gang. That is fucking nasty. That's gross. All right, this is the paperwork in his case. It says the judge hereby orders the sheriff officer to allow the defendant to have no more than 5 suits for trial. That's nasty. That's nasty, nigga. If you finna be on trial, he already musty. Y'all see that nigga be smelling his underarms and shit. He already musty, gang. So now we know. Now we know this nigga ain't allowed but 5 suits. He already musty. He is already fucking musty. So the judge has made a decision in this case. He can only wear 5 suits. All right, that's nasty. And when you see him with his suit on, because we've already seen what, 3 different colors, 3 or 4 different colors now. Actually, I think he's going back around. How long he been in trial? About 6 days. So now he's starting to go back. He's starting to go back to his suits now. So he going back around now. All right, he done already wore the 5 out. Now he's back to you see what I'm saying, to wearing the rest of his suits. I think Levi just answered the question. Clarion Kids. Shout out to Clarion Kids in the house. Let me see. They should have alternate jurors. I've seen it in a lot of cases where they have jurors waiting to come in. If something happens to a juror, you see what I'm saying? They have jurors waiting to come in. Nikki say he back to suit 1. No, Nikki, no. Nikki say he's back to suit 1, y'all. Nikki, leave him alone, Nikki. That's YM Melly. Nikki say he is back to suit 1, okay? All right, gang? All you got to do is do the numbers. Do the numbers. He is back to suit 1. All right? That's nasty. That is so fucking nasty. But that's how it's set up. It's set up like that. The judge put that as an order. Look, this is an order. He made this order in July 2022. It is an order. YWN Melly cannot have no more than 5 suits for trial. That's an order. All right, so pay attention to his suits, gang. Pay attention to his suits. All right, Nikki say he's back to suit 1. Pay attention to the rotation of this man's suits. All right, Levi say he got the same dirty ass turtleneck on. I think the judge may have put an order in only 1 turtleneck. All right, only 1 fucking turtleneck. Yeah. Say La Vie say he better start mixing and matching. Wait a minute. I wear all navy blue suits so no one would notice. Somebody gonna notice. Somebody gonna notice. Somebody's gonna say, hold on, bro. Did you have that suit on yesterday? Nah, that's YNW Melly. You know that they ain't got the same suit on. Shit. Ain't what the judge said. The judge say, nigga, you are hereby ordered to have 5 suits for trial. If I find out that you have any other clothes, you will be sentenced to death. You will get the death penalty. All right, we're going to pass it down to your ass. Only 5 suits. All right, let me see. Let me see some more paperwork. Hold on. Matter of fact, let me see, gang. Let me find some more paperwork while we stalling for this trial. Oh my God, these depositions are crazy. Let me see the T-Mobile warrant. Let me see if y'all want to see the T-Mobile warrant. Cause they got all his phone records. Let's see. All right, gang. Here's the T-Mobile warrant right here. All right, here's a T-Mobile warrant. The judge ordered denied defendant's motion to suppress evidence obtained from T-Mobile. So T-Mobile, look, that's how you know he gonna lose, gang. That's how you know he gonna lose. All right. They got his T-Mobile activity from his phone. The defense tried to put a motion in to throw out this evidence to where the jury can't see his motions. They know exactly where he was from the time. My bad for yawning. They know exactly where that nigga was from the time the murder occurred to the time they tried to cover it up. So the defense put in a motion to suppress the evidence obtained from T-Mobile, from the T-Mobile warrant. And the judge said, hell no, this cause came before the court as the defendant motion to suppress. You see what I'm saying? The court held hearings on the defendant's motion on April the 6th. Having considered the defendant's motion, the state's motion to strike testimony and evidence presented at the hearing, arguments of counsel, the court filed applicable law, and otherwise being fully advised. All right, let's read through this real quick while we waiting on them to get back. Detective Mark Moretti stated in his T-Mobile search warrant affidavit that the defendant placed a call to his mother, Jamie King. All right, they got the evidence. Just after the shooting, requesting that she come and pick him up. Wow, nigga, so you killed somebody and you called them on a T-Mobile phone and you told your mama to come pick you up? What the fuck? I haven't even read this paperwork, y'all. This is my first time reading it with y'all. All right, so YNW Melly killed 2 people and then he used his T-Mobile phone to call his mama to come pick him up. Bro, they're going to fry your ass. They're going to fry your ass. Detective Moretti received this information directly from Mrs. King at the hospital, who identified herself as a defendant's mother and provided the phone number ending in 9807. Miss King, his mama was snitching on him. Miss King identified his number as defendant's defendant's cell number. So your mama was snitching on you, bro. Your mama told the detective all this shit. Let's keep going. Detective Moretti believes that Miss King was with Miss Ashley Phillips, the aunt of one of the... Oh, Jesus, help me out. I didn't know this. Oh, my God. Are y'all reading this shit? I'm looking at the crowd. Are y'all reading this shit? YWN Melly, his mama was at the hospital with the nigga that he killed mama. Oh, you can't make this shit up. So wait a minute. You kill a nigga. Hold on. Let me explain what we just seen, y'all, because this is my first time reading this shit. You kill a nigga And when the nigga mama go to the hospital to go see the body, she takes your mama with her as a confidant. And then you call your mama and say, hey, mama, come pick me up. And she's sitting there with the mother of the person you just killed, my nigga. You can't make it up, gang. You can't make this up. And so the detective scooped him. Oh, Jesus, you are, boy, this is the death penalty for your ass. They got your T-Mobile word. Oh, let's finish reading this shit. This shit is good. This shit is good. Shit, y'all, I can't believe this shit. Shout out to Christopher, man. We going through the paperwork right now. What's up, Miss Prissy? Virgo said they was friends. Shit. You ain't my motherfucking friend, nigga. You killed me, nigga. Fuck you. You ain't my friend. Shout out to Virgo. Makeda said, wow, this is crazy. He killed the person his mother's with the victim's mother. Wow. That's what I'm saying, Levi de Leon. That's some next level ass shit. But you guess what? You never would have known this without the paperwork. So we got the paperwork on this channel, okay? All right, so let's finish reading this shit. Marati believed that Miss King was with Miss Ashley Phillips, the aunt of one of the victims, and other family members. Detective Marati did not know if anyone was within earshot when he spoke with Miss King. She walked out in the hallway with that call. She was like, let me go in the hallway. Let me take this. I know she wasn't sitting there talking to this nigga while she was sitting there with Miss Ashley. She had to go out in the hallway with this one. Let me see. Although Detective Morelli does not remember the exact time when he spoke to Miss King at the hospital, he remembers that it was still dark outside. So wait a minute. So you kill a nigga and the detective is at the hospital talking to your mama. Boy, yeah, I need to go lay back down. Okay. I think I got up a little bit too early. I got up a little bit too early, gang. You kill a nigga. The detective is at the hospital talking to the nigga, ain't he? Yo mama is standing right with the nigga, ain't he? Yo mama is talking to the detective. While your mama talking to the detective, you call your mama and say, come pick me up. Oh my God, I don't know what to say, man. I don't know if I can finish reading this one, y'all. Maybe I should have read it before I read it to y'all. This is so new to me. It's another document I read. I never read this one. I pulled this shit up like 2 weeks ago and never read it. I don't know what to say. I thought they ain't gonna have no retrial. Melly's mom and Juvie's father used to mess around. Oh my God. That's his government last name, I think. The judge ain't allowing no mistrial. Hell no, the judge ain't finna let him. Ain't gonna be no mistrial. Y'all can kill that noise. They can put out 1,000 mistrial motions in. The judge ain't finna hear that shit. Oh my God. They need to hurry up and start this trial back. I'm tired. This is crazy, y'all. All right, so let's finish reading this. At the time, Miss King also told Detective Moretti that she could not reach. Ooh, she lied and told the detective that she couldn't even reach her son. Ooh. Detective Moretti took notes on a notepad and authored the T-Mobile search warrant affidavit 2 or 3 days after the shooting. Detective Moretti did not preserve his notes. He authorized a police report based on his notes and the contents of various, let me see, this is crazy, of various, let me scroll down some more. Search warrants, affidavits, but this report was written several months after the shooting. He had cause to doubt Miss King's veracity at the time he authored his police report. Detective Moretti acknowledged that Mrs. King's statement was not in his police report. After the T-Mobile search warrant was issued, Detective Moretti obtained records that corroborated Ms. King's statement that there was a phone call between Ms. King and defendant after the shooting. Detective Moretti also later obtained information that the phone. Detective Moretti testified that he did not include any false statements in the T-Mobile search warrant, nor did they deliberately omit any information from the affidavit. All right, oh my God, this is horrible, y'all. This is sick. I see why the defendant in the hospital throwing up. Somebody said, "Don't stop. Your reactions are genuine." Yeah, you're right. Very genuine. This is some sick ass shit. Shout out to Virgo, man. 3 jurors didn't show up, so the trial began at 1:30. I appreciate that, Frayby. Appreciate that, Frayby. All right, 3 jurors did not show up, so the trial began at 1:30. And how you know that, Frayby? Let me know. Let me know. I love the fact that that only you has this information. I'm in Florida. That's crazy. Shout out to Mandy. Mandy, that's crazy, man. People, look, this channel is so valuable. It's crazy how we the only one be having shit, but because nobody don't know this shit. Look, we the only one got this shit. All right, nobody else has this shit. People need to go over there and direct traffic over here so people can help read this shit with us, because this is sad. Virgo want me to keep reading, but oh my God. Okay, she said she was in law and crime, and the judge said to shout out to Frayby. Frayby in the house. Frayby in the house. Now you with the paperwork party, Frayby. Stay your black ass over here. Don't take your ass back over there. You stay your ass over here, Frayby. Stay with us. Okay, Frayby. Okay. Don't be straddling the fence, girl. Stay your ass over here. Shout out to Pensy Lola Yabless. How you doing, girl? What you doing? All right. Shout out to Pensy Lola Yablessed. All right, we in this bitch, man. We in this bitch, man. Frayby in this bitch. My girl Beverly in this bitch. Let's finish reading this, gang. Let's finish reading this. Jesus Christ, I cannot fucking believe this shit. For y'all just now coming in, we are actually reading the paperwork from the trial. This is sad. This is sad. You know what I'm talking about? We reading the paperwork. Your ass wasn't showing it. Love you too. I love, girl, you better go look at my page. You better go look at all my, girl, I've been showing this trial. All right, my channel is not bigger than Law and Crime, goddamn it. Matter of fact, Law and Crime, we got into it on the XXX trial, because I was the only one showing the XXX trial, and I had damn near 1,500 people in my crowd. And then Law and Crime, when we was at the courthouse in Miami, right? Law and Crime, they actually went up, made a backdoor deal with the television station that was in there, and the television station let them niggas start filming it instead of us filming it. And then they started, go check the XXX trial. We filmed it way before Law and Crime. Law and Crime got wind that we was filming, so Law and Crime know who the fuck we are. They got word that we was filming it, so they went and paid the TV station to only send the footage to them, because we was getting it directly from the site. They made them shut it off their own site and film it directly to them. They paid behind the scenes. So Law and Crime some goons. So fuck Law and Crime. It's going down. But shout out to Frayby in the house, man. I know y'all remember that shit. We was the only one doing that shit. Ah, okay. Let's keep going though. Let me see. I don't even know who Leandra Phillips is. Let's go. Miss Leandra Phillips testified that she alleged victim Christopher Thomas's mother. That she was alleged, or whatever that means. She was at work in Vero Beach when she received a call from her sister Ashley Phillips, who told her that her son was dead. Oh shit. Defendant's mother, Miss King, had called Miss Phillips and told her that the defendant was in intensive care unit. And hold on, so his mama was lying? And Mr. Thomas was dead. Miss King drove Miss Phillips to the hospital. At that time, Mr. Earl Phillips did not speak with Miss King or any police officer. She spoke with Detective Morelli only later after her son's viewing. Jana Thomas. Miss Thompson was allegedly victim Anthony Williams' mother. She received a call from her ex-husband the morning after the shooting, who told her that her son was dead. She called defendant's mother, Jamie King, at 8 a.m. or 8:30 a.m. in the morning after the shooting. Miss King was crying and said she was on her way to the hospital. Miss Thompson did not go to the hospital. What the fuck his mama crying for? She crying because her son about to go to jail? All right, Ashley Phillips. Miss Ashley Phillips is the sister of Miss Leandra Phillips. On the morning of the shooting, defendant's mother, Jamie King, called Mrs. Ashley Phillips and told her that Mr. Thomas and Mr. Williams were dead and that defendant was in the intensive care unit. Miss Ashley Phillips met with Miss King at the Tri-Rail station. It was daylight when she met Miss King, and they went to the hospital together. Miss Ashley Phillips approached Detective Moretti at the hospital and had a conversation with him. Miss King was some distance away standing with Cortland Henry during this conversation. After their conversation, Miss Ashley Phillips walked over to where Miss King and Mr. Henry were standing, and the three of them got into Miss King's car and left the hospital. Miss Ashley Phillips did not remember if Miss King spoke with Detective Moretti. The court considered the following evidence: the Defense Exhibit 1 T-Mobile search warrant and search warrant affidavit, Defense Exhibit 2 witness list compiled by Detective Moretti, State's Exhibit 1 pawn shop receipt with defendant's signature and phone number, analysis. Where the defendant makes a substantial preliminary showing that a false statement, knowingly and intentionally or with reckless disregard for the truth, was included by the affidavit in the warrant affidavit, and if the allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held to the defendant's request. In the event that at the hearing the allegation of perjury or reckless disregard is established by the defendant by a preponderance of the evidence, and with the affidavit's false material set on one side, the affidavit's remaining content is insufficient to establish probable cause, the search warrant must be voided and the fruits of the search excluded to the same extent as if the probable cause was lacking on the face of the affidavit. All right, so basically they're trying to get the motion thrown out. Under Franks, the movant is required to point out the specific portion of the affidavit alleged to be defective, alleged that the defendant consistent either of a deliberate falsehood. Let's keep going down. Okay, here we go. The court finds, and this is this right here, y'all, is just to let y'all know what's going on with this guy. This is sad. This is so sad. I'm just thinking about my bed and that big ass pillow I left. Shout out to Michaela, man. Michaela in the house. Say La Vie got a popcorn ready. It's going down. Good morning, Leslie. Leslie's in the building with us right now. Shout out to Leslie. I'm talking about welcome to the party. Miss Pensley Low La Bless. All right, it's going down. All right, so look, let's read what the court found. The court finds that Detective Moretti testified credibly at the evidentiary hearing. The court further finds that he did not include a deliberate falsehood or a statement made in reckless disregard of the truth in the T-Mobile search warrant affidavit. Detective Moretti's inadvertent omission of Ms. King's statement regarding defendant's phone call from his police record written several months after the shooting is not sufficient proof of a deliberate falsehood or statement made in reckless disregard of the truth. The court is not persuaded that the destruction of the detective's Moretti's notes is evidence that he lied in a T-Mobile search warrant affidavit. Furthermore, the defendant does not explain how at the time he submitted the T-Mobile. So in other words, the judge denied this, y'all. There it is right there in black and white. He denied them throwing it out. They was trying to throw out the T-Mobile records. And you know what? That's going to really break this case because they have T-Mobile records between YWN Melly and his mom talking while his mom is at the hospital with the dead body. I didn't even fucking look. I didn't even know this. While his mom is at the hospital with the dead body, they have, this is crazy, gang. This is fucking crazy. All right, this is some sick ass shit. This is some sick ass shit. And for y'all to just now coming in, that's his attorney. There go Miss Raven Liberty. All right, there go Miss Raven Liberty. This nigga got a criminal representing him. That's sad. I mean, if you go hire an attorney, you need to do a background search on your attorney. That's what it's getting to. It's getting so sad that you need to do a background search on your own fucking attorney. It makes no fucking sense that this nigga's attorney is just as much as a crook as he is. There should be a boundary between that. It should be like, oh, you just got out of jail? Oh, I don't think you should represent me. They got me. This is a double murder case, ma'am. This ain't no traffic ticket. So since you just got out of jail, I'm going to go ahead and go hire somebody that I believe that's going to help me beat this case. That lets you know this case right here is a fluke. This case is a fucking fluke. All right, this is a fucking fluke, y'all. This don't make no fucking sense. Now I'm gonna show y'all one more document because we're gonna have to come back at 1:30 when the trial actually gets ready to start. Again, I guess they're gonna try to replace. Let me show y'all one more document real quick. Y'all, I think I showed this the other day. I'll show y'all again. You see what I'm saying? Because we definitely got the exclusives on this channel. All right, as y'all know, that the judge denied YWN Melly dental care. All right, they put a motion in with the court for him to go to the dentist. The judge said, hell no, nigga, your breath gonna have to stink the whole trial. All right, bitch, you been in jail 5 years, your breath been stinking 5 years, you cannot go to the dentist. Now that's sad. Look, if I was the judge, I probably would at least let the nigga go to the dentist. At least. I probably would at least let the nigga go to the dentist. All right, but the judge said, no, your breath stank. Your breath gonna be stinking for however long it's gonna stink. You are not allowed to go to the dentist. All right, so they did put paperwork in with the judge to try to get YNW Melly to the dentist. They tried, y'all. The judge say, nah, you can only wear 5 suits and your breath gonna have to stink the whole trial. Notice how that nigga breath been stinking the whole damn trial. He be putting his hand over his mouth and shit. That nigga breath stank, y'all. I'm not just bullshitting. Everybody at that damn table that has been around him, they smell his shit. If you've been sitting in jail 5 years with the same teeth in your mouth and you ain't had no time to fix it, because you understand he got a grill in his mouth. Those grills stink. You have to take care of those grills. You gotta look whenever you got a grill. 'Cause I got a lot of homeboy with grills. Whenever you got a grill in your mouth, you gotta go take care of that motherfucker. You can't sit in jail 5 years with the same grill and think that motherfucker gonna be smelling good. No, you have to take care of your grill. All right, you got to take care of your grill. That nigga ain't been taking care of his grill. That nigga ain't been taking care of his motherfucking grill. His breath stank so bad, they had to put a motion in for this nigga to go to the dentist. And the judge said, nah. This nigga got the same grill in from 5 years ago. Same grill, y'all, from 5 years ago. And the judge was like, nah, nigga, you can't go to the dentist. Denied. Come on, judge. I'm gonna be in the courtroom. My family gonna be in there. Everybody gonna be in there. Nigga, bro, you about to die. What you mean, nigga? Your breath stinks. I don't give a fuck, nigga. You smell like a fuck boy. And that's exactly what the judge is treating him like a fuck boy. All right? I don't even know if them diamonds in his mouth. It probably is cubic zirconia. You know cubic zirconia stink. Shout out to Vincent. You know them cubic zirconia stink. I don't even know if that's I think his cubic zirconium stink. You know they stink. Oh my God. You know them cubic zirconiums stink. The judge say, nah, nigga, you think I'm finna let you come to trial blinging? Bling, bling. Every time I come around your city, bling, bling. Lorenzo's on Oklahoma tie, bling, bling. Every time I come around your city, bling, bling. Bling, bling. He like, nah, nigga, you can't be blinging in my court, nigga. Hell nah, nigga. It's a death penalty trial. You ain't be coming to this whole diamonds and everything, bling, bling. Nah. Keep your cubic zirconiums. We provide toothpaste. We provide penitentiary toothpaste. The little old bitty bottles of toothpaste they give you. We provide scope. We provide fucking toothbrushes. All right? That's what you got to do. You have to brush that shit. All right, nigga? You have to brush that shit. So, all right. I'm showing y'all the paperwork. I'm showing y'all. So when we go back in the courtroom later on today, y'all can see why that nigga breath. Somebody said that nigga mouth on fire. That nigga mouth on fire, y'all. That nigga mouth on fire. The judge said, no, I'm sorry, sir. Can't go to the dentist. Well, my breath stank. Hey, nigga, you killed 2 people. You think I give a fuck about your breath and your cubic zirconians, nigga? Fuck you, nigga. You know. Denied. This nigga, boy. Somebody say he got a flea market grill. Got them Indians in there. Hey, we fix your grill for you. Ooh, we got you. I mean, go back and look at some of the trial that we've already showed on this fucking page. When he started talking to that woman, she turned her head to the side. Y'all see how she got her head turned to the side on this one? That's exactly how she turned her head to the side. Soon as he started talking, she'll turn her head to the side like, damn, is that nigga breath really stinking like that? So I pulled up the paperwork and it said that the judge said you can't even go to the dentist. Like, damn. That nigga hot breath, hot Cheeto breath ass nigga, flea market grill wearing ass nigga. Come on, Melly, man. What the fuck wrong with this nigga? That nigga breath stank. You know what I would have did? For that 5 years I was in there, I would have got that tattoo taken off my face. For that 5 years I was in there, I would have got that grill out and worked on some more shit. Nigga, you know your teeth fucked up when your grill is hanging out your goddamn mouth. Your teeth is fucked up. Bro, who grill hang out their mouth? Who the fuck grill hang out their mouth? Nigga, if you go get your fucking teeth done and your grill is literally chopping up the bottom of your lip and scratching your chin, nigga, you might as well get all your teeth knocked out, nigga, and get a whole new row in that bitch, nigga. Get your whole grill fixed, nigga. You ugly. I don't know. Somebody need to knock him out. Shout out to Spanish. Somebody need to knock him out and start him over because the way his grills is designed, his teeth protrude out like they trying to get away. I think his teeth know his breath stink. They trying to get out his mouth. They are trying to get out of his mouth, y'all. This nigga breath stink. And then you know your breath stink when the judge put that shit in your paperwork. If your paperwork say dental care and the judge say denied, nigga, you know your breath stink. Somebody say he got some molded breath. Shout out to Antoine. They got that molded breath, bro. What the fuck is going on? Yeah, flies everywhere around the table and shit. They had to put some swat flotters by the table. Soon as nigga walk in, it's fly swatters laying all on the table. What these for? These for knock all the flies out the way. All these goddamn flies around this motherfucking table. Every time the nigga open up his breath, flies. Shit is sad, gang. This shit is sad. Throw up a reference pic. Look, hell no, I'd rather show a picture of this bitch mugshot than to see him again. That dude is horribly ugly. You see what I'm saying? His mouth is fucked up. His breath stank. He got on the same suits. Shit, let me see. What's her name? Say he back on suit number 1. Shit, I think that was Nikki said that. Nikki said he back on suit number 1. So he's crazy. He got that rotten teeth. I go Earn Luke. Earn Luke say he got that rotten teeth. He's definitely back on suit number 1. All right, so, you know, gums are minced on. Hell nah. Did you see Zakai? I know you seen him get that nigga a mint the other day. They gave that nigga 2 mints the other day. He opened them hoes up and that shit dissolved. Soon as he put that bitch on his tongue, you can actually see the camera. I may have to rewind that shit. You can see the whole mint dissolve and just disappear. I was like, whoa. That nigga didn't chew that bitch or nothing. That bitch just dissolved. You can see the smoke coming out his mouth too after it happened. I was like, whoa. I feel sorry for that mint. Hell no. That bitch dissolved. I'm not bullshitting. I know y'all been watching the trial. Y'all remember when they gave that nigga a mint the other day? They put a mint in that nigga mouth. That bitch dissolved, nigga. He should have just threw the whole mint in there with the damn plastic. The plastic would have melted and stuck to his tongue a little bit, but he should have just put the whole bitch in his mouth. You see what I'm saying? He should have put that whole bitch in his mouth. That motherfucker dissolved. She said, yep, I saw it. I know you seen that shit. That nigga breath stank so much, they gave that nigga a mint. The judge ordered that shit. They were like, Judge, can we give him some gum? And I ordered. Yeah, you can give him a mint, goddammit. All right, you can go give him a peppermint, but we can't let him go to the dentist. If it was a mobile dentist, we probably can let the dentist come to him, but nah, you can give him a mint. They gave that nigga like 15 mints. They had a mint bowl. Nigga, they went to the mint bowl and scooped up about 15 of them damn mints and took it to that nigga. Like, bro, your breath stinks. Nah, it's beyond dragon. Dragon's breath smell way better than his shit. All right, anytime that you got paperwork saying, and you know what, your breath smells so fucking bad, the fucking the defense wanted you to go to the dentist, bro. Your own defense team was begging the your own defense team was begging the judge for you to go to the dentist. That's how stinky your breath is, bro. Your own defense team took the time out to get some paperwork and write this shit up and say, Judge, please, Judge, we got to sit by this nigga at the table. Judge, hell no. The judge like, I don't give a fuck. He was like, Judge, no, we got to sit by this nigga. What you mean you don't give a fuck? We have to sit by him. How am I going to defend my client when his breath smell like ass and titties? Please, Judge. That judge say, nigga, I don't give a fuck. Yeah, I the one took this case. All right, I don't give a fuck. That's crazy, gang. The damn judge said, I don't give a fuck. The damn judge is the fucking, this shit is crazy. This shit is fucking crazy. All right, this is what I'm going to do. I am going to, they showing the what's name. We can play this. They showing the other. This is what we're gonna do, gang. We're gonna go ahead and play them. They showing replays. Fucking this shit is crazy. This shit is fucking crazy. Look at this is what I'm gonna do. This is what I'm gonna do. I am how the fuck I put the wrong one up, y'all. Y'all can tell. Look, now I just woke up, so y'all can kiss my ass. But hold on, let's get it going. Y'all know I love y'all, man. I put the wrong one up. I put my shit up. Let me put this bitch up. Where is that bitch? There you go.
Ms. Holmes, were you ever told the defense, or the defendant rather, would take care of you and pay for your bills?
No.
Have you ever made a statement that is different than that?
I've never said anything like that.
Can we approach her?
Sure. Just read this. I don't remember that.
Okay. So, Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they've all disappeared. You've never said that before.
I don't remember saying anything like that.
Objection, Your Honor. Move for a mistrial.
Thank you. Why don't you go
Ms.
first?
Holmes, did you ever say the defendant made you quit your job?
I don't remember saying anything like that. I don't want to ever made me quit my job.
Objection.
Do I may approach him? I'm going to show you this next few minutes. So I'm going to ask you again, have you ever made a statement that the defendant made you quit your job and that they would take care of us until the trial was over?
I don't remember saying anything like that.
Okay. So you're denying making that statement?
I don't remember saying anything like that.
No.
Objection. Your Honor, can I just have a standing objection so we don't keep interrupting?
No, you stay with your standing objection.
Whatever defense it
That's
chooses
fine.
to
Go
proceed. Okay. So, Ms. Holmes, in terms of have you ever said a statement, or have you ever made a statement to the effect of, you were told to quit your job and the defense would take care of us?
Of the judge.
But sometimes I look in her eyes, and that's where I find a glimpse of us. And I try to fall for her touch, but I'm thinking of the way you are. I heard that.
Play into the defense's motion for a mistrial, which we just heard right there. What are your takeaways?
You know, it's obvious that the prosecution's getting very frustrated with her. And listen, it's not an easy job to handle one of these types of witnesses. There is a way to go about doing it, and there's a way to go about doing it that's convincing to the jury. But you have to keep in mind that you have an audience. This isn't just a one-on-one conversation. There are 12 people watching you, so you have to be cognizant of how are they receiving this exchange. And if it looks like you're just getting frustrated, you may believe that the witness is lying to you. And in fact, some of the jurors may believe that. But if the way that you're conducting yourself is not professional at all times, and I'm not saying that it crossed the line here, but I'm saying that you have to be cognizant of your audience. The other thing I'm curious about is, we obviously don't know, but the conversations that they had at sidebar were obviously instructions to the prosecution on how to handle this witness appropriately and without objection. And for whatever reason, every time they come out of a sidebar, the next question is objectionable. So somewhere there's a miscommunication or misunderstanding between the prosecution and the bench as to how to handle this witness.
And Gene, when juries see sidebar after sidebar, or objection after objection, what do you think they make of that? Because on one hand, they're not supposed to take that into consideration. It's really what is allowed into evidence, but they have to take that. They have to, you know, the defense has been making the point that that in and of itself has been prejudicial. Do you agree with that?
Well, sidebars in and of itself are not prejudicial, but I can tell you this, jurors hate sidebars because they don't know what's going on. It's delaying the trial, and it slows things down, and they're worried about getting out at 5 p.m. and they don't want these lawyer discussions to slow them down. I will say this, the prosecutor is not doing it's not a perfect cross-examination / direct examination, but there are a couple points she's getting out. The punchline for me is this. Did the defendant, Mr. Demons, did he himself or through others try to influence what he thought would be a key witness for the prosecution? That's called witness tampering. That's called obstruction of justice. She was getting there with her questions. Did the jury get the same message from her cross-examination, if you will? I don't know, but that's what she was trying to do.
Okay, well, we're going to see. There hasn't been a decision yet as to this motion for a mistrial. As I reported earlier, there's a sick juror that's delayed trial at least till 1:30 p.m. Eastern, but I'll let you know if there's any activity in that courtroom. Clearly a lot more to talk about. We'll take a quick break. When we come back, we'll get more into Holmes' testimony. Stay with us.
visuals on this game blow away any competition we've seen so far. You will see some insane boss battles, some really cool hero.
God damn it, these motherfuckers right here, bro. Shit, I can't get shit done. Let me see. Let's go ahead and block him. Do we got moderators in the crowd, Nikki? Who moderating this crowd? Hold on, gang. Let me answer this real quick. All right, gang, I'm back. I had to take that call. Do we got moderators in the crowd? Let me see. Nah, fuck what they meant. You should have got his ass up out of here. All right, yeah, because I seen exactly, yeah. Shout out to Nikki, man. Nikki said she was trying to figure out what he meant. He was trolling. He snuck in real quick. Trolling. He may be cool with YNW, some of his friends come up in this motherfucker. He may be cool with that nigga. All right, but as y'all can see, moderators, the nigga I just got up out of here. Yeah, get him the fuck up out of here. He may be cool with him. All right, so this is what we're doing. We are definitely waiting for this trial to start. I'm not gonna stop this live because the trial is what we start about the next 40 minutes. So I'm not gonna stop this live. But what I will do is, let me see. Yeah, I'm not gonna stop the live. Let me see, but cause they supposed to be coming back in this motherfucker. Let me see. I'll put the paperwork back up. And once that live start, and we'll be back. Let's see. Since our boy was trying to take up for him, we'll put the motion to go back to the dentist back up. Cause ain't no way in hell, nigga. Your homeboy breath gonna be stinking like that. You in my motherfucking crowd with that bullshit. All right? That's your homeboy with his stanky ass breath. The fucking attorney said we can't sit at this table with this thing. And I ain't gonna lie, y'all, I went to go brush my teeth again. That's what I was doing. I went to go brush my teeth again. I came back, my phone rung. I got the phone call, but I just brushed my teeth again. All right, so I done brushed my teeth twice this morning, gang. You know, looking at this paperwork about the dental care and all that, I was like, nope, I gotta go brush my shit again. All right, I gotta go brush my shit again. So yes, I just brushed my teeth again. Matter of fact, my shit look more refreshed. I guess I need to start brushing my teeth twice, 3, 4 times every fucking day, because Shit. I just got to brush my teeth again, goddammit. I must have missed something, or I was like, I don't know if I missed something. I had to brush my teeth again. All right, so that's exactly what I just got through doing. But yeah, so we waiting on these motherfuckers. You know what? These motherfuckers must be watching my channel. Every time my motherfucker, they are definitely watching my fucking channel, gang. Look what they got back there.
No, I don't remember that.
You don't remember that?
Yeah.
Did you talk to Cortland Henry about your daughter's involvement in this case?
Not that I can recall.
Ms. Holmes, did your daughter tell you what happened in this case?
Objection.
What's the objection?
Calls for hearsay. It's immaterial.
Not what the statement said, but did you say something about the case? It's overruled. Not what was said. Just, did you have a excuse me. Not what was said. Was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter ever
She never told me. She hasn't. I asked my daughter, did she know anything about this case? And she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember seeing anything like that.
May I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Can we approach?
Yes.
Let me let somebody ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about what happened.
Did she tell you what happened? Without no, she didn't.
Just told she didn't know.
Have you ever made a statement that is different than that?
I don't know.
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed to your approach.
Showing you your messages from Instagram from February 5th of 2021.
Who was that Instagram? Is that the one this memory stands with Portland?
Ma'am,
I don't remember that Instagram.
Look at it.
I already looked at it. You want to show it to me?
So is the...
I don't remember that. You showed it to me like 3 times already.
So you don't recall making
I don't recall making a statement.
Excuse me, one at a time, please. Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
So you don't recall saying...
Objection.
Sustained.
So, Ms. Holmes, in terms, you said that your daughter didn't tell you.
Objection. Asked and answered.
Sustained.
So did you ever make a statement that's different than that?
Objection. Asked and answered.
Sustained.
Into the statements that, with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, ask and answer.
Sustained. Listen, I just want one of you to make an objection. So whoever's going to handle the
Yes,
witness.
sir.
All right?
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection. Asked and answered.
Sustained.
Ms. Holmes, have you ever let me rephrase. Ms. Holmes, did your daughter ever threaten to cooperate with law enforcement?
Objection.
Sustained.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection. Asked and answered.
Different question.
Why don't you come sidebar?
Ms. Holmes, did you ever make any statements about what happened on October 26th of 2018?
Objection. ask and answer.
I don't know what statement you're talking about. Rephrase the question to specific.
Ms. Holmes, did you ever make any statements specific to what was happening in the car on October 26th of 2018 prior to the homicide?
Objection.
Thank you.
Okay, pretty explosive testimony, but I'm back here with Josh Ritter and Gene Rossi. They're still with me, our criminal defense attorneys on the panel. So Josh, I'll start with you. A little bit of an update for you. The attorneys were given the written order denying the motion for a mistrial this past Friday. Defense attorney Stuart Adelson told our very own Terry Austin that the attorneys were given the written order denying this mistrial. So it was denied. We were curious which way the judge was going to go. We were wondering whether or not the judge would actually vote in favor of the mistrial. That is not happening. What's your thoughts on that?
It's a really difficult burden for the defense. I mean, they can. A lot of this is preserving objections for appeal. So you understand why they make the objections, but it really weighs heavily in favor of the prosecution. The judge essentially has to find that the trial, for whatever reason, this is, based upon questions asked by the prosecution, perhaps testifying during the questions, whatever kind of inadmissible evidence may have come before the jury. Does the judge feel that that bell simply can't be unrung to the extent that it has derailed the entire trial? And the judge is reluctant to do that. They don't want to put everybody through all of this again over something that they feel that perhaps could be solved through a curative instruction to the jurors. And the judge obviously felt that way in this instance. It's not surprising because most of these are denied.
Well, and Gene, you and I were talking earlier about whether the judge would be so upset to grant this motion for a mistrial, basically with prejudice, and there would be no more retrial. So that's not the case. I'll give you your thoughts on your reaction to the fact the judge denied it. But also, let me ask you this, Gene. Is this actually beneficial for the defense? Maybe they're in a good position in this case, and maybe starting over wouldn't be ideal for them. Maybe they're winning. What are your thoughts on both points?
If you pray for something hard enough, you may get it. I think the defense is happy that the motion was denied. All right. And I agree with Josh. The courts have wide discretion on whether to grant or deny a motion of mistrial. They rarely grant them because trials aren't perfect. But I got to say this. The defense in closing argument has incredible fodder and ammunition, no pun intended, to go after the integrity of this prosecution. It is absolutely painful for me to watch this direct examination of Ms. Holmes. It's painful, painful.
Oh, well, there's going to be more of it. We're going to play a little bit more of it and see what happens. I'll tell you what, in the meantime, we are going to take a quick break, so you're going to want to stay with us. But before we do, here's a special report from Law and Crime's very own Sierra Gillespie.
What's the address of your emergency? Somebody just got stabbed.
We're now learning more about the near deadly stabbing of a Florida teenager whose ex-boyfriend allegedly slashed her 15 times, now leaving her paralyzed. Less than a week before the attack, the victim's mother filed a criminal complaint against the suspect.
And you said somebody got stabbed?
Somebody just got stabbed right in front of Chubby's. 17-year-old Madison Shemitz is now being called a rising senior and star softball player by friends and supporters. On June 3rd, she and her mother met up with friends for lunch at Mr. Chubby's Wings in Point Vedra, Florida. Not long after their arrival, the pair noticed Shemitz's ex-boyfriend, 18-year-old Spencer Pearson, sitting nearby. When they decided to leave the lunch early, Pearson followed them into the parking lot.
What's the address of the emergency, ma'am?
Oh my God, it's at Chubby's Wings on A1A.
Chubby?
According to an arrest warrant, Pearson began harassing Shemitz in April. Prior to the attack, her mother reported Pearson, quote, started acting strange toward her daughter by following her to school or leaving notes on her car. She alleges Pearson also harassed Shemitz on social media, even creating new accounts after he was blocked. The report argues Pearson made suicidal comments and struggled with mental health issues. His mother said she would, quote, handle it accordingly when told about the situation. But on June 3rd, Pearson allegedly charged Shemitz and her mother in the parking lot.
And you said somebody got stabbed? Somebody just got stabbed right in front of Tubby's. Okay, don't hang up. I'm showing you at 150 A1A North. What's this address? 150 Valley Circle. I'm going to get the fire department on the line.
Shemitz was stabbed about 15 times in the neck. According to a GoFundMe page in support of her family, quote, she will have a long road to recovery as she is in critical condition at Memorial Hospital in Jacksonville. Her family says Shemitz's spinal cord was damaged in the altercation and she's currently paralyzed. Her mom and another person in the parking lot who tried to intervene were also injured. According to the police report, after Pearson stabbed Shemitz, her mother, and that bystander, he, quote, immediately began steadily cutting his own throat in an effort to kill himself.
Oh my God, he's sliced open. Oh my God, there's more people injured.
Officials say Pearson suffered life-threatening injuries and is now being treated in the hospital. He faces charges of first-degree attempted murder and aggravated battery. Reporting for Law and Crime Network, I'm Sierra Gillespie.
back, everybody. So we're continuing to follow the double murder trial for rapper YNW Melly. Of course, as you know, the Broward County Courthouse took a brief hiatus while they have dealt with a sick juror situation. So as we wait, we've been listening to the testimony of Felicia Holmes. This is the mother of the defendant's ex-girlfriend, and this is going to be her cross-examination when we jump back into court. So let's get right to it.
So, Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17 and I had been present.
Oh. Do you recall about when that happened?
If she was 17, that happened in 2018.
Okay. Without getting into what she said on that, do you remember where that statement was taken?
No, I don't.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Calls for a conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
It's the same.
When you arrived in Fort Lauderdale and saw Mr. Dennis, did you ask him what happened?
Objection. Asked and answered.
I'm sorry, repeat the question.
When you arrived in Fort Lauderdale, did you ask Mr. Dennis what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
You came here and one of your first... Let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, counsel, you direct your comments to...
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, I feel threatened.
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
What the rules?
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Anything else to this witness?
Yes, sir. Ms. Holmes?
Yes.
You said you feel threatened by me.
Of course.
Okay. Did you fail to appear for numerous court appearances?
No, you never served me. Lied.
Okay.
You lied to the court.
And with regards to, did you work in Redding, California?
Yes, I did.
Okay.
Immaterial.
Overruled.
And so that was a location you were at?
That's where I was chopping myself. Yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify?
You served me a subpoena on November to be the next weekend. I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in February of 2019.
You never served me. I know you served it to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019?
Objection. Beyond the...
So, Ms. Holmes, you even went so far as to hire an attorney to try not to show up.
I sure did.
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has ruined my life.
And in terms of your feelings and ill will towards the state and myself,
I just feel like you lock up innocent people.
And does that influence your testimony today?
It's not influencing my testimony. I'm telling you.
Excuse me, hold on. Only one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, sir. So that my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay. You hired an attorney to go and represent you at the 4th District Court of Appeals?
He had to hire an attorney because he tried to get him this far.
And no, that's a false statement.
Objection.
Excuse me. Counsel, you're not testifying.
I
all right?
agree on that.
Excuse me. You asked a question. All right? That's it. You asked the question.
And so it comes with regards to that you hired an attorney.
Yes.
And you then tried to get any sort of court order requiring you to be here in court thrown out.
No, what I did was I hired an attorney because you were saying you served me this subpoena that you never served.
And that was found to be valid.
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from those addresses that you said you served. Those are not my addresses.
Your testimony said you have never been served to appear in court.
Sustained. Excuse me, sustained.
And so, with regards to your feeling threatened on them, have I ever any sort of physical violence against you? Do you have any written threats from me?
It's intimidating. You've intimidated me this whole time. As now.
And in terms of your participation in this case,
yes.
You understand that you were served a subpoena to appear here today.
You served a subpoena after you arrested me.
And
you served a subpoena at the jail when I was in Broward County.
And you understand you were here pursuant to that court order.
I'm here.
And that requires, under the law, to comply with court orders to and that compel attendance of witnesses.
I've been complying.
Nothing further.
Anything further?
No, sir.
Thank you. This witness excused?
Yes, sir.
So, Josh, I'm going to give you an opportunity to jump in on the fun here because Gene and I were talking about the prosecutor taking the bait and basically getting into this kind of back and forth with the witness regarding whether or not the prosecution threatened her. What was your take on how the prosecutor handled that?
You can't ever allow yourself to get embroiled in the trial. You can't ever allow yourself as a prosecutor to become a character in this trial. And that's what she's allowing herself to do. She's making it personal. She felt attacked by that one question that the defense had. Everybody knows in that courtroom that that woman doesn't want to be there testifying. And everybody knows that there's a hostility shared between the two of them. What points are you going to score by getting up and trying to get this witness to admit that you never threatened them? You're never going to score those points. She's never going to give you those answers. And with each question that you ask, she's getting something else out that's, I think, more hurtful than the points you were trying to score to correct what the defense asked on their questioning. It was a trap. And she fell for it. And I don't think it went well. And she's got to also, I've said this before, realize there's 12 people looking at her and they're also watching the judge. And if the judge doesn't appear to be on your side and the judge seems to be shutting you down, you're not doing your case any favors.
Gene, I think I know where you stand on this, but let's go back to you on your thoughts.
I always think about closing argument, the final mosaic. And in her redirect, which was terrible, she made a comment, false statement, and she editorialized, and the judge almost took her head off. I would use that in closing as a defense attorney to show how the prosecution is so desperate to meet these elements. They engage in vituperative attacks against witnesses and become bullies. That would be one of my sub-themes. I got to tell you, if the vote were today, acquittal.
Okay, well, the vote will not be today. We even have a delayed trial because of a sick juror who's actually in the ER getting fluids because of dehydration. Really scary situation there. We hope she's okay, and we'll continue to follow the courtroom and see what updates we get. In the meantime, we're going to take a quick break. When we come back, we'll get more into the YNW Melly trial.
Gang. Look like they keep throwing a loop. All right, we are, let me see, we're about 30 minutes from the trial starting back. We're about 30 minutes from the trial starting back. And we also are about an hour before the jackyje live. So remember, we're going to be doing a jackyje live this morning. Shout out to Jackyje and her family. Actually, rest in peace to jackyje. But let me see. So what we're doing right now, just going through here real quick, and just checking out the trial. If YNW beats this, they're going to look at the prosecutor for funding them. Shit, ain't no if. Ain't no if. Remember, they changed it from
Is this the bag you're looking for?
5 on jury. He's definitely not going to beat this one. Yeah, he's definitely not going to beat this one. I don't see him beating this one. Matter of fact, let me check this poll real quick. I'll put a poll up. Let me check the poll. All right, so the poll is, would you hire an attorney like Raven Liberty, who is fresh out of jail? 30% said yes, and 70% said no. I was expecting at least probably 10% to say yes, but 30% of my crowd would hire Raven Liberty. All right, because she's fresh out of jail, gang. She's fresh out of jail, which I'm not discriminating, but I'm just saying I would expect, and that tells me a lot about the crowd we have this morning, I would expect at least 10% of the crowd to say yes, maybe a 5%, not 30% say yes. All right, so my crowd this morning, maybe y'all ain't woke up yet. Maybe y'all ain't had a bowel movement yet. I don't know what it is, but if y'all would hire this woman, that's on y'all. All right, that's definitely on y'all if y'all would hire this woman. But I wouldn't hire her. I'm with the 70%. She's fresh out of jail. All right, and she's representing a double fucking murder. This is not a double cheeseburger. This is a double murder. I know a lot of y'all ate a double cheeseburger yesterday from your favorite fuck restaurant. All right, this is a double murder. Why would you hire a bitch fresh out of jail to help you with a double murder? I mean, come on. We already know what she's good for. Let me see. They ain't hiring her for. That's what I'm saying. That 30% is not hiring her for legal purposes. I'm with you, Levi. I believe if you would hire her, I believe it's not to beat the trial. You would hire her just to bend her over on the desk and spank her little bitty ass. Let me see. He's co-defending, could be key witness. Shout out to Duke Famous in the house. Duke Famous waking up with us. What was her charges? I believe they said it was. Let me go look it up.
All right, welcome back, everybody. Thanks for joining us here on Law and Crime for our continued coverage of the YNW Melly double murder trial. And before the break, we just finished showing the testimony of Felicia Holmes, the mother of the defendant's ex-girlfriend. And that testimony that the defense deemed too prejudicial in their motion for a mistrial, well, we recently learned that the judge denied that motion for a mistrial on Friday. So this trial will continue. And now we are waiting for court to start up again after they took a recess. There was a juror who was actually sick, recovering from food poisoning. For now, I do want to bring in my panel of criminal defense attorneys, Josh Ritter, Gene Rossi, to talk a little bit more about this. Josh, how's the prosecution doing so far in this case? I mean, aside from the whole testimony of Felicia Holmes and the mistrial, there is things that we've seen. We've seen evidence of the surveillance footage. We've learned a little bit more about the car. We've learned a little bit more about the trajectory of the bullets. How do you think the prosecution has done so far at establishing that YNW Melly is the shooter?
They're piecing together the case, and I actually think that they have a strong case, and I thought that they were doing a fairly good job of building that case slowly. You know, it's not going to be one of those things where there's some sort of smoking gun, part of the pun evidence, but there was going to be a death by 1,000 cuts where they were able to piece this case together and convince jurors beyond a reasonable doubt. I just hope that it hasn't been derailed by this one witness, and that can happen in a case. You're cruising along smoothly, and all of a sudden you hit one witness, and it just seems to change the entire dynamic of the case, and it changes how the prosecution is perceived by the jurors, and maybe how they begin to react to other witnesses and how the prosecution is handling those witnesses. And they're looking to the judge for the cues on how to view the evidence. And so I hope that this doesn't change the trajectory for the prosecution. But up until now, to answer your question, I think they were doing a fairly good job.
And Gene, it's interesting to think about how they're doing, because we were talking a little bit more about the weaknesses in the prosecution's case. You thought that there would be an acquittal if the jury came back today.
I do, and I have the utmost respect, high respect for Josh. What I'm saying is, at this point, they have not met that heavy burden. And it's not, he's kind of guilty, likely guilty, maybe guilty. It's beyond a reasonable doubt, and I'm not going to labor that point. But here's what the prosecution needs to do to get back on track. Keep their personalities out of it. And they should focus on what they're going to say in closing. And they should just have a chart with a list of the undisputed, forensic, stipulated, or uncontested facts. And there are some good ones. When Mr. Demons got in that car, according to the surveillance video, that is 180 degrees different than their narrative of a drive-by shooting and he wasn't there, basically. Okay? They also have cell phone records that show different routes for Mr. Henry when he went to the hospital. There is a lot of undisputed evidence that does support the prosecution's narrative. And also this, you have a huge motive. And the motive is this: you have competing singers, rappers, and the two victims, Mr. Thomas, Mr. Williams, they were competitors. And believe it, that's the motive.
I mean, I'm struggling with that. They were friends. I think maybe the more idea of that he was a part of a gang and maybe was trying to show his loyalty. We'll explore that a little bit more about what actually could be the motive here, or the potential motive, even though it's not an element to a crime and you don't have to prove it. It's just something more to think about. Gene, thank you so much for coming on. Josh, appreciate you coming on. You both have been great. We're going to take a quick break on our end. When we come back, more discussion on this case. Stay with us.
They pissed me off with these damn breaks. I'm trying to get my shit ready for the next show. They pissed me off with these damn breaks. But shout out to the game, man. Yes, no mistrial, Miss Silver, no mistrial. They can put as many motions in as they can. There is not finna have no fucking mistrial. Not on this one. Not on this double murder. All right, let me see. And the link here is dropped. I don't know. Did I pin the link to the top? Let me check. Because the link is definitely dropped. Matter of fact, let me drop it again. If anybody want to come up and discuss the case with paperwork, let me drop this link. Shout out to the gang. Shout out to everybody stepping in, man. If you're in the building, hit the like button, gang. The likes should match the views. All right, we got 190 people in the room, pushing up to 200. All right, we got 190 people in the room. If you're just not coming in, this is a picture of YNW Melly's attorney. Mr. Melly's attorney is fresh out of jail. All right, she is fresh out of fucking jail. All right, it's going down. Somebody said it's better than the NBA Finals. Shout out to Jesse L in the house, man. Jesse L is stepping in with the paperwork party, man. She's fresh out of jail, gang. How many breaks do they take? That's what I'm saying. They know they're trying to eat. Well, it's about to start my 30 minutes. So they're taking a lot of breaks. Let me pin this to the top. I thought I had it pinned already, but let me see. No, actually it wasn't. All right, so the StreamYard is pinned to the top. That's if anybody want to come up and discuss this case. All right. That's if anybody want to come up and discuss this case. We actually getting ready for the show. The show will be starting about the next hour. Remember, y'all, we got a brand new time, 11 o'clock. Let me go ahead and put that up for y'all to see. For the people that's just now coming in the room. All right. We got a brand new time. All right, we go live at 11 a.m. All right, so the paperwork party goes live at 11 a.m. Central Time to 1 p.m. All right, and right now, just to let y'all know who's ever new to the channel, right now we are actually covering the YNW Melly trial. We covering the YNW Melly trial. And then, but we will be going live at 11 a.m. To discuss what's going on with jackyje. We'll be discussing that today. So be sure to catch us at 11 a.m. Paperwork Party. It'll be the same channel. It's just to be a whole different live. And I think it's going to run simultaneously with the live that's going on now. So be sure to tune in with the Paperwork Party to catch Miss jackyje. And we do headline news. So if you want to catch up with the headline news, what's going on in the world, we do headline news, and we will be talking about that. So it's like I'm doing a double live, but you know, y'all worth it. Y'all my people. I love y'all, and I'm definitely gonna wake up for this one. All right, I'm definitely gonna wake up for this one, y'all. All right, so let me see. That's the sacrifices he made. Most definitely. I don't even think he was up there yet. Shout out to G Denzel 55. I don't think he was in that space. I think if anything, he was probably getting close to that space. I don't even think he was in that space. The Illuminati they was probably looking at him, but I don't even think he was there yet. I think this was just some fuck shit he did, because this sacrifice, you see what I'm saying? I believe this was just some fuck shit that he did. You see what I'm saying? But it's definitely going down. Shout out to my boy Levi the Legend. All right. Shout out to Levi the Legend. Yo, we'll definitely be live at 11 a.m. gang. 11 a.m. same channel. Good morning with the gang, with the morning show. All right, that's what's up. But if you just now coming in too, I dropped the paperwork.
The YNW Melly double murder trial today. Thank you so much for joining us here. So this is a really incredible case where on Friday there was this motion for a mistrial by the defense after the mother of the defendant's ex-girlfriend testified. The judge actually denied that motion on Friday, and we're now waiting for court to start back up again. And as we wait, I want to take a look back at the motion for the mistrial that came in on Thursday, because I thought that was a really interesting point. Let's take a look.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Dennis, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I'm thinking maybe about 2016 or so till maybe 2019, 20.
Okay. Did you have the opportunity to meet Mr. Dennis?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
Your Honor, the record reflected in court identification of the defendant.
Yes, the record will reflect an in-court identification of the defendant.
So in October of 2018, had you met the defendant prior?
Yes, I did.
How many times had you met him in person prior to that?
A couple.
A couple?
Maybe two maybe.
Okay. Did you follow him on social media?
I'm not sure. In 2018, I wasn't. No.
Okay. Did you know if he had social media at that time?
I didn't. No, I didn't.
Okay. Did you have a social media account at that time?
Yes, I did.
And what was your social media handle?
I'm sorry?
What was your social media name?
My name? For which one?
For Instagram.
Instagram, it's like Bling Queen 258.
Okay. Did you have a Snapchat at that time?
I don't think so. If I did, I may have.
Okay. What about your daughter? Did she have an Instagram?
I'm pretty sure she did.
Okay. Did she have Snapchat?
I'm pretty sure she did.
Okay. So I'm going to show you what's been already admitted into evidence as 861. There's a couple of videos and things on that I would like to ask you to some questions about.
Your Honor, we'd object as to the predicate being laid for this witness to testify to any of this material. material.
Thank you. Next note.
So I'm showing you what is titled Memories 2018 October 9th, 4:58 UTC, Melly, Montana. Can you see that picture there on your screen?
Yes, I can.
Okay. Who is the female over there?
That's my daughter.
And which daughter is that?
My wife.
Okay. Who else is in that photograph with her?
That's Chanel.
I want to go here to this image. This is 2018, November 11th, 23:53:26 UTC. Again, Melly, Montana. Who is pictured in this photograph?
My daughter, Mariah.
Do you recognize the individual in the back?
No.
Prior to coming into court yesterday, were you shown two photographs of the alleged victims in this case?
Yes, I was.
Were you able to identify them?
No, I was not.
In terms of your relationship with Anthony Williams and Chris Thomas, how many times have you met them?
Maybe Stack maybe twice. Judy maybe once.
And do you know them by their real names?
No, I don't.
How did you refer to them?
Stack and Judy.
Okay. So I want to go forward to some of the videos in this particular exhibit, specifically Memories 2018, October 18th, 2:17:49 UTC. Start with this one. I'm going to.
So my other extra shit, and like, they need the most important shit here.
So the image that is shown there, do you recognize the person in that driver's license?
It's blurry.
Okay. I'm going to show you another video, the next one here.
Right there, like, you know you come back.
Whose driver's license is that?
That's my daughter.
The conversations and things that on there, do you recognize the voice?
I didn't really listen. I mean, you have to play it again.
Sure.
So my other extra shit, and like, they need the most important shit here.
Do you recognize the person who's speaking in that video?
Yes, I do.
Who is that?
That's Chanel.
Okay. So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I did.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I have.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you to.
I don't know if I did or not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Okay. Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. I don't remember what I said at that. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection?
No.
Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie on the stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
I just asked and answered.
Excuse me, overruled. Repeat your question.
I don't remember.
Excuse me.
Yes, sir.
Only one person can talk at a time, and there was an objection. I just wanted to be clear. All right? You asked your question again.
Okay. So, Ms. Holmes, did you lie to law enforcement?
Not that I recall.
Oh.
I don't remember.
Okay. Going forward to the events of that day.
Yes.
When you heard that phone call, where were you?
I'm home.
Okay. Where was it? Home in Cocoa?
Cocoa.
Who else was there at your house?
My kids.
When you heard the phone call, did you hear what had allegedly happened?
I heard that there might have been a shooting.
Okay. Did you see any pictures or videos of anyone that was injured at that point?
No, I did not.
Did you see the defendant on the screen of that video call?
I saw his face, yes.
In terms of the method of communication, do you know if it was a FaceTime call?
I assumed it was FaceTime. I couldn't say for sure what kind of call it was.
At the time of October of 2018 through December of 2018, did you know the defendant's phone number?
No, I don't.
Do you recall today what the defendant's phone number was?
No, I don't.
Okay. In terms of the information and stuff that you have regarding that phone number, was that saved in your phone at that time?
It may have been. I can't remember.
Do you remember what phone number you had?
No, I don't. No, I don't.
So, Ms. Holmes, to go back in terms of looking at your statement or any of the other things, refresh your recollection as to what the defendant's phone number was and what you had at that time.
I'm sorry, could you repeat the question?
Sure. You said you didn't remember the defendant's phone number.
No, I don't.
Would looking at a copy of your statement help refresh your memory as to what?
No, I don't think it would.
Okay. Would you like to try to do so?
You have to look at it for you, sure.
Okay. And so, counsel, on for the record, I'm showing for page 3 of 8. And I'm going to ask you, Ms. Holmes, to just read this part silently to yourself. Okay. And we're going to start here, this, and through here, okay? Silently to yourself. During reviewing that, does that refresh your recollection? Your Honor, pursuant to 90.8035, the state would move at this time to read into the record the relevant portions.
Objection.
All right, joining me this hour, I have civil rights attorney Joe Richardson with us and federal law attorney Gwen Marie Davis Hicks. It's great to have you both here. Joe, I'll start with you. As we've been mentioning, we're kind of in a little bit of a lull right now, a break from the courtroom activity because there was a juror who got sick, had a bout with food poisoning. But we're breaking down Ms. Holmes' testimony, and when we think about Ms. Holmes' testimony, I'm curious, is she a reliable witness or not? I mean, there are all these questions about whether or not she was truthful with police. She's making these allegations that the prosecution feels that they're threatening her. Do you think that she's a reliable witness?
My sense is she could very well be a reliable witness. It is not unheard of for someone to feel like they're bullied by law enforcement, that they're bullied by prosecutors, and to demonstrate it, this prosecutor bullied her while she was on the stand because she wasn't getting the answers that she needed, forgetting entirely that you can, draw more bees with honey. And so there's no reason to think that she may not be credible necessarily, other than the fact that she's not going along with the prosecution as this willing and happy witness. Most people in her position aren't going to be willing and happy, but that's why the prosecutor has to be very, very careful to make sure that she doesn't become a villain in all this, because then that detracts away from the case that has some real good evidence, frankly. And so I don't necessarily know she's not credible, but the prosecutor's not helping it, not helping her cause here.
It's like you were listening to Gene Rossi earlier on in our show. So Gwen Marie, as I mentioned, the judge denied the defense's motion for a mistrial. Some might say that's a loss for the defense, but another way of looking at it, maybe it's a win, because you could argue, well, if they were granted a mistrial and there was going to be a retrial, you start all over. They might be in a position right now where they're winning. And maybe a mistrial wouldn't actually help them in the day. Maybe if they look at the case right now, they're in a good position, continue on with this jury and see where it goes. I'm curious, at this point in the case, how do you think the defense is doing? Because there's a lot on the line. The death penalty could even be instituted here if he's ultimately convicted.
Yes, there's definitely a lot on the line, but I wouldn't say that it's a loss for them either. They're just fertilizing the ground for appeal. So if it goes well, great. If it doesn't, then that sets them up for appeal. So they have an appellate issue to deal with the appellate courts. So that's something that I'm sure the defense definitely has, and know that they needed to preserve the appeal process. So that's really important here in this case as well.
That's a good point. That's a good point. Just because a mistrial wasn't granted, whatever issue they took with what happened in court, they could say that was overly prejudicial. The judge made a mistake, and maybe an appellate court would rule in their favor if he's ultimately convicted. We're not at that point yet. So many moving parts. We're going to take a quick break. When we come back, we'll get into a little bit more of this trial, because there is so much to talk about. We'll be right back.
Lady J, what's up with it, Lady J?
What up, PW?
Shit, chilling on it, getting ready for the other show. I'm gonna let you have the floor. Just talk about what you want to talk about. I guess they'll be back in like a minute. You see what I'm saying? Let me go get something real quick, but just talk to the crowd about what you think about what's going on with YNW Melly. You got the flow.
Yeah, I'm just hoping that the prosecutor doesn't mess up the whole case, catching her feelings and going with a cat fight. I meant with the mother of the ex-girlfriend or girlfriend of Melly. But yeah, I don't know. We'll see what happens. But him laughing and joking throughout the trial, showing no type of remorse. These are supposed to be his best friends. It's just weird to me, definitely weird, but hopefully he does get convicted, because this is definitely messed up. Definitely messed up. Those are my thoughts on what's going on right now. I haven't been on the whole thing, obviously worked during the day, but definitely you gotta just sit back and watch. It's definitely a waste of money, though. This trial shouldn't even be going on. Waste of taxpayers' money. Let me see if I could look at some of these comments. But yeah, y'all. Stay with us. We'll be following this case as well as the jackyje, as you know. Jackyje is coming up in about 40 minutes or so. We'll be switching over. But this will still be going. Hopefully they'll be back at like 1:30, I think they said. Waiting on that juror. hopefully they'll be able to come back this afternoon and we can get back on the case for today. I'm trying to see the comments at the same time. But good morning, y'all. Good morning. Was that the bell? I'm a whole YNW back in a minute. Hit that like button. Share the live.
Hey buddy, got any stars left?
Hit the like button, y'all. What are y'all thoughts on the prosecutor and her actions with the mother on the case? Melly definitely looks possessed. I agree, 100%. 100%. Definitely a waste of money. He's been in there. They should have just solved that themselves.
All right, thanks for joining us once again on our continued trial coverage of the YNW double murder trial here on Law and Crime. I was teasing in our last block that there was a motion for a mistrial on Friday after the mother of the defendant's ex-girlfriend testified, Felicia Holmes. And the judge actually denied that motion on Friday, and we're now waiting to jump back in court to see the continuation of this trial. But I do want to watch that motion unfold, and we'll talk about it on the other side.
Counsel remain along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me that I don't know if I don't think there was any evidence that she had something that might have been marked as an exhibit.
It was not marked on it. It was just a copy of the transcript.
So you're okay with it?
Yes, sir. I have plenty of copies.
All right. In any event, so jury's been excused. Counsel remain along with the defense. So you have a couple motions for mistrial. You want to talk about those?
Yes, sir. As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible, instead of at least admitting that that was what the state intended to do, advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to Plan 1, the original one all along, of the state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had, into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, which you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate, it is highly prejudicial, this jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that means.
This is your motion for mistrial, Mr. Addison?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Yes, second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table. And despite the judge, Your Honor's instruction to ignore it, it's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper, and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text, couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since, so just to let the court know there is no factual predicate for the implication, or not implication, the accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or that Mr. Demon's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about motion for mistrial. I think it would be appropriate that he be consulted as well. But I haven't reached any conclusion about it, and so I'm going to see exactly what was said. I thought I heard what was said, and I'll check with the court reporter, get a little piece of that transcript, and we'll go from there. And I'll take it under advisement. But if you talk to your client about it, we'll see everybody back on Tuesday. All right, sir.
Have a good weekend, sir. Judge, since we're breaking early today, can we have a few minutes with our client? Right
Sure,
now?
I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yes, sir.
Joe, those were strong arguments they were making, so strong that a lot of our analysts were suggesting it would have been possible, and maybe we should be on the lookout for the judge actually ruling in favor of the mistrial and granting a mistrial. The judge decided not to do that. Are you surprised?
Yes and no. On the one hand, it's very, very hard to get a mistrial, right? And often they aren't granted. Most of the time they aren't granted. They're asked for kind of as a matter of course. But one of the situations in which they can be granted is when the prosecution introduces something that they know has no business coming in. There's no way for it to come in. There's a whole discussion about this previously. And so they were trying to get through the back door what couldn't come to the front door. And it was interesting that the attorney said, I agree, where he said, there's no catch-all for, we're just trying to do good and therefore it comes in. If something is not supposed to come in, it's because it's already been judged that it's going to be more prejudicial than it is probative. And they went and did an end run around that anyway. Meanwhile, back at the ranch, as has been said before, not only is this preserved as an issue on appeal, but, as of right now, the prosecution doesn't have a groove at all. And so therefore, if the prosecution keeps doing what they're doing as to other witnesses, or if they don't make enough of a presentation to make the jury forget about what happened here, they could hang the jury. The jury could be hung, or it could be they could acquit.
All right, more to talk about. We're going to hit a quick break, but before we do, and we want you to stay with us, there's this special report from Law and Crime's very own Sierra Gillespie that we want you to check out.
Get out! Go away. Dude, get out! Get out! Get out! Get the...
A New York State Trooper of the Year is now charged with manslaughter after he allegedly shot and killed an unarmed man who refused to get out of his vehicle.
What's up, Jones? I shot him. I got the camera rolling.
Law and Crime Network first brought you the story last year when body camera video was released of the February 12th, 2022 shooting. At the time, officials responded to a call for an erratic driver.
749 to 37 for termination of pursuit.
Officials say the driver, 38-year-old James Huber, was speeding at more than 100 miles per hour along Interstate 90. When Huber crashed into a state police squad car and headed for downtown Buffalo, the search was called off. But Trooper Anthony Nigro IV later caught up with Huber in the city's downtown. Body camera video shows Nigro approach Huber's vehicle, telling him to get out.
Get the out! Get out! Get out!
Next, Huber appears to reach for something in the center console of his vehicle. Seconds later, Nigro opens fire.
Go away. Dude, get out! Get out! Get out! Get the
The vehicle then takes off and crashes on its side near a parking ramp.
7415 Buffalo. Shots fired.
What's your location?
Get out of here! Get out of here! Washington. Washington and Eagle. Shots fired. Send an ambulance.
Body camera video shows Nigro approach the crashed vehicle, swearing at Huber.
Oh, you dummy.
Later, Nigro can be heard telling other first responders that Huber is dead.
Is this the one you were chasing? Yeah. He's dead. Yep. Just one? Yep. So you're okay? Yeah, I'll be good. Okay. 7415 Buffalo.
7415.
You can have everybody slow down. It's okay. Driver's deceased. You need a tow truck and a supervisor. Slow all units down.
As a first responder approaches, Nigro admits he shot Huber and caught the entire interaction on his body camera video.
What's up, Jones? I shot him. I got the camera rolling. So.
Huber was pronounced dead on the scene. He was unarmed at the time of his death. The New York Attorney General Letitia James's Office of Special Investigation announced the indictment and arraignment of Nigro this week on charges of first and second degree manslaughter. The New York State Troopers Police Benevolent Association released a statement after charges were announced, voicing support for Nigro. At an arraignment this week, Nigro pleaded not guilty to all charges. A judge later ruled he be released on his own recognizance. If convicted on the top charge in this case, Nigro could face 25 years in prison. Reporting for Law and Crime Network, I'm Sierra Gillespie.
Gang, 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 gang. What's up with the game, man? Get the likes up, man. The likes should match the views. Shout out to the game, man. Me and my girl, Lady J, is most definitely in the house right now.
Yo, that was messed up.
You want to come on, man. You know how they do it.
Oh, Lord.
Arlene said, wow. Arlene, you can't believe your eyes, huh?
He
Definitely
said I
down.
shot him. Just like that.
Hey, man, I shot him. Because they think they justified. When the police shoot you, they think they justified. You see what I'm saying? People don't know. I had a shootout with the police before, and I won. I said that shit on season 1. I said again, I had a shootout with the police before and I fucking won. And they thought they was gonna win this fucking shootout. All right, the police surrounded me and we started busting at each other. The only reason I got away with the shit is because they was shooting at me first. You see what I'm saying? But they got me fucked up. That's one reason they want to disarm America. They don't want us to have a shootout with the police. They want the police to be the only one. Yeah, they want them niggas to be the only one walking around with guns and shit. Fuck that shit. No. It don't work like that. If a police pull a gun out on me and I feel justified, I'm going to pull my shit out and it's going down. We'll talk about it later. You see what I'm saying? And that's what it is. So, yeah, for y'all that don't know, I done had a shootout with the police and I won. I'm one of the only black people that can say, hey, I won the damn shootout. Them niggas like, that nigga busting. Yes, I'm busting back. How about that? Hey, but I do not want y'all to miss the morning show, y'all. It's going down, y'all. In about the next 20 minutes, we will have the morning show, and we got a good show. We definitely gonna be talking about what happened in China. We got some more shit to talk about the Titanic and shit, so y'all do not want to miss it. Remember, gang, the morning show is not at 9 a.m. anymore. The morning show is at 11 a.m. All right, we took a vote on it yesterday, and we have moved it to 11 a.m. Now, as far as the YNW Melly trial, we definitely going to be showing this trial every morning. So even though the morning show is at 11 a.m., we still going to be coming in at 8 a.m. for the YN Melly trial. All right, so just remember that. But yeah, shout out to the gang. What's up with it? So what do you think? Because I ain't gonna lie, they did have some good points on the mistrial, but they didn't win it because it's kind of hard to get a mistrial.
Right.
What do you think they still gonna be coming in trying to get this mistrial? Because I'm gonna tell you one
thing.
I
think they're gonna try it the whole way through.
Yeah, because even though they get denied the mistrial, that only sets up for the appeal. A lot of people don't know how that works. It sets up for the appeal because once they appeal, they can say the judge wasn't fair. The judge was supposed to give us a mistrial on this particular case. You see what I'm saying? But we didn't get that mistrial.
Right.
And he can win his appeal for the death penalty, which means, okay, well, it's not going to be a death penalty, but we will do this.
Spend the rest of his life in jail.
Yeah, spend the rest of his life in jail. Yeah, it's the wild, wild west around this motherfucker. Shout out to Arlene. It's the wild, wild west around this motherfucker. You see what I'm saying? I done got shot 5 times. Thank God I'm still here on this earth. You see what I'm saying? Doing my thing. But yeah, as far as the police is concerned, somebody said Tupac did too. Yeah, Tupac shot at, matter of fact, Tupac shot the police in the ass. Thank God now one of mine didn't hit. I was just busting in their direction. Thank God now one of mine didn't hit. I'm blessed to have none of mine hit. You see what I'm saying?
Right. You just let them know you wasn't playing.
Yeah, I'll just let them know I wasn't playing. I'm not the one. Y'all can go do whatever y'all want to do with them over there. But when it comes to me and mine, God damn it, I'm not playing with you motherfuckers. You see what I'm saying? And motherfuckers were looking, the people that was with me was looking at me, oh, this motherfucker shooting. Yes, I'm shooting, nigga. Duck, get down, nigga. It's going down. Shit, it's going down. All right, so look, let me talk to my girl Lady J about Miss Stein. Now, how did you vote? Because we got 30% that said that they would hire her.
No, I said I would not.
Well, okay, so you the 70%. What do you think about this woman?
And welcome back, everybody. So today we are laser focused on this double murder trial of rapper Jamel Demons, better known as YNW Melly. And we're waiting for day 5 to resume a little later this afternoon. There was an issue with the juror being sick. But for now, we're reviewing some of the most important testimony that we've heard thus far. And that leads me to the lead detective in this case, Hector Bertrand. So with that, let's get to the Broward County courtroom and we can hear a little bit more of what he had to say.
Hector Bertrand Jr.
Your first and last name for the court report.
HECTOR, E as in boy, ERTRAND.
Thank you. Please be seated. Mr. Bertrand, the microphone in front of you only adjusts up or down, not back and forth, all right? See a little too high. All set, ready to go? Count you may.
Thank you. Good morning. Could you please introduce yourself to the ladies and gentlemen of the jury?
Retired detective, homicide detective, Hector Bertrand, Belmont Police Department.
Congratulations on your retirement. How long have you been retired?
About 2.5 years.
Prior to that, how long did you work for the Miramar Police Department?
28 years.
Can you tell the ladies and gentlemen of the jury some of the different hats you wore while employed for the Miramar Police Department permanent?
Initially, after graduating the academy, I did a couple years in road patrol. Then there was a position open in Detective Bureau as like a training position that was going to be for 6 months and then go back to road. I never left the Detective Bureau. I did a couple years in juvenile and sex crimes. I did 10 years in undercover narcotics. And then the last 15 years was in homicide.
During the course of your time in the homicide unit, How many cases were you involved in the investigation of?
A lot.
Is there
I couldn't give you a number. A lot.
more than 100?
Yes.
With regards to the homicide unit back in October 26th of 2018, were you employed with the Miramar Police Department then?
Yes, ma'am.
Tell the ladies and gentlemen a little bit about the training and education classes you take while you're preparing yourself as a homicide detective.
I've taken a lot of classes. I couldn't name them all, but anywhere from in the narcotics, surveillance, court, advanced basic homicide, advanced homicide, some forensic classes, crime scene reconstruction, things like that.
So, drawing your attention to October 26th of 2018, did you have an occasion to become involved in a Miramar police case investigation documented under Miramar case number 18-10-06269?
I did.
What was your role?
Initially, I was called out as the primary detective, but we kind of had an agreement within our unit because I was only 2 years away from retiring, that any cases that would get assigned to me, that one of the other detectives.
You know, Gwen Marie, there's been allegations put forward by the defense that this is a botched investigation, that law enforcement only targeted Melly because he was famous. I'm curious, after hearing what we've seen so far put forward by the prosecution, and they are going to have a lot more that they're going to present, you think any of that is justified, or do you see a competent investigation where the evidence is adding up and leading to YNW Melly as the killer?
Look, it's the defense's role to create reasonable doubt. That is a good way of creating that. Was it botched? Was the investigation botched? Putting that in the jury's mind makes them think when they go into that jury room, that's going to be a big topic. Is he credible? He wasn't even a part of the investigation. He knew he was going to be retiring in 2 years. He had somebody else going into it. Was it clean? Chain of custody. All those things are really critical here. And I think that that is going to be a key point in my prediction back in that jury room when they are deciding.
Okay, we will wait and see. Not quite there yet. We're going to take another break as we slowly inch closer towards live trial. Again, we're expecting, I think, 1:30 p.m. Eastern is when we hope for that juror to come back after this bout of food poisoning and being sick. So we will see. Stay with us. We'll be right back right after this.
Gang, 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 gang. Shout out to the gang, man. It's me and Lady J on the platform. The link is dropped, pinned to the top. If you want to come up and discuss this case with us real quick, you see what I'm saying, before I go to the live of the morning, you're welcome to come up. All right, before I head over, because we're about to head over about the next 15 minutes. Now, what did he say, 1:30, Lady J? What time would that be in Texas?
They're going to try for 1:30, yes.
What time would that be in Texas? Do you know? Do anybody know? Because Texas is central, Miami is eastern. So 1:30 would be what? Would it be 12:30?
I think it's 12 hours behind, if I'm not mistaken.
I thought it was an hour behind too. Let's see if the crowd know. Do y'all know what 1:30 in Miami is in?
12:30.
Just one you.
Let me see. Nikki say
There are many sides to
12:30.
you.
Okay.
And
okay,
all of them
okay.
deserve the best.
All right, who agrees with Nikki?
Introducing Max, the one to watch.
I do.
Okay, Charles agree. Okay, Lady D agree. Okay, so we agree with Nikki then. Nikki say 12:30. We got Charles C. Charles C say 12:30. So definitely we're gonna be live with the jackyje case. Who the hell said 2:30? Come on, Miss. Did you wake up and splash some water on your face, Miss _L8LSS? Well, let me see. HLS. I know for a fact it's not 2. Maybe she forgot to put the 1 in front of the 2. All right, let me see.
Oh, that's possible. Yes.
Clean that up, Miss LLS. She probably forgot. What you think? She forgot?
Yes, I do. I believe she forgot.
All right, Carolyn say
She missed that
12:30.
one.
All right, cool. All right, so that's how the world turns, gang. That's how the world turns. For y'all that just not coming in, the question of the day, because we got the picture up. Would you hire Raven Liberty to be your attorney fresh out of jail? Because she's fresh out of jail, gang. All right, she fresh out of jail. Here go her mugshot. She been doing her thing.
Mugshot.
And now
like she got some Botox injections.
But she's definitely representing. She represent Melly Mel, man. She represent Melly Mel.
She look crazy.
Charles said, "Hell no, Charles. Go ahead and take the poll." It's a lot of people saying yes, though. Go ahead and take the poll. Is at the top, y'all. The poll is at the
they hire
top.
her for other things. Definitely not for to represent them.
Hey, she fresh out the tank. Noodles and honey buns, goddamn. Noodles and honey buns. And that bitch eating noodles and honey buns, and now she's sitting at a double murder table.
Laughing and joking with him.
Oh, hey, you know what? We was trying to figure out why she was laughing and joking with him. Like, why is this woman laughing? Now I know. Now we know. Fresh out the tank her damn self. She's sitting there laughing like, nigga, I got out. Let's see if you gonna get out. Man, she fresh out the tank. Hey, and for y'all just not coming in too, we actually, let me see, double cheeked up. Nah, for real. For y'all just not coming in too, we actually dropped the paperwork showing that they only gave him 2 suits. 2 suits. Frey B said 11:30. Come on, Frey B.
Oh, I thought he was allowed 5.
I said 2 suits. I'm over here looking at something else. Yeah, you right. It was 5. I thought he was allowed 5. Yeah, he got 5 suits. I'm tripping, y'all. She was Kodak's lawyer. Come on, Sheila. What? Nigga, she gets around. She was Kodak lawyer. She definitely getting around, gang. She definitely getting around. Yeah, so
somebody put he getting a conjugal visit from her.
She should be able to get one.
All right, welcome back, everybody. So we're closing out hour 3 here on our Law and Crime morning show about the YNW Melly case. Unfortunately, we weren't live today, this morning. We are going to be live this afternoon, and we're going to have live analysis and a live Q&A session, but there was a sick juror that actually delayed the trial. This, of course, is the murder trial of rapper Jamel Demons, better known as YNW Melly. Day 5 began this morning with some discussions, but they're now, as I said, on this brief recess, and we're going to wait for it to resume. But I want to go back to some of the most important testimony that we've heard so far in this case, and that again leads me to the lead detective, Hector Bertrand. So let's go back and hear what he had to say.
Over it, and that I would assist to avoid having to come back. Well, it didn't work out.
So you still come back and testify in all your old cases?
Yes.
Okay. So, Detective, do you live locally still?
No.
I'm not going to ask you. So going forward, do you remember about what time you got called out?
5 o'clock in the morning.
What types of procedures are in place? How do you get called out?
Typically, it's I would either get a call from the sergeant or I get a call from our dispatcher at the PD. In this case, I got a call from Sergeant Shaw.
Okay. Once you get that phone call, how long do you have before you must respond to the scene?
There's no real set time. It's just, from wherever you're at, you try to, put some clothes on or shower, so, and then prepare to go. So I think it took me like about 45 minutes to get to the scene.
Okay. When you arrived on the scene, who else was there?
Well, prior to going out to the scene, I actually called Detective Moretti, advised him that I had got called out, and so at that point, so that he could take the lead in the investigation. So when I got there, I got to the hospital. It was the first place I got there. There were some officers there at the scene, at the hospital. I spoke to them, got briefed. Detective Moretti showed up shortly thereafter.
Okay, with regards to individuals that you made contact with that were not law enforcement, do you remember speaking with an individual named Cortland Henry?
I did.
That statement of Mr. Henry, how many times did you speak with him?
I spoke to him twice. Both times were recorded. At some point towards the end of the first one, don't know if I got called out to something else or I just briefly walked away, turned off the recorder. Then I came back, asked a few more questions just to verify location, and wish I recorded that portion, but it was very short, maybe a couple minutes.
So I wanted to go back to the set up the geography. You said you worked in Miramar for 28 years.
Yes, ma'am.
And during that time, did you become familiar with the area?
Joe, it's interesting listening to the lead detective and thinking about this case, because one thing I actually haven't addressed yet is the fact that this is a death penalty case, right? I mean, so this is Florida law changed. It's 8-4. If the jury finds in favor 8-4 in favor of death, that's it. There's no unanimous jury anymore. Florida law changed. Everything that you're hearing about this case, the circumstances of it, if he's convicted, do you think that it's an uphill battle for prosecutors to get the death penalty?
Not necessarily, because if it was uphill, 8-4, the possibility of 8-4 evens it out quite a bit. The idea that you don't have to have unanimous anymore. And so that's what allows them the opportunity, even in a rough day and a rough time, to hang in there and potentially win. So this is going to be appealed to no end if they end up getting a conviction for that very reason. But yeah, everything is possible, particularly when you don't need unanimous.
Mm-hmm. And Gwen Marie, we keep seeing these kind of photos, these images of this video of the defendant in court smiling, blowing kisses, laughing. One of the questions we get is he going to take the stand? Now, I don't know if it's necessary. I actually don't think it's necessary here, but do you think he's going to take the stand and give his side of the story?
I don't think he should take the stand. It's basically kissings and blowings, but you never know. I mean, I've been surprised before, and you just don't know what's going to happen. I mean, his fans do love him. So we'll see what happens, but it could definitely go the wrong way too. So they got to be careful.
Yep, there you go. The blowing of the kiss right there. Couldn't have made it better. Gwen Marie, Joe, thank you so much for taking the time. I wish we always had a little bit more time with you guys, but appreciate it. And we're going to continue our coverage. Of course, we're going to continue our coverage here on Law and Crime of the YNW Melly trial. And up next, we have something very special for you, our live Q&A session with a great set of guests and hosts. And stay with us. If you have questions, submit them now. If anything you want to ask about this trial, now's the time. I'm Jesse Weber. We'll see you right after this break. Stay with us.
Gang, gang, gang. All right, so check it out, gang. They breaks are not that long. They have little bitty, 3-4 minute breaks. Their breaks are not that long. So the people that's actually interested in this trial, you can stay and watch this trial. That's what's up. We got 190 people in the room. I think we got up to like 200 and some people. We appreciate everybody coming in. The actual trial, it will start back in about another hour. All right, let me see. Did they say 11:30? Was that 11:30, Lady J?
1:30. So
1:30.
1:30.
So let me see, 11. Okay, so we may be back in here before it start back, because I'm definitely finna head over to the jackyje case. All right, so look. I put it in the comments, y'all. I'm finna head over to the jackyje case. It was nice talking with y'all. I will be back probably before the trial starts. All right, I got to go narrate another show real quick. Let me go jump on this other show. I'm going to be back. My avatar will still be up here the whole time. All right, so I'm in my studio right now, so I got a shitload of screens in my studio, so it's going down. All right, so look, I'm gonna go to the other fucking show, do my thing. I'll be back. The ones that want to stay in the room, go ahead and stay in here. I know we're going to have a crowd standing here because they want to watch the trial. And also, we got another crowd that's already forming on the other page right now. Well, on the other live. It's already a crowd forming. Let me get over there, man. I got 3 minutes to start my other show. I love y'all. I will be narrating this bitch. Whenever the screen come up, we will be right back. Do not fucking worry, gang. They will be right back on this because looks like Law and Order has taken over the cameras of this case. It works real crazy how they can take over the cameras. If it was a news station, we'll be getting the feed directly from the news station. But since the news station has been paid by these motherfuckers, because I'm starting to learn their game. What they do is they contact the news station, they give them about $2,500 behind the scene, and then they feed it right to them niggas. All right. So that's exactly how they doing. So I ain't tripping on that. Shout out to Law and Order. I see how y'all do it. You see what I'm saying? Maybe in the future we'll be able to do it like that. But I'm definitely not finna get on news station $2,500 for their direct feed. I'd rather put my own camera in the court. All right. So look, I'll be back. Let me head over and do the jackyje case. Y'all want to go to the jackyje? Head over there. I'm about to get the fuck up over there. They'll be right back. We will be right back. I love y'all. Stay in the room. All right. You ain't gotta dip out. You see what I'm saying? This live will stay running for the next 3 to 4 hours. All right. I'm pretty sure this is gonna be a 7-hour live. All right, especially when this case start jumping back. All right. So I love y'all, man. I see y'all, man.
Let's go.
Let's go, gang.
Thanks for joining us here on Law and Crime. I'm Anjanette Levy, and we have a great hour planned for you just ahead. We are going to be taking your questions live here on the Law and Crime Trial Network as we cover the double murder trial of YNW Melly, the South Florida rapper who's accused of killing 2 of his friends and group members. This is a case that's getting a lot of attention. A lot of you guys are watching it, and you've been sending us great questions so far. So keep that going on Twitter, Facebook, Instagram, TikTok, and YouTube, and we'll get to as many of them as we can over the next hour or so. As I mentioned, Jamel Demons, who's known as YNW Melly, accused of murdering his 2 friends. They were Christopher Thomas Jr., who went by YNW Juvie, and Anthony Williams, who went by YNW Sack Chaser. This all happened in the early morning hours of October 26th of 2018. And there is a co-defendant in this case, really a co-conspirator who's charged separately. His name is Cortland Henry. He goes by YNW Bortland, and they were all part of the same YNW collaborative. They made music together. We're lifelong friends. It's an incredibly sad case. And Melly, as a young man, faces the possibility of the death penalty if he's convicted of these crimes. So let's get started with everything. I want to start with Terry Austin, who is live down there at the Broward County Courthouse in Florida, covering the trial for us this week. And Terry, you know, when we left off last week, there was a request, there were 2 requests really for mistrials by Melly's attorney. And so tell us what happened with that and why court was delayed today.
Well, the request for the mistrial was made because the prosecutor was trying to get evidence in the back door that she couldn't get in the front door. And the judge has made a ruling. There was a written ruling on that motion, and he denied the motion for the mistrial. So the case will proceed. But this morning was very interesting because even though the case was directed to proceed, it took a pause, and that is because there was a juror who called in sick. And what the judge announced was they don't know the exact status, except that she apparently was dehydrated, which makes complete sense because it is hot here and it's a bit muggy, it's windy, but apparently she was dehydrated, and she's expected to come back this afternoon, Anjanette.
Yeah, South Florida is no joke in the summertime. It is hot and muggy down there, almost kind of swamp-like. So as I mentioned, we got lots of great questions coming in, and with us this hour as well is Brian Buckmeyer, host here at Law and Crime, also Law and Crime Network host Bob Bianchi, and they are both attorneys as well. So let's start with this first question. Brian Buckmeyer, I'll send it over to you. QDF from YouTube asks, why mistrial got denied? Terry just kind of wrapped that up. Is there a reason for that, and is it a good or bad for Melly? So what are your feelings on the mistrial request, Brian?
Yeah, so you have to make the request. It's one of those issues that if you don't bring it up, it's the colloquial saying, if you don't use it, you lose it. So bring it up makes sense. Why it was denied, I haven't really heard the details as yet. I'm going to be very interested to see why that was. The judge clearly said to the prosecutor, don't do this. The prosecutor clearly did it. But I think Bob will do a better job of explaining this later. What is the judge going to do now to cure the issue that was created? Because the prosecutor said something she wasn't allowed to. What's the jury to now presume 3-4 days after now of hearing that incorrect statement or incorrect law?
Well, and there were actually two requests for mistrials. David Howard made one of the requests. The other defense attorney made the other. They were also upset that they felt like Christine Bradley, the prosecutor in the case, pointed to the defense and said, when questioning Felicia Holmes, they felt like she was saying that the defense, as in the defense team, paid Holmes off for her testimony. The prosecutor said, that's not what I was saying. So there was the issue about the old evidence, the law enforcement statement about what happened that night from 2018, and then the deposition, and then there was this whole other issue. So I'm assuming the judge, I guess, denied both of those requests. So Bob Bianchi, as Brian mentioned, aside from a curative instruction to the jury, what else can the judge do to ensure that this jury isn't biased against Melly?
This is an egregious breach of the ethics code as well as the judge's ruling. This was an intentional decision to circumvent that. So the judge would likely give a very strong curative instruction to the jury to explain to them that it was inappropriate and they were disregarded. And I'm going to also say, from a prosecutorial standpoint, this is a unforced error by them. Even though the judge denied the motion, because I think that was the appropriate thing to do, they've gone through jury selection, they're well into this trial. What they've done is create a significant appellate issue in the case, the prosecutors, by doing what it is that they did. The judge's remedies are to tell the jury that it was inappropriate to do, and in truth, I have seen instances in which judges have referred these things to the ethics committee because prosecutorial overreach. This is clearly a way of circumventing the judge's ruling, and not only are they going to look bad in front of the jury, but I'm going to bet the judge is not going to be all too happy this point going forward and giving them any level of the benefit of the doubt going forward. It was a bad prosecutorial move. Last point, Anjanette, when I was the county prosecutor, if one of my assistant prosecutors circumvented a ruling like that, they would not have a job.
Very interesting. Well, it'll be interesting to see what happens with Christine Bradley as they proceed. There was a curative instruction given on one of the issues on Thursday, but it'll be interesting to see if the judge goes a step further today when the testimony resumes in just about 90 minutes or so, if that juror is feeling up to it. I'm going to send this next question to you, Terry Austin. This is from Janet T. from YouTube. This morning, the judge gave out the name and medical information of one juror. Would this be a reason for a mistrial, or what impact will that have on the trial, if any?
That's an excellent question. I don't think it would be a grounds for a mistrial, but from a privacy standpoint, you would think that the medical information would not be shared. I did hear the judge talk about this juror, and he was trying very hard to be a bit on the vague side. He didn't give any details. He simply announced to the courtroom that there is a juror, she is sick, she is getting treatment at this point, and she may be back between 1:30 or 2 o'clock. So he did mention the dehydration, but I don't think he gave enough specifics for it to be a real breach of privacy, and I definitely don't think it's a grounds for a mistrial in this case.
Well, Andy has to make this known for the record, and everybody's sitting there, right? You've got both parties, the state and the defense, sitting there like, what's going on? We're ready to go. You denied our mistrial request. The defense is saying that. So they're going to note these things for the record, and I don't think a mistrial would be likely either, just my 2 cents. Our next question, Skywalker from YouTube. Is the driver intended to testify against Melly. Brian Buckmeyer, what are your thoughts on that? They're talking about YNW Portland.
Yeah, is he intending to testify? I would imagine no. If he was going to take the stand, it would be a lot of, I plead the fifth, I plead the fifth, I plead the fifth. The question becomes one of two things. One, why? Is there any incentive for him to testify? Is he going to get a lower sentence or a lower offer? We already know that they're not seeking the death penalty against him or any as serious as YNW Melly. And then two, who could compel him to testify? It's not the defense. The prosecutor couldn't because he has the Fifth Amendment right. So I would probably give it like a 2% chance, if that he would testify at all.
Yeah, I don't think there's any way YNW Portland's getting up on the stand because I'm not sure the prosecutors even want to give him a deal or give him any type of consideration given what happened in this case, at least the allegations about what happened with these two young men being shot to death. The prosecution contends in cold blood from the backseat of a vehicle. Let's get to some Twitter questions now. Bob, I'll send this one to you. It's from @22Roscoe. And he asks, will YNW Melly take the stand? Bob Bianchi, what do you think? And do you think that could change if Portland testifies, which we don't think will happen?
I want to go back to the last question real quick. You know, the prosecution always can give immunity to a witness that's got the Fifth Amendment if they really want his testimony, because that can't be used against him in a subsequent trial. Listen, no defense lawyer, nor certainly somebody who has not looked at the file and is not involved in what the defense may ultimately be, is going to make a prediction. Usually the decision as to whether or not a defendant is going to take the stand is not made until after the state's witnesses have all testified. And you have to make a balancing equation when you're consulting your client and say, listen, did the prosecution prove its case beyond a reasonable doubt? Because to use an old axiom that my mentor taught me, juries love to convict defendants from the mouth of themselves on the witness stand. So it is an extremely personal and nuanced decision. Last point, I'd say, Anjanette, the one caveat and curveball when you have a celebrity like this, there's a lot of ego. There's the court of public opinion. There are his fans that he wants to cater to. And sometimes that drives them to do something that's good in the court of public opinion, but disastrous in a court of law. We'll have to wait and see.
We will definitely have to wait and see. And, you know, YNW Melly's fans, I'm sure, want to hear from him. They are very active on Instagram and TikTok. But whether or not he gets up there and puts himself in the hot seat, that's a decision that is totally up to him. His counsel can, of course, weigh in with him and advise him. But in the end, it's his decision to make. Our next question, Terry, I'll send this one to you. Tay from YouTube asks, will the prosecution need, in all caps, the weapon used to get a conviction?
Well, what they need to do is to prove to this jury beyond a reasonable doubt that it was Melly who was sitting in the backseat of that car on the driver's side who shot those two kill shots to both of the victims. And what they need to do is to have some forensics. They've already had some experts who came in to try to say that the trajectory of the bullets went a certain way. But on defense, they really did a great job cross-examining those witnesses and saying, look, you don't have the height, you don't have the distance, so this is basically just a guesstimate as to where those shots came from. So if they can't put the gun in Melly's hand and if they can't show where those bullets came from, I think the prosecution is going to have a very difficult time. Plus, the defense has already laid the foundation in the cross-examination and certainly in their opening statement that the investigation was very poorly done. They did not follow up on leads. They did not even follow up with questions to Henry, who is the co-defendant, and that case has now been severed from this trial. But I definitely think that those are the two areas. One, the fact that they didn't follow up with these investigations, and two, the bullets. It's going to make it a little bit difficult for that prosecution to prove that it was Melly who did this. So right now, I think the momentum is on the defense side.
Very interesting take, Terry. And you are there in the courtroom, so we're going to be really excited to hear more from you as the days go on about what it's like in there, sitting there kind of taking this all in and what's going on in the gallery. Facebook question for you, Brian Buckmeyer. Catherine Vargas asks, if there were additional jurors missing today, on top of the one that was in the emergency room, at what point would you call in alternates?
I mean, I don't know why he's not calling an alternate now. You're able to call an alternate for any reason. A juror is stuck in traffic, a juror is sick, illness in the family, whatever it may be. I don't understand why we're waiting on this juror. Maybe it's a fear that if you just give one alternate into the main jury pool, then they'll start quote unquote dropping like flies. But any point in time, I don't know why we didn't start early this morning. Maybe the judge wanted the morning off. I don't know.
We don't know. It'll be interesting to know. Maybe they feel like we don't need to call in an alternate. We can just delay a couple of hours. Maybe they don't want to lose one, because this trial could go several weeks from what we have been hearing. All right, everybody, we are going to take a quick break, but we want you to stay with us as we continue to take your questions this hour. So keep submitting them to us on all our social media platforms: Twitter, YouTube, Instagram, TikTok, Facebook. We'll get to as many of them as we can, and stay with us. I'm Anjanette Levy. You are watching Law and Crime. We'll be back in a few. Welcome back. I'm Anjanette Levy, and thanks for joining us here on Law and Crime as we take your questions this hour on the trial of YNW Melly. There's been a delay because a juror was ill this morning, but that juror is expected to report to court around 1:30 p.m. Eastern time. So we are hoping that testimony will resume at that point in time. So keep it tuned right here to the Law and Crime Network. Also our YouTube channel. You can watch the feed uncut there. And keep your questions coming to us. You guys have been submitting a lot of great questions, and we'll answer as many of them as we can about the trial. So I'm going to send this next question to you, Bob Bianchi, about the co-defendant, the co-conspirator in this case, who's also facing criminal charges, Cortland Henry, known as YNW Bortland. He was the driver of the vehicle that night. This is One Icy Woo from Instagram. They ask, will the state prosecute Cortland Henry as the murderer if Melly is innocent? And I'm wondering if the question is being asked because will they try to say he was the trigger man, not just the driver, if Melly is acquitted?
Yeah, that's a really, really interesting question, and it's a prosecutorial discretion question. I have literally been involved in cases where the principal is found not guilty, but prosecutors continue to prosecute the person that they believe was involved in the conspiracy. Essentially, what the prosecutor feels is that the acquittal was not appropriate, that they had enough evidence, and if they think somebody else was an aider and abettor or a conspirator, they can still prosecute that individual. So that's really up to the prosecutors at the end of the day to say to themselves, ultimately, though, hey, if we couldn't prove that he was the shooter and he was acquitted, do we want to really go forward with somebody else who's not a shooter but a co-conspirator? Again, a prosecutorial decision. I will say there are times, Anjanette, where prosecutors say, you know what? I'd rather try the case. I know it's going to be tough. I believe he did it. If he's acquitted, but at least we gave it the fair fight.
Yeah, that's all they can do at some points in time. You know, like if they think they've got the evidence and they think the person did it, they have to go forward and they roll the dice. TikTok. This question is from TikTok. It's from Lay from TikTok. Why isn't Bortland getting the same treatment as Melly if most of the evidence is on Bortland? And I think this question, Terry, it relates to the fact that Melly is facing the possibility of the death penalty. YNW Bortland is not.
Well, that's right. And, you know, the death penalty obviously is a final sentence. I mean, it'll be appealed if, in fact, he's convicted and he gets that. But I think that right now, because the case is severed, they will be pointing the finger at each other. You heard in the opening for the defense that they were saying, look, it wasn't Melly who was lying. It was Henry who was lying. So they're basically trying to say, look, it was Henry who said that he was the only one in the car. My person has not done any of that. So I think having it severed is better for each of the defendants, frankly, because sitting at the same table, they can't really do much of the accusatory actions that they're doing now. And right now, we can't see any defense, obviously, from Henry because he's not here. But when that trial takes place, you better believe that they will probably be pointing the finger the other way. So because it's severed, I think it's easier for each of those defendants to be able to point to each other.
Yeah, a lot of this going on in this case because they can do it. As you mentioned, the cases are severed. Let's go to the next question. I'll send this one to you, Brian Bruckmeyer. Extra_simply from Instagram asks, why did he leave his one friend to take the others to the hospital? And I think this question refers to Bortland taking off with the vehicle and Melly not going to the hospital as well.
Yeah, I mean, we're only going to know if he takes the stand and testifies, but I guess the assumption for the prosecutor would be is that YNW Melly is the main guy. He's the trigger guy. I mean, that's why they're asking for the death penalty for him rather than that of Cortland Henry. He's only looking at life in prison. But I'm assuming they would say that YNW Melly didn't want to be associated with the lie, the conspiracy, the cover-up, that this was supposedly a drive-by, that he and Henry must have concocted this idea beforehand, and Melly would stay back and Henry would go and drop off. Now, the curious question becomes is, if they fail in this case, do they still proceed to Henry as Bob was talking about? I don't think that they'll be able to say that Henry was the trigger man Of course, in this trial, the defense can argue Henry was the trigger man. We don't know if our guy was the trigger man. The angles and the trajectory, we don't know if those are correct. But a prosecutor has to stick to the same theory. Otherwise, if they flip-flop, it is a defense attorney's dream. Oh my gosh, you thought this guy was a shooter this day. You thought this guy was a shooter the next day. Your theories keep jumping back and forth wherever you win or lose. I think there's a lot to gain here for the defense, not so much for the prosecution until they tie up some loose ends.
Bob Bianchi, I'm going to send this next question to you. As a former elected prosecutor, county prosecutor, Jody Smith from YouTube asks, if you were the prosecutor, would you be happy with the way this has gone so far? I think that's a great question.
Well, fortunately for me, I was not elected. I was appointed by the governor to that position. That's
pardon me.
No. That's how we do it in Jersey. And I say this for a reason. I make that distinction for a reason. When I'm appointed, I don't have to worry about the court of public opinion. I don't have to worry about being elected again. I don't have to worry about raising money. To answer the direct question about whether I would be happy about the way the prosecution is going, I'm not happy about the expert witness that was attacked and the defense scored points. I'm extremely unhappy that my assistant prosecutor did something in violation of a court order that could jeopardize the case, even if not now, but certainly for appeal. So listen, sometimes to answer the viewer's question, you dance with the one you brought. I've tried lots of cases that the evidence wasn't so good. There were nefarious witnesses we had to put on the stand. Things started to fall apart, but we were convinced the person did it. That's my ethical obligation. And so then I would just say to my staff, or I would say to myself, you're going to go in and fight the fair fight, and whatever the jury does, the jury does. But to answer directly, I am not happy about the way the prosecution has put this case in, nor the witnesses who have testified.
Yeah. And Anjanette, on the other side, the defense attorney probably had a very good long weekend. They were probably dancing most of that weekend.
Sure.
Yeah, I think that they are happy with where things sit right now. I mean, they were pretty upset at the end of the day on Thursday. Probably don't like that their mistrial motions were denied, but I mean, they've been able to do a really good job on cross with a lot of these witnesses, it seems, from where I'm sitting. Our next question, Miosha from YouTube, Terry. Why didn't they put his girlfriend on the stand? That's Mariah Hamilton. We heard from Mariah's mom, Felicia Holmes, on Thursday, but do you think we'll end up hearing from the girlfriend?
I think that's a great question, and it is a distinct possibility. I think that on the stand, the mother was really afraid. She basically said on the stand, the very first thing she said when she sat down was, I'm intimidated, I'm afraid. And ultimately, she explained that she was afraid of the prosecutor, and specifically, she was afraid of Bradley. And I think, obviously, it's because she feels as though both she and her daughter have some exposure here. She was under arrest. She was wearing an ankle bracelet. She said she lost her job. And so I think both of them are in fear of getting up on that stand. We saw Felicia first. I do think we may see Mariah second. Obviously, she was accused of perhaps being an accessory after the fact, and so she is frightened. But I think to answer the viewer's direct question, there's a possibility she could be called.
And Felicia Holmes said that on Thursday, Terry, that she, her daughter that was threatened by the police, according to her, with being charged as an accessory after the fact, because it sounded like back in 2018 they may not have been talking. Let's go next to Freckly Facey from Instagram. Brian, why are they bothered by Melly's actions in the courthouse when in a situation of facing the death penalty, you have no choice but to try to stay positive? And we've seen Melly be pretty expressive in the courtroom.
Yeah, I would agree. I've done trials. I've had clients next to me who have seen a trial go well. In the middle of it, they're smiling, or a trial go poorly. In the middle of it, they kind of frown. The thing that I agree with you, it should be that he's allowed to go through this process however he wants. The problem is he is literally being judged. Every action, whether it be a smile, a frown, he wears a brown jacket, he wears a cream jacket, an entire state has said that you are accused of the highest crime and they are seeking the highest punishment. And so just to be safe and try to please as many people as possible, there is a reverence that most defendants are asked to have, so that people, when judging them, will judge them positively rather than negatively, as so many people are. I've never been on trial where my life is on the line. I don't know how I would act. I don't know what his mental status is. I don't know how he reacts to stress, but people are people.
That's for sure. People are people. And, Bernardo Villalona and I were talking about this the other day, that we don't know his mental health condition, his mental health state, and people do react to things differently. And he is under a lot of pressure. All right, guys, keep your questions coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok. We'll get to as many of them as we can. But for now, we're going to take a quick break. I'm Anjanette Levy, and you are watching the Q&A Lunch Show on Law and Crime. Thanks for joining us here on Law and Crime. I'm Anjanette Levy, and we are taking your questions this hour on the case of YNW Melly. That trial is well underway in Broward County, Florida. And Melly is a rapper accused of murdering two of his friends, YNW Juvie, YNW Sack Chaser, back in October of 2018. Melly says he didn't do it. He also has a co-defendant, Cortland Henry, who goes by YNW Bortland, who faces charges in this case as well, but will be tried separately at a later date. We're taking your questions, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, and TikTok, and we'll get to as many of them as we can. Bob Bianchi is here with me, Brian Buckmeyer, Terry Austin. We're all Law and Crime all the time here today. Bob, I'm going to send this next question to you. It comes from Wesley Passmore from YouTube. And Wesley asks, do you think the mistrial not happening is in favor of YNW Melly, and how do you think his mannerisms in court will affect the jury's decision?
I'll take the last one first. And by the way, great questions. His mannerisms are not helping him in the courtroom. You just don't need the jurors to feel that those weird things he's doing are disrespectful to the court, because they're going to make an analogy. And maybe as a prosecutor, I want to sum up, if this is the way he takes it as a joke or whatever you hear, can you imagine what he's capable of doing outside of the courtroom? So I'll just leave that aside. As a defense lawyer, you just don't need that. With respect to the mistrial motion, great question. There's a lot of nuance here. Let's get to it. On the motion for a mistrial, what I had imagined the defense would have done, and Brian can see if he confirm, and each state's a little bit different, is that the judge were to have granted it, the defense would have then indicated that they want to have the case dismissed for double jeopardy grounds. They would have argued that this mistrial was done because of purposeful, outrageous conduct by prosecutors, and that he should not be convicted or brought to trial a second time. Now, that's a really hard standard in most instances. But what the defense attorney clearly wants to do is create a record for appeal, and if the judge denies all these things, an appellate court can revisit it. But Anjanette, here is the tactical issue here. When you have a really good case and your case is going well, a lot of times you make these motions because you have to preserve the record, hoping the judge denies the motion, because if the judge were to say mistrial, but I'm not granting double jeopardy, so we go back to square one, the defense can't guarantee on the second act or the second play that the testimony is going to be as good, because they've already let their cards out to a certain extent. So a lot of times you want to win the battle by losing, or win the war by losing that battle. So it's a really sophisticated and nuanced thing here, but the judge actually did them a favor. The judges often say, you know what, I'm not granting a mistrial. Now you prosecutors have created an appellate issue in this case. Now I'm going to give a curative instruction to this jury to say what you did was wrong and that they should disregard it. And then the defense lawyers can say, whew, wow, now we don't have to have another trial from the beginning when our trial's going in so well right now.
Good insight from you, Bob Bianchi. I'm going to send this next question to you, Terry Austin. It's from Slap Shoddy from TikTok. What if Melly gets the death penalty and later on we find out it wasn't him?
Well, that's a good question. I mean, that's part of the issue many people have with the death penalty. There is no room for any sort of mistake. And there is a distinct possibility that if convicted, he could get the death penalty, because we know that the Governor DeSantis just signed a new law that says it doesn't have to be unanimous 12-0. It can be 8-4. And so it is a bigger possibility that that death sentence could be issued here. So if it's the wrong answer, and ultimately some of the other people that the defense pointed to who said might have been suspects in this case, but that the prosecution didn't go after them, if we find out later that someone else did it, or perhaps that, you know, Henry did it and Melly didn't do it, whatever the scenario is, if you find something out later, it is too late if in fact that death sentence has been issued and executed. Now, I will say that it does take years, because oftentimes there are appeals, as there should be, because it's a very final sentence. So hopefully, you know, if it gets to that point, it's the right conclusion, but that is in fact a very serious problem with the death penalty. You have to be absolutely correct.
Yeah, definitely. And, you know, a lot of people have a lot of questions about that lower threshold now for that law that Governor DeSantis just signed back in April. So this is just a recent thing that's happened. We'll send this question to you, Brian Buckmeyer. Horatio27 from TikTok asks, do you think the prosecutor will bring up prior bad acts such as the shooting that happened?
So there should have been a ruling on it already as to whether or not it came in. The only other thing the prosecutor could do is try to question a witness in a way that opens the door. Or maybe if the defense puts on someone on the stand, this might actually be a reason why YNW and Melly doesn't testify. Not necessarily because of anything that happened in this case or this incident, but because of prior bad acts. If he goes up there and says, I never touched a gun, I've never touched a gun in my life, then they get to attack that second half of it and say, hey, here are other cases, here are other videos, here are other photos of you showing the gun, and that prejudice could come in based on his own words. So do I think the prior bad acts will come in? At this point, I think if there's a ruling on it, no. However, testimony in the future, whether it be YNW Melly himself or other witnesses, could potentially open the door to it.
Let's go to our next question for Bob Bianchi. This is from @LegendDad2013 from Twitter. Why are they charging Melly with 2 first-degree murders when the other person in the car, Bortland, could have pulled the trigger?
Well, that kind of gets back to what Terry was talking about before. Listen, having tried death penalty cases, the number one rule is you have to be absolutely convinced at who the person is that shot the individual. You can't have any hesitation about that. There could be no other explanation. So you also have to have aggravating factors in a case in order to get the death penalty. In this particular case, I think the aggravating factors against Melly are very weak to begin with, and they're certainly going to be weaker to the co-defendants or even aiders or abettors with regard to whether those aggravating factors exist sufficient enough to justify the imposition of the death penalty. So a shooter you get, the people that may have been surrounding them don't implicate the same aggravating factors as the shooter. So this is why, if there is any dispute in a prosecutor's mind as who the person was that potentially killed the person, it should not be a death penalty case. And if you are not surely convinced that you can prove beyond a reasonable doubt to each and every individual juror, each aggravating factor, at least one aggravating factor that justifies the death penalty beyond a reasonable doubt, then you should not be imposing it. We have a lower standard now with the DeSantis rule, if you will, but as a prosecutor that's tried death penalty cases for the life of me, I don't even understand why this is a death penalty case to begin with. I'm not suggesting that what happened is right, but you have to make a decision as to whether the aggravating factors in the case, for example, vulnerability of individuals, young people, old people, was it done, in the commission of a felony, certainly one of them, was it done as part of terrorism? There's a number of aggravating factors. Are they sufficient enough to go in that direction where you're asking the jury to give the ultimate penalty, and especially in a case where the defense seems to be showing to a jury, he may not have even been the shooter. It's not a good death penalty case.
Well, the state says he was the shooter because they have this surveillance video of him getting into the back passenger or back driver's side seat. And so they're saying that these, bullets were fired from there. They're stippling on the victims, meaning at close range that these happened. There's another question, Terry, I'm going to send to you from Georgia Peach, I think, GA Peach 1988 from Twitter. And this is kind of tough because we heard this testimony last week, but I think it's kind of, confusing to people. Can you explain the trajectory of the bullets in reference to the angle of the bullets in the car?
Well, it's interesting because during the opening for the prosecution, she actually did state, listen, don't forget your science that you learned when you were in school. And she admitted it's not going to be foolproof, that all of her evidence that she's putting in from a forensic standpoint might not tell you the exact thing that happened. And in fact, when she brought those forensics in and she questioned them, they could not basically state certainly that the trajectory was from that back seat. And here's the reason why. We heard on cross-examination, and I mentioned this before, that we don't know so many of the variables. We don't know how high or how tall the individual was. We don't know where he or she was sitting. We don't know any of the information which could actually give us the trajectory of those bullets. And so they actually had to admit on the stand during cross-examination that essentially it was a guesstimate. So I think it's a very difficult issue. I think that that's a weakness in the prosecution's case. And I think if they can't definitively state how those bullets were shot from that back seat, it's really going to be very difficult to put Melly in the box. And that's what they've done right now. I think Bob is absolutely right. They've said, look, Melly was the one with the gun. Melly was the one who shot. He was in the back. You have that, gunshot on close range. And so for those reasons, they decided that he was the one who was the shooter. But it's not that definitive, at least not in my mind, and I think in the minds of those jurors as well.
Mm-hmm. Well, it'll be interesting. Terry, I want to see what you say later in the day about how this jury looks as they're listening to the testimony. I know it's hard to read them, but sometimes they're kind of expressive and you can tell what they're thinking. But we still have a long way to go. And we are going to take a quick break. So stay with us and keep your questions coming to us on YouTube, Instagram, TikTok, Twitter, Facebook, and we'll get to as many of them as we can. I'm Anjanette Levy, and you're watching Law and Crime. We'll be right back.
Okay, welcome back to Law and Crime Network. My name is Bob Bianchi. I'll be taking for the next 2 hours. Our trial coverage takes us to Broward County, Florida, for the trial of Jamel Demons, better known by his stage name YNW Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of his 2 friends, Christopher Thomas Jr. and Anthony Williams, who are also part of the YNW collaborative, along with Cortland Henry. The co-defendant in this case will be tried separately, those cases having been severed. Today, court is off to a late start because of a juror issue, and we're going to recap some of the key moments from Thursday's testimony due to the court being dark on Friday and Monday. And as soon as court starts, of course, you know we're going to jump right into it. So let's listen to the testimony of forensic scientist Tyrenichol.
And without getting into the actual results, we're just going to orient the jury to the chart that I have here, beginning with the top left.
Yes, so the top left is an image kind of showing where the particle is located on the sample, and that is taken at 400 times magnification.
And the top right?
That is now a closer up image of that particle taken at 3200 times magnification, where you can see clearly that it is bright, it is round in shape, and you kind of are able to visualize really the morphology of that particle.
And bottom left?
So that is what is called the EDS spectrum. Basically, it's just showing you what elements are present in that particle. So PB is lead, BA is barium, and SB is antimony. So you see peaks for all of those present in that particle. Therefore, it is a particle that contains lead, barium, and antimony, which makes it characteristic of gunshot residue.
And are the peaks that we see consistent with the amount of that compound within the sample?
Yes, overall, the height of the peaks relate to how much of that element is in the particle.
And finally, the bottom right.
So that is the image that the instrument takes during the automated analysis.
I'm showing you what's been entered into evidence in states 57. Do you recognize that?
I do, yes.
And what is that?
This is a gunshot residue kit that we received in this case.
And did you analyze states 57?
Yes, I did.
And did you ultimately analyze state 60?
Yes, I did.
Okay. So, let me see. Grab your scissors. Go ahead and open the states 57. I'm going to ask permission from the judge for you to step down.
You may.
You want to open it, grab some gloves, and we'll go to the machine.
Just if you can publish state 57.
And the contents. So you received one sample, but there are 2 tubes.
Yes.
What are they representative of?
These were samples that we had received that are labeled as coming from the right hand and the left hand.
And who's the individual?
Cortland Henry.
Did you ultimately have a chance to analyze and go through this SEM process, which was the automated process, and your individual process, in order to come up with an opinion as to the presence of GSR?
Yes.
And what was that opinion? And if you can specify both the left and then the right.
Mm-hmm. So the right hand of Cortland Henry contained 0 particles characteristic of gunshot residue and 2 component particles. And the left hand contained 1 particle characteristic of gunshot residue and 1 2-component particle.
Okay. And can you explain to us what that means?
Basically, overall, there was gunshot residue present on the hands.
Okay, and what affects the presence or absence of GSR on a person's hand or any object?
Sure. So If there is gunshot residue on someone's hands, that means that the individual got it on themselves by either discharging a firearm, being in the proximity of a firearm when it was discharged, or by coming into contact with a surface or object with gunshot residue on it.
Okay. And if we may go back to the demonstrative aid, what was this demonstrative aid? Was this representative of your results of Portland Henry?
Yes, that was the particle characteristic of gunshot residue that was on the left hand.
And the components, which you explained before, there are three kinds or three compounds that you were looking for, and which compounds were present in Portland Henry's left hand?
Lead, barium, and antimony were present in that particle.
So all three components?
Yes.
Okay, and let's move on to stage 60, which was the sample for the Jeep. What were your results? And again, did you also go through the SEM automated process and then your individual characteristic process?
I did, yes. So there were 0 particles characteristic of gunshot residue, but at least 9 2-component particles.
Okay. And what does that mean?
So, like I mentioned, 2-component particles can come from gunshot residue, but they also have other sources. So, because of that, these results are basically inconclusive. They could be gunshot residue, but they also could be from something else, and I can't say which it is.
Okay. In your analysis and reviewing the sample, did you find anything inconsistent with gunshot residue, if I'm phrasing that correctly?
Correct, and I did not. So overall, with 2-component particles, or any of the particles we look at, oftentimes if the particles are from another source, there are other elements or amounts of elements that would be unusual to find in gunshot residue. So, for example, one common source of 2-component particles is brake pads. Brake pads typically contain high amounts of the element iron. So if I'm doing my analysis and I come across particles with high amounts of iron, I eliminate them and I do not report them because there's something about them that would suggest they're from something else. So while I still cannot call these particles gunshot residue, there was nothing about those particles that were unusual.
Are you familiar with them in general?
I am, yes.
Are you familiar with the friend or foe presumptive GSR kit?
I am.
What is that kit testing?
That kit is like you said, a presumptive test that is looking for the presence of nitrates, so nitrogen containing compounds.
Okay. So for instance, these GSR kits are made to essentially alert to the presence of a certain compound.
Yes.
And the friend or foe kit specifically alerts to the compound of nitrogen particles.
Yes.
So the presence or absence of nitrogen particles.
Correct.
And are presumptive tests relied on exclusively?
No, they are just a screening tool. Like I mentioned, they're looking for nitrates, and there are many things that can contain nitrates. So they are not conclusive to the presence of gunshot residue or gunpowder. They are really just to be used as a screening tool.
Okay, well, welcome back. I still have Brian Buckmeyer in studio with me. You know, what can I say? He's just everything extraordinaire at the Law and Crime Network. So it's great to have my friend here as well. It's Natalie Whittingham Barrell, who is a criminal defense lawyer. And I'm being told, I'm looking at the producer says here, known as, this is what I'm being told you're known as. This is not what I am saying. Let's be clear for the record here, that you are referred to as the lawyer chick on YouTube. Is that right? Is that what you refer to yourself as?
Yes, so I will not be offended. Here on YouTube, I am known as Natalie Lawyer Chick.
Yeah, I don't want to step into anything here, but anyway, that's great for you because I hear that you're awesome, and I'm glad that you're here on the show. Natalie, let's look. This testimony as a prosecutor, still to this day, all these years later, makes me want to faint. I get nervous. You have to put it in. It's important to the case. You don't want to lose the jury. So rather than talk about the ins and outs of the perfunctory part of admitting your evidence in, which is a skill set you have to learn as a prosecutor, what are your thoughts about the trial overall, where it's going? What are you seeing?
Well, from the perspective of a defense attorney, I know that jurors treat forensic evidence very, very seriously, and the presence or lack of it can be detrimental to a prosecutor's case. That does not mean that a state cannot win their case without that forensic evidence. And here, they just don't have the forensic evidence to back up their case. What they have is YNW Melly in the back seat, even according to his girlfriend's mother, and phone records placing him there when the shooting is alleged to have occurred. That's their best evidence. But this gunshot residue being found on YNW Bortland's hands is more helpful to YNW Melly than it isn't. The same thing with the ballistics evidence. It was more helpful to YNW Melly than it was not helpful to him.
Wow, a great point, Brian. We were talking with Anjanette before, and I want to get into this because I think it's so important. They're talking about the motive, and I hate when, and it's true, the prosecution does not have to prove motive, but you sure want it as a prosecutor, and a defense attorney is sure going to say, what would cause him to do this? Now, we're talking about aggravating factors, Brian. We talked about it before, and I heard that there's a dispute. It could be, maybe it was over a financial thing, assuming you want to believe the state's theory of the case. Maybe it's gang related. First of all, where, Brian, is the evidence of the gang related aspect of it? Is just another while throw it out there? Because this is really important, because the gang relation is one of the aggravating factors for the death penalty case, Brian.
Yeah, so first and foremost, understand when I answer these questions what I am. I'm a former public defender from Brooklyn, not from Brooklyn, but practice in Brooklyn. And so what I see oftentimes in cases like this, unless you're going to get that smoking gun of my client's in a gang and watch him do gang stuff and look at this video of him acknowledging that he's in a gang, they're just going to throw circumstance and the typical tropes. Look at his face. He has tattoos. Look at the way he raps. Look at the way he holds himself. Clearly he must be in a gang. But there's no, unlike what my grandfather, my mom probably says, guilt by association. You have to actually participate in the gang. You can't just go on a social media or go on a rap video and say, hey, I'm a part of this crew, or hey, I'm a part of this crew. Hey, you can even be part of that crew, but if you're not doing anything gang related, the enhancement doesn't seem to work there. And here we have a case where no one's quite sure what it is. Is it money motivated? Is it gang motivated? Maybe he is in a gang, but this was his day off. I don't know. But I don't know, I guess they get days off. We get days off as attorneys. I assume you get days off on gangs. You can't be gang banging every day. But if there's no evidence and there's just this pomp and circumstance of, look at his face, look at his tattoos, he says he was a gang, this must be gang related because someone died around him, I don't see the aggravating circumstances.
Yeah, and Natalie, I go to the point, and I think that this is not a liberal concept. This is from a person who's tried death penalty cases as a prosecutor. I want to be absolutely convinced who the shooter is in a case like this, and I want to be absolutely convinced as to what the motive is, because with all respect to the judges and the defense lawyers and the prosecutors, the system is not infallible, and I think in the end as a prosecutor, tactically, the defense is going to jam this down the prosecutor's throat in summation to say they're just throwing the spaghetti against the wall and hoping something sticks, and then they ask you to convict him of capital murder for that? I mean, talk to me. What are your thoughts as a defense lawyer? Because this is one where I think they could really get outraged about.
Yeah, as a defense lawyer, I always anticipate where the state doesn't have a motive. And I know that in closing, the state's going to hammer home that they don't even have to prove a motive in order to prove their case. But we know juries and we know real life people, and they're going to want to know why. Why did this happen? And so far, there's been no evidence of a why. If you believe that YNW Melly is in a gang, then you must also believe that YNW Sack Chaser and the other gentlemen were also in the same gang. What type of conflict was there in order for this alleged murder or hit to be ordered or carried out by YNW Melly? There's just no evidence of it so far. And as you said, in a death penalty case, the jury's really going to want to see the proof.
Yeah, and I'll tell you what, it's not just so much showing what the motive is, i.e. if they want to prove it's gangs, it's just show it's not any other motive. At least that's what I would do as a prosecutor. Anyway, now let's take a listen to the cross-examination and a bit of the redirect.
You got the sample from Marijuana Police Department?
Yes.
Specifically, Detective Moretti directed to you?
Yes.
And when we talk about GSR, or gunshot residue. You're aware that GSR can be found on clothes, correct?
Yes, that's possible.
Did Detective Moretti send you any clothes of Cortland Henry?
He did not.
He didn't send you any of the clothes?
No.
Did you know that the clothes of Cortland Henry were collected by the Miramar Police Department?
Objection calls for speculation outside the scope of court.
Well, I don't know that calls for speculation. If she knows she can answer the question, overruled.
Were you aware that the Miramar Police Department collected Cortland Henry's clothes?
No, I was not aware of that.
In your examination, had you received clothes, you could test those clothes for GSR, correct?
Yes, we can certainly test clothing.
And you've done that many times, correct?
Yes, absolutely.
Also, if someone is in a hospital, in a bed in a hospital, do you know if that person has washed their hands?
I don't.
Okay. And by washing your hands, you can get rid of GSR, correct?
Yes, hand washing can remove most, if not all, of the particles on someone's hands.
Do you know if Cortland Henry washed his hands or changed his clothes?
I don't know that.
Is hand washing the only thing, contrary to popular belief, that removes gunshot residue?
No, gunshot residue is easily removed in general. So with respect to the hands, any type of activity, touching or use of the hands can remove particles pretty easily. With clothing, any activity. So if the garment is touching things, if it's laundered.
If it's removed?
Yes, any activity can cause particles to be destructed or removed.
And you're an independent lab, correct?
Yes, we are.
You're not associated with Miramar Police Department?
Correct, we are not.
You're not associated with the Broward Sheriff's Office?
We are not.
So you can only test what you're submitted, correct?
Correct.
Nothing further.
One question. Yes. You were hired by the Miramar Police Department to perform this test then, correct?
Yes, they're the ones that submitted the samples.
You can only test what was submitted. On that note, we're going to take a break. We'll talk about it on the other end. Please stay with us. Turns out to be why, and we're completely thrown off in the beginning of the case. But I have a moral responsibility when I get in there that I know, no matter how hard the evidence is, that this is the person who did it, and we have done everything to check to see if it was anyone else, and to build up that case so that all threads were tied up, if for no other reason that you don't have what the defense attorney did right here with this forensic expert to show that you were malfeasance. The more malfeasance there is, the less confidence the jury has. What are your thoughts?
So exactly right. And as the defense attorney, I'm looking for every single opening that you're going to give me. And there were a lot of openings here in the forensic evidence. There were even openings with their civilian witness, the mother of the girlfriend. There were openings all over the place, and YNW Melly's attorneys are highly skilled. And so they got right into those openings and pointed out all of the inconsistencies, all of the ways in which the evidence is missing and lacking. And that was only cross-examination. Wait until they get to closing arguments and they're able to point out every single opening that was left by the state. All of those openings are reasonable doubt. At least that will be the defense's argument. Does that get them over the finish lines to not guilty or a hung verdict? I don't know, but I do know that it seems like the prosecution left a lot to be desired here so far.
Well, you definitely know things. My producer said you were rather prescient, and in fact, during the course of your answer, you proved that because Felicia Holmes, the mother of the defendant's ex-girlfriend, which you just mentioned, took the stand on Thursday, and there was never a dull moment for sure. Let's take a listen as to why.
Good morning, Ms. Holmes.
Good morning.
How are you today?
Not good.
Are you cold?
No, I'm just, you know, I don't feel comfortable.
Are you nervous?
I feel threatened.
So, Ms. Holmes, I want to start and just talk about who you are.
Yes.
Ms. Holmes, do you have any children?
Yes, I do.
Can you tell the ladies and gentlemen of the jury who is Mariah Hamilton?
My youngest daughter.
And how old is Mariah?
She's 22 right now.
And Mariah, did she have a romantic relationship with someone named Jamel Dennis, also known as YNW Melly?
Yes, she did.
When was she involved in that romantic relationship with Melly?
I think it may be 2016 or so till maybe 2019-20.
Okay. Did you have the opportunity to meet Mr. Dennis?
Yes, I did.
What did you refer to him as?
I call him Jamel Melly.
Do you see him here in the courtroom?
Yes, I do.
Where is he?
He's right here.
And what's he wearing?
A white turtleneck and a gray jacket.
You are made a record reflect an in-court identification of the defendant.
Yes, the record will reflect an in-court identification of the defendant.
So I want to go back to October 26th of 2018. Where were you living?
I was living in Cocoa.
And my geography is terrible, I think. How far away is Cocoa from Broward County?
About 3-4 hours.
What do you do for a living?
I'm a registered nurse.
Were you a registered nurse at that time as well?
Yes, I was.
Did you know the defendant's mother?
Yes, I do.
And who is she?
Jamie.
Have you met her prior to October 26th of 2018?
Yes, I have.
Have you communicated with her?
Yes, I did.
Did you have a phone number for her?
I'm pretty sure I probably did.
I'm not asking you, sir.
I don't know. I did not. I can't remember.
Okay. So I want to go forward on October 26th of 2018 and talk about that early morning hours. Did you receive or hear a phone call or FaceTime video call in which the defendant was a participant?
I did overhear. I'm not quite sure exactly the context of the call, but I did overhear the phone call.
Tell the ladies and gentlemen of the jury what woke you up that morning.
Just hearing my daughter's voice.
Okay. What was the tone of her voice without saying what she said?
I don't remember. I don't remember.
Okay. Do you remember anything the defendant said on that video?
Not verbatim, no, I don't.
Okay. Did you have an opportunity to read the statement you gave in 2018?
I read the statement.
Okay.
I don't recall. I don't remember anything from that statement, but I do remember my deposition from December 22.
So the deposition, that would have been 6 months ago?
Yes.
Okay. I want to go, and when you spoke, remember speaking with law enforcement in December of 2018?
I remember speaking with them, but I don't remember what they look like. I don't remember their names, but I do remember talking to someone.
Okay. So, Ms. Holmes, I want to ask you, were you honest and truthful with law enforcement when you spoke with them?
I would hope so. I mean, it was 2018. I went through a lot during that year, so I'm not sure where my mindset was at that time.
Did you lie to law enforcement?
I would hope not. But I don't remember what I said at that. It was like 5 years ago.
Oh, of course. I understand it's been a long time. So in terms of the time frame, that was closer in time to the incident of October 26th of 2018?
If that's where you guys are saying it is.
You don't even remember?
I don't remember. Like I said, 2018 was a very hard year for me. My husband just went to prison. My father died. I had a lot going on, so I was really out of it.
Okay. And in terms of your conversations with the police officers that morning?
Yes. I do remember that they kind of bullied me and threatened my daughter to take her to jail for accessory after the fact. I do remember that.
Yes. And in terms of the statements that you made about what happened, you don't have any recollection of that? Did you read this statement multiple times?
I looked at it and I just didn't recall it, and I don't know.
And so you indicated you hoped you were truthful with law enforcement?
Yes, I did.
I have to ask you to be more definitive. Were you truthful?
I don't remember what I said to them back then, so if I was to tell you something now, I could be lying. I don't want to lie to stand because you're going to take me to jail. So I'm saying what you want me to say.
I do not want you to say anything. I want you to tell the truth.
Okay, that's what I'm doing.
Okay. So, Ms. Holmes, with regards to that day, did you lie to law enforcement?
Objection asked and answered. Excuse me. Overruled.
Ms. Holmes, did you ever say the defendant made you quit your job?
I never said anything like that. I know it's never made me quit my job.
Objection. Overruled.
If I may approach him? I'm going to show you this next few minutes. So I'm going to ask you again, have you ever made a statement that the defendant made you quit your job and that they would take care of us until the trial is over?
I never say anything like that.
Okay. So you're denying making that statement?
I never say anything like that.
No.
Objection. Your Honor, can I just have a standing objection so we don't keep interrupting?
No, you stay with your heard on the standing objection.
Whatever defense is.
That's fine. Go ahead.
Okay. So, Ms. Holmes, in terms of have you ever said a statement, have you ever made a statement to the effect of you were told to quit your job and the defense would take care of us?
Of the judge? No.
Excuse me.
The defense? No.
How much comes out?
Let me let Ms. Holmes, I can ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about what happened.
Did she tell you what happened? Without? No, she didn't.
Just told she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I do.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Bradley, the prosecutor's office.
This prosecutor.
Yes, I do.
Thank you.
Man, I don't know who's more angry, the witness or the defense attorney on that one, but we're going to talk about it with our awesome guests on the other end. Take a break. Please stay with us.
We did get an update from the juror who was in the hospital this morning, and my understanding is she will be joining us. Everything was just, I guess, issue of dehydration or something along those lines, but I'm told she will be here. Can you hear me all right? All right. One thing, though, I need to bring to your attention is when we broke this morning, one of our jurors, as Gary was escorting the jurors out, he was approached, and one of the jurors had asked him a question. Gary, go ahead. You want to tell us exactly what was said?
She more or less asked me if she could ask me a question. I said, well, it depends. So the question was, she said, well, what's the status of the mistrial?
So now, I don't know what you want me to do about that, but that's the question that was posed.
That's what we need to have her record and find out how she would have any knowledge of that, because that was never stated in front of them.
I think it was. I think there was it was done on the record by Mr. Howard the other day. Is Mr. Howard here? No?
No, he's not.
Oh, I apologize. I thought we were all here.
He's coming right now, Joe.
Mr. Howard, I'm sorry.
Oh, no problem. I heard it all inside the media room. So, no apology necessary. Thank you. Apologize for not being present.
No, it's my fault. I thought Gary walked in, but what he was advising me and I to the attorneys was that there was a comment by one of the jurors. Did you hear that?
Yes.
So I don't know exactly what you want me to do. Who the juror was?
Miss Manuel.
Miss Manuel. So I guess one of the things that is, my recollection, and I could be wrong, is different than yours, Ms. Bradley. My recollection is that there was a motion for mistrial that was made out loud, and Mr. Howard came sidebar. But the jurors have been instructed not to read anything about the case. So I don't know if there's something in the newspaper about that. That's a different story, but I don't know what you want me to do, if anything. I bring it to your attention, any real interaction that Gary has with them, something that may seem inappropriate, we always bring it up and let you know.
And should I assume that for future reference, you'd rather I make those motions outside the presence of the jury?
Just come side.
Okay.
But that was my recollection. I thought you, at one point, I don't know which, there was two motions for mistrial. I don't know at which point, but I believe at least one point you stood up and said, I have a motion for mistrial.
No, actually, there was a question asked. I said objection, move for mistrial, and
No,
you called the
before.
sidebar and asked me to hold it until the end. And then at the end, after the jury left, Mr. Adelstein and I articulated motions for mistrial on an independent basis. And that's how it trended. That's how it went down.
But it was announced in open court, correct?
I said objection, move for mistrial. You called
That's
the
my
sidebar.
recollection.
I remember coming sidebar and there being that being said in sidebar. I don't recall it being said in open court.
I thought it was said in open court.
It's a fact that I said it.
So again, I don't know what you want me to do, if anything, and the jurors. Is that juror here, by the way?
She's in the reception area.
So anyway, I'll leave it to your discretion. It was announced in open court. There was a motion for mistrial. Gary obviously didn't answer the question. What did you respond, Gary?
I told her I didn't know anything about that. And then she asked me, weren't you there? I said, I don't remember that.
Anyway, that's where we're at. So you think it over. Let me know if there's any inquiry you want me to make. Madam?
Yeah, I think you need to, the state's position would be that she needs to be brought in. Your Honor needs to inquire if she's saying anything in the media or any coverage of that, because that was discussed online, is my understanding.
What do you think, counsel?
Well, to the extent that the court's inquiry of this jury is because of the state's faulty recollection that I didn't say move for mistrial in front of the jury, I know that not to be the case. I did say objection, move for mistrial. You then called a sidebar, and the only thing you said was, please reserve that to me.
That's my recollection.
Yeah, that's what
Again, is that what you're concerned about, or is it concerned about just because it was said that you think I ought to inquire?
Your Honor, I think that it's at defense's peril if we go forward, and if they're going to waive any inquiry of this witness, if she's been looking at any of the other items or anything online that defense brought to Your Honor's attention earlier. Because if they thought was laboring under the impression that there was some sort of cessation of trial and then started looking at media and news reports because they thought their jury service was over, that would be a problem.
Better to have more information than less, so we have no objection to that being the procedure that we deploy.
So you want me to bring her in, indicate to her that I was advised by our bailiff, Gary, that you asked him about a motion for mistrial and what had happened, and just ask her how is it that you're feel concerned about that or where did you hear about it? And just find out what information she's got and about it and where she heard it from. Is that the end of the inquiry?
I would ask that you inquire from her if she conveyed any of that to any of the other jurors.
Anything else?
Unless the court wants to say, unfortunately, I denied that.
So we're going to ask what she heard, where she acquired it from.
If she did any outside research afterwards.
And if she inquired or asked any of the other jurors concerning that topic.
Anything else that you want me to ask, counsel?
No.
Anything else?
Nothing, sir.
All right. Do me a favor.
You went to get him.
Okay. I don't like that
Just quick. Gary. Yeah.
Thank you. Ms. Manuel's coming in, counsel. Ms. Manuel's going to come in now.
Okay. Thank you.
Yours, X-ray?
Hey, Ms. Manuel, thanks for coming back in. Let the record reflect the approach of the defendant, his counsel, the assistant state attorneys, as well as one of our jurors, Ms. Manuel. Counsel, please be seated. Ms. Manuel, please be seated. Ms. Manuel, why I brought in is my bailiff indicated to me that when you weren't able to start this morning, that he was escorting the jurors out, and you approached him and asked him about what happened with the mistrial or something to this effect. Is that right? So that's a yes. All right. So I guess my concern is what you may have heard about this alleged mistrial and where you heard it from.
The last day I was here, and the defense attorney jumped up and said mistrial.
Okay. So that's where you heard it from?
Yes.
Anything other than that?
No.
Was there any other research that you may have done or looked at newspapers or any kind of article about the motion for mistrial, anything like that?
No.
Anything on the news, any news media
No.
about the mistrial? No. And last but not least, did you speak with any of the other jurors about the motion for mistrial?
No, when Gary came in and asked us this morning, did we have any issues, any questions? And I didn't want to ask him in front of everybody, so I waited till we got in the hall and I put him inside and asked him that. If he asked him, he had any concerns.
Okay. All right. Okay, that's what we're trying to clear up and find out. Because there's an admonition that I say every time we break, don't discuss the case, don't form any opinion about
No,
the
it was
case.
said in here.
That's what we're trying to find out.
Okay.
Thank you, ma'am. Appreciate it. Thank you. Let the record reflect the juror stepped out. Counsel remain on the defendant. Anything you wish to do regarding this issue with this manual, counsel?
No, sir.
So are we otherwise ready to proceed?
Yes.
Juror shows up, yes.
I think, are they all here?
As far as I know.
Okay, so see if they're all here. If they're all here, we'll start. Yeah, he did say we're short 2 or 3. 3. But they're here now? They're all here. All right, they're all here now. You all ready?
Go.
Okay, counsel, I'll bring you in. Is that all right?
Yes, sir.
All right, let's bring the jury in. Thanks, Tom.
I did.
Jury entering.
Steve, you see it? Let the record once again reflect the presence of the defendant. his counsel, the assistant state attorneys, as well as the ladies and gentlemen of the jury. Ladies and gentlemen, sorry for the late start. Hopefully everybody's all right. We appreciate your patience. We also appreciate the fact that you're all here, and we thank you. But we're ready to begin again. When we left off last week, the state was still on its case in chief. Madam, who's your next witness?
Susan Johnson of T-Mobile.
Susan Johnson, please. Good afternoon. Are you Susan Johnson?
Yes, sir.
Welcome.
Thank you.
What I'd like to do is raise your right hand for us.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Susan Johnson,
Please spell your first and last name for the court reporter.
SUSANJOHNSON.
Please have a seat.
Thank you.
Ms. Johnson, that microphone in front of you will adjust up or down, but not back and forth. Okay?
Thank you.
Are you ready to proceed, ma'am?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Ms. Johnson. How are you today?
Good, thank you.
Could you please introduce yourself to the ladies and gentlemen of the jury and tell them where you work?
Sure. My name is Susan Johnson, and I work for T-Mobile.
How long have you worked for T-Mobile?
A total of 26 years.
And what do you do for T-Mobile?
I am a manager within the emergency response unit.
Prior to working for T-Mobile, did you work for any other telecommunications companies?
Yes, I did.
And what were those?
AT&T Wireless.
And how long did you work for AT&T?
5 years.
How long in total have you worked in the telecommunications industry?
31 years.
So you indicated you were part of the manager of the emergency response?
Legal emergency response.
And what does that mean?
That means that we respond to subpoenas and other legal demands from various agencies across the United States.
And when you say a legal demand, what would you mean by that?
Subpoena or a court order, search warrant.
In terms of the records when you work with them, how often do you work with them?
Every day.
What do you do with the records?
So we're able to retrieve the information from our secure computer database and then send the response back to the agency that's requesting.
And I know this might sound silly, but what type of company is T-Mobile?
We're a wireless telephone carrier.
And is T-Mobile the parent company of any other wireless carriers?
We did acquire Sprint.
How long has T-Mobile been the parent company for Sprint?
April 1st, 2020 is when we acquired them.
In terms of the information that is kept by T-Mobile, do you keep phone call records?
Yes.
What would you call those?
Call detail records.
Do you keep information regarding the networks?
Yes.
Do you keep information regarding subscribers?
Yes.
What type of information is kept in a call detail record?
So call detail reports will show incoming and outgoing phone calls or text messages made or received by the cellular telephone.
Does T-Mobile keep that information as to when data is used?
Yes.
Will a data phone call or video call show up in call detail records?
No.
Does the information show for who is being called?
Yes, it will show the transaction of the outbound or inbound phone call on the call detail records.
Does T-Mobile keep the cell site information for the call that the outgoing non-T-Mobile subscriber?
No.
What's the purpose of collecting this information at T-Mobile?
Billing purposes.
Is there any consideration as to the health and optimization of the network?
So we keep what is known as timing advance records, which is solely for engineering purposes, so that they are able to check up on the network, yes.
When a phone call is made from a cellular device or handset, can you describe from the network perspective, what happens?
Sure. So what happens is the phone reaches out to the tower with the strongest signal, which is not necessarily the closest tower. So for example, we can have a tower on top of the building, or we can have one down the street. However, the one down the street might be the stronger signal and would pick up that call. At that point, it's transferred to our switch, and our switch is what records all the information that you will see on the call detail records. At that point, it's then transferred to a landline company, and it's the landline company that actually delivers the call.
So you mentioned true call data. What is that?
So true call data is for the network. It will show where the phone is connected to when it's not in use, as long as it's turned on.
Does Sprint also have a similar type of data?
Yes.
What is per call measurement data?
Correct.
Is that the same for true call with the Sprint analogy?
Correct. That's Sprint's term.
In terms of subscriber information, what types of subscriber information is kept?
So the subscriber information, we have two types. One would be a prepay, and then the other would be a monthly account.
So the prepay, what type of information could you have?
So prepay, a customer is not required to provide their information, but they could provide a name, address, and date of birth.
On the postpaid or the billed type, what type of information do you have?
So we would have the name, the address, date of birth, social security number, and we actually do a credit check on that individual.
In terms of the individual using the specific phones or handsets, can you testify to that?
No.
How many times have you testified in court before?
Over 1,000 times.
Were you, as the records custodian for T-Mobile, provided legal process, I'm going to go through them one by one, under reference tracking number for T-Mobile, 214-6318, for two phone numbers of 305-922-9533 and 954-376-9158?
Yes.
As the T-Mobile records custodian under tracking number 219-2645, where you provided records or requests and legal process for three phone numbers, 561-720-3210, 772-713-9807, and 954-376-9158.
Yes.
As the records custodian for T-Mobile under T-Mobile tracking ID 208-1851, where you submitted a request for phone number 954-248-9081.
Yes.
For T-Mobile tracking number 217-2715, for phone number 954-376-9158, where you provided a legal process to obtain the records for that issue?
Yes.
Were you also under tracking number 205-8127, asked to provide for legal process phone number records for 772-713-9807?
Yes.
Was Sprint at the time, now part of T-Mobile, under the phone numbers for 772-713-2341 and 954-371-7895 under Sprint tracking number 2018-221418, provided legal process and requested to provide records?
Yes.
Was Sprint under Sprint case number 2019-15821 asked to provide records with regards to phone number 225-529-5054?
Yes.
Prior to coming into court today, did you have the opportunity to review the records that were provided?
Yes, I did.
Are these records made at or about the time they are created by a person with knowledge?
Yes.
Are they kept in the regular course of business of Sprint and T-Mobile?
Yes, they are.
Okay. Is it in the regular practice to keep such records?
Yes.
You're at this time approaching with what's been labeled as states 000 for identification purposes and previously shown to defense. Ms. Johnson, do you recognize this USB?
Yes, I do.
How do you recognize it?
My initials and today's date are on the USB.
And does those USB fairly and accurately represent the records that were provided by T-Mobile in response to the tracking numbers that we just discussed, as well as to Sprint and the tracking numbers and case numbers they just provided?
Yes.
Here, at this time, the state would offer states 000 as state 63.
Any objection?
Yes, Judge. Objection. Relevance.
Sure, why don't you come sidebar here? Thank you. So, objection overruled, it will be admitted. What's the next number?
63.
63 and evidence.
Permission to publish?
You may.
I'm sorry, the objection.
63.
So I'm going to start with the Sprint records. What are we looking at in this particular file, 2018-221418-6155597?
This would be the subscriber information.
And in terms of looking at this particular one, I'm going to zoom in. What is the billing name for this?
Chris Thomas.
And going to the second one, what is the billing name on this one?
The first name is Dontavius. Last name is Withers, Withers.
At the top of this screen capture, there's a BAN number. Do you know what that means?
Yes.
What is that?
That would be the account number.
Does that correlate with the other data that's been provided?
Yes.
Going to now the same Word document file name. What are we looking at in this Sprint document?
This is also subscriber information.
So you had mentioned that billing account number, that BAN number?
Correct.
If you can touch the screen in front of you, you can write on it and it will show up on the screen for the jurors. So if you could point out where the billing account number is here. Okay. And then what is the phone number that was being used by this account, or the subject number?
772-713-2341.
And is this again for that Chris Thomas billing account?
Yes.
Okay. Scrolling down to the next billing account number. Is this the other account that we just looked at the subscriber information on for Dontavius Withers?
Yes.
And what is the phone number that's associated with this particular account?
954-371-7895.
Going on to 2019-158-210-6566861. For the phone number in question on this particular record, is that labeled right here?
Yes.
And what phone number is that?
225-529-5054.
And looking at the Microsoft Excel viewer, can you explain to the ladies and gentlemen of the jury what we're looking at here?
These are the call detail records with cell site information for Sprint.
Going over to the T-Mobile records. Just for demonstrative and illustrative purposes, when you are looking, this particular one called Timing Advance LTE and UMTS _ TN 772-713-9807. Then it has another underscore IMSI. What is an IMSI?
That stands for International Mobile Subscriber Identity Number, which is the number that's associated with the SIM card found in the back of the phone.
And the first, the 772-713-9807. What is that?
That would be the phone number.
Are all of these records provided by T-Mobile?
Yes.
In terms of completion codes, is that something that is reflected in these records?
Yes.
What is a completed successfully completion code?
So that means that the call went through the network successfully.
What is an abnormal completion?
An abnormal completion means the call did not go through. Perhaps the user hung up prior to the call connecting, or a dropped call.
Okay. In terms of what time frame are all of these records kept in?
We keep them in UTC time, which is Coordinated Universal Time. So depending on what time of the year it is, you would have to subtract either 4 or 5 hours from the time that you see reflected in order to arrive at East Coast time.
On October 26th of 2018, how many hours did you have to subtract?
It would be -4.
The cell site locations indicate latitude and longitude of the cell site. Is that now there's also a physical address. Is the physical address always the same as the latitude and longitude?
No.
What could the physical address sometimes show?
So that's what we refer to as an administrative address. So we use that for 911 purposes. To get the exact location of the cell tower, you would take the two coordinates, the latitude and longitude, plot it into a mapping program such as Google Earth, and that will give you the exact location.
There's nothing further, please witness, Your Honor.
Counsel, is there any cross-examination?
1 second, John. Good afternoon, ma'am.
Good afternoon.
How are you?
Good, thank you.
So, the technology that you just described for identifying locations, how is that verified by T-Mobile itself?
That you would have to ask an engineer for.
So you don't know how that's done?
How it's verified?
Yeah.
As to what tower connected to? Is that what you're asking?
Yes.
So it's done with a radio frequency, is how the towers work. It's a signal.
Okay, so but you were telling us earlier that the phone does not necessarily connect to the nearest tower.
Correct.
It connects to the tower with the strongest signal.
Correct.
So how is it that you know to approximate, how do you know how far the phone is from the active tower?
I don't.
Is there no way to tell that?
No. Not through me.
Not through you?
Correct.
And how do you know if the tower that the phone connected to is the closest tower or the one with the stronger signal?
That would not be a question for me. You would have to ask an engineer.
How would you know whether or not a phone defaults to a stronger spectrum? If you have a tower with a strong signal and another tower with a not so strong signal, or a signal that's not as strong as the other. You with me so far?
Yes.
How would you know at what point the signal disparity is strong enough for it to default to the one that's further away as opposed to the one that's closer?
Again, that's a question for an engineer, not for me.
So you have no way of helping us understand any of this information that you just described?
Correct.
You just collect it when you're subpoenaed and you provide it.
Correct.
And you're not familiar with the technology at all?
Not the questions that you're asking, correct.
One.
Sure.
Is it correct that the data location information, the purpose that you worked with Sprint and with T-Mobile at some point?
I'm a T-Mobile employee.
And you were a Sprint employee at some point?
No, sir.
You were somewhere else? No?
AT&T.
AT&T.
Correct.
The purpose that AT&T, and in this case now T-Mobile, collects this data location information is for billing.
Correct.
That's its only purpose.
And network. Engineers collect to optimize the network.
Okay. It's not used for identifying the locations of customers' phones beyond the purpose of just billing.
Correct.
Okay. Thank you.
Sure.
Thank you. Is there any redirect?
Yes, Your Honor. Ms. Johnson, counsel asked you, how do you know how something didn't happen? Is that a fair question?
Objection. Sustain. Rephrase.
With regards to these records, are they accurate?
Objection. What's the objection?
Lack of foundation, Chief.
Watch him sober. The objection was sustained. Rephrase.
So, Ms. Johnson, with regards to the records, does the T-Mobile keep any record of something that doesn't happen?
No.
What is contained in the records that have been provided?
Calls and text messages that have happened.
Is this from the network's perspective?
Yes.
Nothing further, Your Honor.
Is this witness excused?
Yes, Your Honor.
Thank you. You may step down. You're excused.
Thank you, Judge.
ma'am. Who is your next witness?
Jonathan Zeller.
Jonathan Zeller, please. Good afternoon.
Good afternoon, sir.
Are you Jonathan Zeller?
I am, sir.
Welcome. Come on up here, sir. After our witness stand, when you get there, you put your things down, you raise your right hand, be sworn.
Do you solemnly swear or affirm the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Jonathan Zeller. This is Z-E-L-L-E.
Spell your first name as well, sir.
Jonathan.
Thank you.
Under that microphone, will just up or down, but not back up.
Yes, sir.
Counsel, if you're ready, you may proceed.
Good afternoon.
I'm sorry. Can we approach very
Thank you. Anything else, Council?
No, Judge.
Bradley, if you're ready, you may proceed.
Yes. Okay. Detective, how are you today?
I'm good, thank you.
Good. Where do you work?
I work with the Miramar Police Department
How long have you worked for the Miramar Police Department?
for 23 years.
What do you do for the Miramar Police Department?
I'm a detective in the homicide unit
And how long have you been in the homicide unit?
since 2009.
Prior to going into the homicide unit, what other hats have you worn for the Miramar Police Department?
Several. One in particular is the digital forensic examiner.
Okay. What is a digital forensic examiner?
So what I do is we'll stick with the cell phones or cellular phones or devices of that nature. I do the extraction and the analysis for it.
And when you're doing an extraction, can you explain to the ladies and gentlemen of the jury what types of software or tools you use to do an extraction on a cellular telephone?
Okay, so what we use is a software and hardware from a company called Celebrate. And this is specific for conducting extractions of cellular devices.
And approximately how many different trainings have you taken in the use of Celebrate systems?
I've taken a few. Each of them consisted of 40 hours of class training and exercises, and obviously the exam as well.
What about you taking training with the past team of the FBI?
I have.
Have you taken, you said you also do analysis of the cellular forensics or digital forensics. What do you mean by that?
So, depending on what type of case it is, I will actually do the extraction and I'll also do the examination of it, the analysis for it, and go through it and look for items that potentially could be considered evidence.
And in terms of to do the analysis part, what information do you need?
I need to know what the case.
In this case that we're here on today, Miramar Police Department Investigation 18-10-6269, were you the lead detective?
I was not.
What was your role in this case?
Doing the analysis or the extraction of the device.
Did you do any analysis of the device?
I did not.
In terms of the extraction of the device, were you provided an iPhone with the phone number attached to it of 772-713-9807?
Yes, yes.
Prior to coming into court today, did you have the opportunity to review the digital copy of that extraction?
I did.
I'm showing defense counsel. Leslie Marcus states triple P for identification purposes, showing the witness. Detective Zeller, do you recognize this thumb drive?
I did.
How do you recognize this?
My initials and my ID number on the jump drive.
What is that thumb drive contain?
This is the generated report of the generated report of the cellular device that was extracted.
And is that in the same or substantially the same condition as when you performed that extraction?
Yes.
Here at this time, the state would request to move states triple P in as state 64.
Objection. Yes, sir. Name.
Sure. Objection to overrule, let it be admitted.
4.
What's the next number?
64.
Thank you.
So Detective Zeller, can you explain to the ladies and gentlemen of the jury what an extraction does?
So the extractions consists or is done in order to obtain whatever's on that phone and to put it in a legible or readable report that's easy for someone to look at. And some of the things that you would get also by doing that, you may get items that have been deleted, so on and so forth. And that's why we do those types of extractions.
Nothing further from this witness, Your Honor?
Any cross-examination?
Yes, just briefly. How are you, sir?
Good news, sir.
You said you did a phone dump here of a particular unit that the state referred to.
That's correct.
And you have not analyzed it?
No.
You don't know if there's any relevant evidence on it at all?
That's correct.
Okay. And you don't know who it belongs to, do you?
I do know who it belongs to. Obviously, I'm in the office. I know who it belongs to, but as far as the contents of it, I don't know.
You don't know. You don't know who uses it.
I do not.
You don't know who it's registered to.
I do not.
Okay. 1 second. And as to any contents of that phone, you don't know if they're texts, who authored them.
Once again, I don't know the contents of it.
Okay. Okay, Your Honor, we'd like to come sidebar if you would. Sure.
Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant, Mr. Daniels. Defendant, you need a restroom break? You need a restroom break? Nope. All right. Thank you. And what did you all want to share with the cases?
Okay, Your Honor, and I can hand them up as I discussed, but I don't think I left one with the court. The one that I referred to first is RLG versus State, 322 Southern 3rd, 721, a third DCA case. This is an app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church, and every time she goes to church and comes back, she's taken 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication hurdle to, as a foundation, establish that that technology is a reliable one. Because she is going to now, and she's introducing the matter for the truth, told the jury in opening, Mr. Demons, who she believes had the phone but has no proof of that to begin with, walks 70 steps. Says who? Says an app. What app? The one in his phone. Is it reliable? We don't know. Why? Because she has not established the reliability of the technology as a predicate to the admission of the data. So that is our number one foundation argument.
A case that you want me to read?
Yes, sir.
I'm happy to take a look at it.
Thank you.
Yes, ma'am.
Here, I first start with citing back to State versus Maximit, which is a 1967 case, which was the earliest time in which I could find a pedometer being mentioned. And at that point, it's important to note this is a well-established technology that's been in use for hundreds of years, initially done by train conductors to measure out distances. It's also allowed under the Florida statutes and used to be used to measure out distances for determination of 1,000 feet from a place of worship, a school, or anything else, for measuring distances for enhancement on drug penalties. So I'd start by handing that one to Your Honor. Then I also have State v. Birch, which is a Wisconsin case in which similar information was admissible and used in a homicide case. Then also the issue of cell phone dumps, and that's at 398 Wisconsin 2nd 1. And then even more recently, this was a federal case, United States versus Rigo, R-I-E-G-O. I just have a Westlaw site because it's 2022, it is not yet. This is 2022 Westlaw 175-46714. And again, those discuss all of the location information and the activity and Apple Health data that was admitted in those cases. And I'll be happy to email copies of those to defense counsel now.
Thank you. All right, we're in recess. I'll read them all.
Your Honor, may I also just direct your attention to a few articles, one of which indicates the highlight here. The reliability of the registered distances, however, depends on a number of factors, including walking speed and walking style of the subject, and can deviate up to 30 to 40% from the true value. That's one of the several articles here. And what I will do is I will compile the articles and send them all back for your review while you're considering the issue, if you don't mind.
Sure. And the state would also submit in terms of law review articles, including a 2016 wearable devices as admissible evidence. Technology is killing our opportunity to lie. The 2019, the iPhone health app from a forensic perspective can steps and distances registered during walking and running being used as digital evidence. And I would direct our attention to the Supreme Court of Alabama. That was Jeffrey West. The individual in that case was convicted as well based on some of the Fitbit data.
Yeah. And may I just ask if the state is making the representation that all the cases she's citing to do not require that a witness establish the reliability of the technology? It's just put in?
It has been admitted, and I have some of the, send everything that I'm giving to His Honor a copy to you as well.
Okay.
Thank you. We're in recess.
Thank you, Judge.
When a juror is pulled out of the jury room, sat down, and being asked questions. Now, let's remember how this happened. This was because she asked a question of the prosecutor, and there is an admonition that you shouldn't speak to the parties. And the prosecutor, if I heard this right at the time, indicated that he didn't know anything about it, about the mistrial motion. Now the judge comes out, it's clean. She heard about the mistrial motion because it was stated in court. And that's what she was asking about. She didn't hear from an outside influence. But I got to tell you, if I were the prosecutor in this case, I'd be concerned that a juror got pulled out. The juror clearly knows I'm the one who gave the information to the court. And I told the juror that I didn't know anything about that, which they shouldn't have said in the first place. The juror may not all be too happy with the prosecutor at this point. Thoughts?
I agree. They might think, well, hey, you know, everything I'm saying, even this little unimportant thing is going to get back to the judge. But on the other hand, it may also strengthen the credibility of the prosecutor, right? Because the juror's not going to say, hey, you know what, this prosecutor plays by the rules, is above board, and doesn't want there to be any bias, any prejudice, anything like that. So it cuts both ways, to be honest.
Yeah, I don't know. I guess let me go to the FBI, CIA, specialist over here. I just think that could be tried. It's a fair point. But he also said he didn't know anything about that when she clearly knows it was said inside the courtroom. So I'm not sure if that really is going to bolster his credibility in her mind. And nevertheless, she got kind of called out. It's just sloppy. It's just something that the prosecutor shouldn't even, I'd be thinking about it, and I don't want to be thinking about stuff. What do you think?
Well, I see where Miguel is coming from for sure, because I do think that it does ultimately cut both ways. But Bob, I really appreciate you saying what you did about how it really is about winning the hearts and minds of the jury. I've said that on here before, and sometimes to the chagrin of other people, but that's the bottom line. And that's what ultimately matters in this. And I do think that a juror who's being called out by the judge, and he's not doing it in an inappropriate way, but that is an incredibly intimidating situation in an already precarious situation, quite frankly, that they're in. This is somewhat of a charged courtroom. And so I really don't think that ultimately this is going to bode well for the prosecution in this case. However, I don't know that it's going to sort of be the ultimate nail in their proverbial coffin, if you will.
Yeah, listen, there's a whole Olympic-sized swimming pool of data that goes into winning a case. I guess I was the kind of person that didn't even want to see a drop come out of that pool. So you're right. It probably has no great effect, but in the end analysis, just another unforced error. On a note, we're going to take a break. We'll be back on the other end. Please stay with us. talking about the law of crime, nobody's doing as good as us in covering these trials because we have two great guests. And guys, we only got a couple of minutes left, so I'm going to turn the show over to you. We'll start with Tracy. Thoughts about the whole case, where we are, where we've been, and where do you think we're going?
I really think motive. That's what I keep saying about this case. That's something that really hasn't been discussed. It's something that, quite frankly, is missing. They have a lot of digital data, a lot of forensic data, and quite frankly, a lot of biological evidence as well. However, the motive seems to be missing. And I think the prosecution really needs to be focusing on that. I know you don't necessarily need that to convict, but again, I think it will bode a long way with jurors if they want to be successful in obtaining a conviction here.
Yeah, and Miguel, not that what Tracy said is nails on a chalkboard to me, because it's not. She's right, 1,000%. Motive is not an element of an offense. That does not have to be proved. But like she's saying, its motive is still so important in a case like this. So, and so I don't agree with you. I shouldn't say it's nails on a chalkboard. It's nails when people say it doesn't need to be proven, and then they end. They don't talk about how important it is she did. What are your thoughts?
I totally agree with Tracy. You don't have to prove the motive or show a motive, but here's the thing: the jurors, they're people just like everybody else, and they want to know why, right? Why, if these two deceased were in the same group, in the same musical group as the defendant, why would he shoot them, right? Was it for gangs? Was it for money, profits? What was going on? Business disputes? So I think it's super important that they get to that why, because everybody wants to know why. Why did it happen?
Well, Tracy, let me go back to you. Why did it happen? And what really shocks me about this, let's keep in mind, this is a death penalty case. And even if they get a capital murder conviction, it goes into the sentencing phase, the penalty phase. And one of the aggravating factors is that this was a gang-related shooting. I don't know, where's the beef? I don't know where the evidence is, whatever. Maybe it's that, maybe it's something else. If we don't have motive in a case like this, how do they get to that significant aggravating factor to justify the death penalty? And if they can't, why is this a death penalty case?
I think you hit the nail on the head. And I know it's like nails on a chalkboard. And again, you don't have to have this to convict someone. I get it. But again, you've got these aggravating factors that they've brought into play here. And if they can't prove that why, particularly in the gang offense, then they've essentially overcharged him, over-sentenced him, if you will. And that will be problematic and can result in a not guilty verdict.
Yeah, well, let me ask you, Miguel, and we're going to give you the last couple of seconds here. This now no longer has to be proven by 12 people. The law has changed, and now only 8 people have to vote with the death penalty. Is it possible we're going to start getting more death penalty verdicts that we previously would not have gotten on weaker evidence because we've lowered the standard? And if so, what do you think our appellate courts will do with that, including the U.S. Supreme Court? I've got about 45 seconds.
I think it's going to keep the appellate courts very busy. The fact that it's lowered down to 8 means that you're right, there's going to be people that are going to be convicted on weaker evidence, and that's problematic, right? Because, I mean, we're talking about the ultimate punishment, right? And so I definitely think that it's probably going to be something that's going to go to the Supreme Court. I really think that this is going to be an issue that's going to be revisited. 8-4 seems, it's
right.
Troublesome.
Yeah, well, this is exactly the reason. If you keep lowering the standard down, I guess eventually, even though the quality of the evidence may be weak, you're eventually going to get somebody to say vote for the death penalty. Maybe we should go down to 2 or 1. I don't know. Guys, thanks very much. That's it for us. Don't go anywhere. In capable hands, Imran Ansari is next. Have a great rest of the week.
Good afternoon and welcome to the Law and Crime Network. I'm Imran Ansari. Our trial coverage takes us to Broward County, Florida for the trial of rapper Jamel Demens, better known as his stage name, YNW Melly. The South Florida rapper is charged with 2 counts of first-degree murder for the deaths of his friend Christopher Thomas Jr. and Anthony Williams. Thomas, who was known as YNW Juvie, and Williams, who was known as YNW Sack Chaser, were all part of the YNW collective, along with co-defendant Cortland Henry, who will be tried separately. Court was off to a late start today, only calling their first witness of the day this afternoon, before court went on a brief recess, but there were some discussions outside the presence of the jury. Let's head into that courtroom for more now.
An app on a phone that purports to account for the number of steps that someone takes. In addition to these cases, I have several articles. There have been lawsuits about the accuracy of the data that is compiled by this type of app, because what it's doing is it's assessing reverberations. So, for example, one of the experts we spoke to indicated that his wife plays the piano at church. And every time she goes to church and comes back, she's taken 20,000 steps because she's doing like that. So the fact is that whether or not this information is reliable is yet to be determined. Whether or not the technology has advanced to the point of being reliable is yet to be determined. But this court cannot admit it until the state first meets its burden of establishing the reliability of the data that is compiled or purportedly developed as a result of the technology. Because we don't know if that technology is accurate. Whether it is or not, I'm not taking a position at this time. I know I've read a lot of articles that indicate that it's not. However, the state has the burden as an authentication, or at least the expert, not even the method, and so we raised the issue. We gave notice of an expert. The state took issue with it, raised the Daubert objection to it at that time. This is not a situation where the state presents us an expert. And we can't anticipate that the state is going to try to admit evidence before they admit it without the necessary predicate. And those cases actually speak to the objection being made at the time that it is sought to be introduced. As a matter of fact, some of those cases rejected the appeal because even though the predicate wasn't made, the objection wasn't made at the time the evidence was sought to be introduced. The state sought to introduce evidence without laying a foundation. Our objection is objection foundation. We're not making a Daubert objection to an expert who's testifying. He doesn't purport to be an expert. This is not a Daubert situation, Judge. This is a lack of foundation situation. And the fact that that foundation needs to be presented by somebody with expertise and knowledge doesn't make it a Daubert question. It's a foundation question. And before the state, I think those cases are clear. If the state is planning to put evidence in that relies upon a technology, they first have to establish the reliability of that technology. And that's the basis of our objection with respect to this step data. We've also made a relevancy objection to the fact that there is a whole set that haven't even looked at it. How do we know that the information in there is relevant? How do we know that the information that has been introduced is not more prejudicial than probative, even if relevant, on a 404B? How do we know that it's not doesn't contain 404B evidence that's inadmissible? The state has to establish the relevance of the information they seek to put in. They can't just put in everything from a phone and pick through what they think, and then the jury has in its possession a host of majority information that's not relevant to the proceeding, which is prejudicial. So that is the other basis for our objection. Also, a lot of the information contained there is hearsay. They said, well, it's his phone, so there's no hearsay objection. There are texts between people. There's also evidence that we have that establishes that that phone was being used. The phone comes up as the name Sack Chaser Howard. Sack Chaser is the nickname of one of the decedents. That phone is used interchangeably so much that when you dial with it, it comes up with one of the decedents' name as the identifier. It's in the name of Jamie King, not Jamel Demons. It was retrieved from Jameson Francois, not Jamel Demons. So it's neither in his name, it wasn't retrieved from him, and it comes up with an ID. It was being used after the defendant was arrested. We have information here that indicates that, definitively. It shows the phone being used to call. It shows the same step data from that very unit after he is incarcerated. So it's obvious that it's being used by several other people. So we can't even say that it's his phone and the information there is therefore all relevant, all information on it is non-hearsay because it's statements of the defendant. Not only is it being used by others to text, to call, being carried by others, it's in somebody else's name, retrieved from someone else, and this witness has not analyzed a single letter, all the information they're seeking to put in. So there is a ton of irrelevant evidence that is being introduced, and a lot of it is going to be prejudicial, 404B and 403 evidence, and that's why we objected before. I didn't wait until after, because one of the points that the court made is you already let it in. We objected before, Judge, and you told us, overruled, let it in. It's still a problem right now, and we're trying to stem the damage before it goes too far. And we think that the issue has to be addressed before this information is used and it goes forward, both on the foundation issue, on the technology issue, authentication issue, relevancy issue, 403, 404B issue.
Thank you. The relevancy issue is relatively low, counsel. My understanding, where's the phone located at, counsel?
The phone itself?
Yeah.
That will be introduced through the...
No, where was the phone located?
The phone was located, it was taken from the defendant's manager on February of 2019. The defendant was providing the passcode and information via jail calls to his manager to use it on that. And the phone also authenticates itself in terms of every single photo that is on that, whether it be a selfie, a screenshot of a FaceTime conversation, or anything of that, goes back to this defendant.
And they have to establish it before they put it in, not after the fact, on this notion that they possess information that makes it relevant. If they do, present it, and then it's relevant at that time. We have, Your Honor, indications of this cell phone and this Instagram account that the state has introduced. The Instagram account is being used to post pictures days after his arrest, up to and including pictures of this very trial last week. This Instagram account is being used and accessible to a number of people. This notion that, oh, it's his account, he's an artist. It's a public account that several people have access to.
I'm sure you're going to be able to ask those type of questions, counsel. My thought is this, counsel. It's not fair to basically give me an inch worth of things to read, cases to read, articles to read, saying it's how it's not, the methodology is and basically a Daubert issue on it. It's not clear. It's not been established. All those types of things that should have been done pre-trial. I haven't seen what's on the account. I don't disagree with that. Counsel's telling me it's relevant because of X, Y, and Z there. You're saying it's not, but I don't know what is the 403 analysis, what's more prejudicial than probative. I haven't seen anything about that. I don't know what it is. I haven't seen it. You haven't made me aware of it. You're just saying it's something more prejudicial than probative. If it is, I'm more than happy to go through one at a time with you and find out. But as far as who used the phone, what was it being done, counsel's saying it's relevant to establish his phone. So I've made my ruling. You've made your objection. So everybody knows where they stand on it. All right, so it's admitted.
Okay.
All right.
Thank you.
All right, bring the jury back in.
Just for process, cross? Or do you have additional questions? Yes.
I don't think he has any relevant information. He said it.
So you're finished?
Bring jury.
I may ask a few.
Jury entering.
Ladies and gentlemen, thank you. After the delay, please be seated. Let the record once again reflect the presence of the defendant, his counsel, the assistant state attorneys. Ladies and gentlemen of the jury, all witnesses remain to understand. So you have questions, counsel?
Yes, I have a few more, Your Honor. Thank you. You did, sir, 2 data dumps from the device in question?
I did 2 or 1?
You did 2 of them, did you not?
I did on this device, I did 1 extraction.
You only did it once?
If I recall.
Did you have the data verified by any third party for completeness of the download?
No.
And you made that decision, was it your decision whether or not to do that kind of verification?
Yes.
Okay, and you elected not to?
Correct, I elected not to.
Did you have an engineer review any of the data that you retrieved?
No.
And have you validated that the Cellbrite extracts in the data that you did were in fact complete?
The extraction is the extraction, and that's what I got out of it. That's what the machine gave me, yes.
Okay, and how did you verify that the machine gave you a complete download?
I don't understand when you say a complete download.
You said you don't understand what I mean?
No, we can elaborate.
How did you verify that the machine, the Cellbrite software that you used, downloaded the contents of the phone in its entirety? How did you go about verifying that?
That is not something that I can verify. That is whatever the data that comes from that phone and appears on the software. That's what I have. That's what I can deal with.
Okay, so you can't verify?
I cannot.
Is there a process of maybe testing, is there another, first of all, software that you can use to download the information?
Sure, there's other software.
And you only use the Cellbrite?
Correct.
And if you use another software and compare the downloads, that would be one way for you to test it, whether or not the download was complete, right?
In theory, I guess so, yes.
In actuality.
All right, I'll stick with that.
Okay, so when you say there's no way to do it, it is what it is, what you're saying is there is a way to do it, and you didn't do it.
download, but it's not true. That's not correct.
Oh, so you did test it on another software?
No, I did not, but this is the only software that I had available to me.
Okay, so it's not that you had another software available to you that could help to verify the completeness and accuracy of your results. It's that you can do it, but you didn't have that software available to you.
Well, correct, I did not do it, no.
Do you know anything about the testing of the technology of Celebrite as to its efficiency and operability?
No, I don't. I'm not an engineer for them.
So you, pardon me?
I'm not an engineer for them.
Okay, so it would take an engineer to do that?
Or somebody from that company, not me.
Okay, so it's like any kind of software. If you have the software and it doesn't work in totality or it doesn't work completely, you're stuck with the answers.
I'm not understanding what you're trying to get at, but can you rephrase it one more time? I appreciate that.
If that Celebrite did not give you a complete and accurate download, you would have no way of knowing it.
That is correct.
Okay, because you didn't have comparable software or similar software to test the results against.
Correct.
Okay, so you're just trusting in the faith. You're just having faith that the Celebrite.
Sustained.
You are relying upon the accuracy and completeness of the Celebrite technology, right?
That's correct.
Even though you don't know anything about whether or not it works properly.
Correct.
Okay. Have you ever done a data dump from a phone more than once? Any phone?
Yes.
On Celebrite?
Yes.
And was it a phone that left your possession and then you regained possession of it?
When you're saying left my possession, I'm sorry.
In other words, it left the custody, strike that. In the instances when you have downloaded information from a phone on using Celebrite more than once, I presume you did it for a reason.
So one of the reasons why I probably would do it is maybe a software update from Celebrite.
Okay, that's one of the reasons. What else? What are the other reasons you might do it?
That's the only reason that I would use it.
Okay. Can I have one more, John?
Yes.
So it is your testimony, sir, that you didn't do an extraction from this phone in June? What year? And then another at a later date?
I don't recall.
At an earlier date in April?
I don't recall.
Well, you have any information there before you? Any of your reports that would indicate that?
I have one that was completed on February 28th. of
February
2019, I think it is.
Okay. Nothing further. Thank you.
Councilor, is there a redirect?
Briefly, Your Honor. Detective Zeller, counsel asked you whether or not Celebrite is accurate.
Correct.
In your training and experience, can you speak on that particular subject?
Objection?
What's the objection?
This witness has already testified that he can't speak.
Sustained.
So Detective Zeller, in terms of you've used Celebrite numerous times.
That's correct.
Approximately how many?
Hundreds.
Have you found any instances in which Celebrite added data to a forensic download or dump that wasn't on the phone itself?
I'm sorry.
Objection?
What's the objection?
You would have no way of knowing that.
Overruled.
Can you ask it one more time?
Have you ever had an instance in which Celebrate has added data to the forensic extraction or data dump that was not on the phone itself?
That was not on the phone. Not that I'm aware of.
In terms of the way to physically review, how would you do that on a cell phone and compare it against a Celebrate extraction?
Well, there's a couple things I could do. I could look at the different artifacts that are extracted, meaning, so I would look maybe at a particular phone call was made at a certain time and date, or a certain picture that was there at a certain time and date, or a video, or so on and so forth, whatever that's there. That's one way of doing it, yes.
So I want to make sure I'm clear. You're saying you would look at outside evidence from the phone and see if it agrees?
Correct, yes.
In terms of the information and the data that's put out there, what is the purpose of taking it off the phone?
Well, you also don't want to use the original and just pretty much making a copy of the phone so that you don't ruin anything, delete anything, or compromise the device, or anything of that nature. So you work off that copy.
In terms of when the phone is brought to you, are there steps that are taken to make sure that there's no outside or internet or network access with the phone?
Yeah, so usually the phones are put in what's called airplane mode, where you disable all cellular connections.
And in terms of the type of extraction that was done in this case, what type of extraction was done?
This is called an advanced logical extraction. So,
what does that mean?
So there's different forms of extraction. The advanced logical pretty much gets, for the most part, I'm going to use the word everything on there. When I say everything, meaning the context, the pictures, the videos, the communications, any sort of communications that are on there, deleted items, specifically deleted items.
Okay. And in terms of to get the advanced logical extraction, what information do you need as an examiner?
Meaning, I'm sorry.
Do you need the passcode to the phone?
Yes, you do need the password, correct, yes.
Nothing further now.
This witness excused?
Yes, sir.
Thank you. You may step down. You're excused.
Thank you, sir.
Thank you. For your next witness, please.
Brendan Collins.
Thank you. Are you Brendan Collins?
Yes, sir.
Welcome. This is our witness stand. Can you go over here, please? When you get there, just remain standing for a bit. Raise your right hand and be sworn.
You solemnly swear or affirm the testimony that you give in this case shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your full legal name for the record.
Brendan Collins.
Please spell your first and last name for the court record.
My first name is spelled B-R-E-N-D-A-N. My last name is spelled C-O-L-L-I-N-S.
Thank you. Please be seated. Mr. Collins, that microphone in front of you, adjust up or down. It doesn't move back and forth.
Thank you, sir.
You ready?
Yes, sir.
Counsel, you may.
Thank you. Good afternoon, Mr. Collins. How are you?
Good afternoon, I'm doing well.
Where are you employed?
I'm an FBI agent, so I'm employed by the Federal Bureau of Investigation, and my full job title is Supervisory Special Agent.
And how long have you held that position?
This current position, about 18 months. I've been employed by the FBI since 2012.
And as far as education, what types of degrees do you hold?
I have a bachelor's.
And is it in a specific area?
I was a history major in college.
Were you employed anywhere else prior to working for the FBI?
By the Army.
And how long were you employed by the Army?
About 6.5 years. I had a couple different jobs.
Okay. going back to where you're working now, the Federal Bureau of Investigation, what are your responsibilities as an FBI agent?
Well, agents do all sorts of different things. Generally, agents are all investigators, and in the FBI, we investigate a myriad of crimes, from violent crimes, economic crimes. We also have national security mandates. Me specifically right now, I'm the supervisor of a squad that focuses on transnational organized crime.
So do you also have an ancillary assignment?
Not right now, I used to.
Would you explain to the ladies and gentlemen of the jury what is the CAST team for the FBI?
Sure. So CAST, for the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, or check your email, post something on social media, that's to connect to a cellular network or through the internet. When you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on your T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions.
So what's the purpose of historical cell site analysis?
To help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. That will say that it'll look at the initial records, like a call detail record, for instance, will sort of look like a billing statement that you might get from a phone company. Will say, this date and time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to when it made that call. So you need that record of the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the earth. You put those two things together into some sort of mapping software and it plots it, and then it will give you a general area of where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person was in a specific area?
No.
Why not?
Because the records I have are just about devices.
Okay. So there are limitations to your testimony.
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAST as
Yes.
well? What is that?
PUD CAST certified is pretty extensive. There's several stages that the certification process is broken into. The first, so I started my initial training in 2017. The first phase of training is the CAST basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at the basic level.
Do you use the CAST work in your day-to-day cases? Before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAST team?
No, I don't want to interrupt, but there's a lot more training than just that 2 day thing. Is that okay?
Well, let's start with, to do that first 2 day training.
Yeah, so the first
is that mandatory?
Yes.
For the FBI?
Yeah.
To go on past that, is that something you have to apply for?
Yes. Yeah.
Okay, and to explain after that first initial training, what happens? What's the next level of training you complete?
So the next course is called the advanced course, and it's a week-long course. And that's just a more in-depth dive into each of the networks. So specifically, what are the uniquenesses of, say, Verizon or T-Mobile, AT&T, Sprint, when it was a standalone provider? What do their records look like? What are the uniquenesses of the way their network's designed, et cetera? After the advanced course, then we have a sort of test. It's like a week long. When I went through, it was a mix of part in the classroom and part in the field, where it's all scenario based. So you, for instance, you'd be like a kidnapping scenario. Like, hey, this child was abducted. Your job as the asset going through to try and use the records to develop a search location and say, hey, I think that we need to go here to try and recover the child. You do a portion in the classroom, you do a portion in the real world where they have test runs set up at different locations, and you validate the results right there. So you either find the person or you wouldn't. And at the end, you either pass or fail. So I passed, and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have a week that's basically a semester's worth of material condensed into a week. It's put on by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel. We talk about these are the types of records that we keep in our specific record, our specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it. We go to infrastructure, so I've been at the Sprint's Network Operations Center, where they oversee the management of the whole the network across the country, etc. And then at the end of that, there's a test, and you either pass and are certified, or you don't.
Okay, so Special Agent Collins, are you certified in cast analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes. So to keep your CAS certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FBI?
No.
What other agencies and I guess companies do the training for you?
Yes, we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously the different telecommunications companies are critical. So we have them come to the recertification conference every year. We've had a range of other people. We've had Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles for vehicle telematics, and anybody that's sort of involved in that ecosystem.
Okay, so you mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works, training on that?
For what?
In terms of being a CAST certification?
After recertification?
Yes.
Yes.
Okay. How long have you been specializing in call detail records analysis?
So call detail record analysis is really like the bread and butter of what CAS does. So since I started the training process in 2017, that's it's when I first really got exposed to working call detail records or CDRs.
Okay, and approximately how many times have you done this type of analysis?
I've done more than 130 cases, and that have included more than approximately 300 sets of records.
When you say a set of records,
Yeah.
what does that mean?
Like a call detail record or an engineering report, some sort of data report, some sort of report from a phone company about a particular device.
And in terms of the types of cases that you've worked, what have they been?
Violent crimes like homicides or shootings, white-collar crimes, and then public corruption, crimes against children, terrorism.
Okay. Have you worked cases where you've been called upon to determine the location of a cell phone?
Yes.
How many?
And for the 130 so cases that I've helped with, the vast majority of those have to do with location, historical location of the phone.
Have you had the opportunity to validate your historical call data reconstructions, or that you do?
Yes.
And how do you do that?
Well, as we mentioned sort of during I was talking about the train up, if it's a situation, a case where we're trying to find someone who we believe is in possession of the device, and you do an analysis and you say, I think we need to go to this house, and you go there and the person and the phone are there, that's validation. if we have a case where we have some sort of other evidence that corroborates it, like in a crimes against children case, and there's metadata on media that was produced at a specific location, and we have cell site that says, okay, we know this film or something was produced here, and here's what the cell site looks like, that corroborates it. A couple examples.
So when you say metadata, can you explain what that is?
Yeah, that's outside of what I do with CAST, but that would be something that would be in a media file, perhaps, that somebody else would you extract the file from the phone using a physical extraction device or a computer or some other device. Sometimes there's metadata embedded within the image or the video or whatever that will tell you different things, such as when the picture or movie was produced, where it may have been produced, or the picture may have been taken, etc.
You're just going to offer Special Agent Collins as an expert in the area of historical cell site and cellular technology and offer for water.
Hey, you want to come side for a second? Thank you. Thank you. Can we arrange for a restroom break for Mr. Dennis, please?
Yes, sir.
We'll be in recess.
Mandates. We specifically right now are the supervisor of a squad that focuses on transnational organized crime.
So do you also have an ancillary assignment?
Not right now, I used to.
Would you explain to the ladies and gentlemen of the jury what is the CAST team for the FBI?
Sure. So CAST, for the Cellular Analysis Survey Team, is a group of specially trained and equipped agents and task force officers who do cellular analysis or mobile device location analysis.
And so when you say that, what types of records are you working with?
Usually records from phone companies or other service providers.
Okay. Can you explain to the ladies and gentlemen of the jury what is historical cell site analysis?
Sure. So when someone uses a phone or a mobile device to do something, to make a call, to send or receive a text, to check a sports score, or check their email, post something on social media, that's to connect to a cellular network or through the internet. when you connect through the cellular network, there's a record that's generated by your phones, by the phone company. So you have T-Mobile gives you service to your cell phone. When you make a call, you'll see records on your T-Mobile sheets about that call. Historic cell site analysis is using those records to answer questions.
So what's the purpose of historical cell site analysis?
To help with investigations.
And what are the main components of a historical cell site analysis?
Well, if you're being asked to do like a location analysis, in other words, to the case involves trying to determine where a particular device was at a certain point in time, you really have three things that you need. First, you need the records for that particular device. And that will say that the initial records, like a call detail record, for instance, will sort of look like a billing statement that you might get from a phone company. It will say, this date and time, this phone number, place this call to this other number, etc. Except it will also have additional information. It will say a cell tower that the phone connected to when it made that call. So you need that record of the device. You also need a record of tower locations that says, okay, the tower the phone connected to is located at this particular point on the earth. You put those two things together into some sort of mapping software and plots it, and then it will give you a general area of where the device was at the time that it connected to that tower.
So you said device. Can you testify a specific person was in a specific area?
No.
Why not?
Because the records I have are just about devices.
Okay. So there are limitations to your testimony?
Yeah, absolutely. Yeah, I'm talking about devices, not people.
Have you received any specialized training to become an agent that does CAST as well? What is that?
To be CAST certified is pretty extensive. There's several stages that the certification process is broken into. The first, so I started my initial training in 2017. The first phase of training is the CAST basic course. That's a 2 or 3 day course where agents and officers from our local, state, or other federal agencies are exposed to what cellular analysis is and how to do it at the basic level.
Do you use the CAST work in your day-to-day cases? Before you became a supervisor?
Yes.
And so is this a required assignment to go to the CAST team?
I don't want to interrupt, but there's a lot more training than just that 2 day thing. Is that okay?
Let's start with, to do that first 2 day training.
Yeah, so the first.
Is that mandatory for this?
Yeah.
To go on past that, is that something you have to apply for?
Yes. Yeah.
Okay, and to explain after that first initial training, what happens? What's the next level of training you complete?
So the next course is called the advanced course, and it's a week-long course, and that's just a more in-depth dive into each of the networks. So specifically, what are the uniquenesses of, say, Verizon or T-Mobile, AT&T, Sprint when it was a standalone provider? What do their records look like? What are the uniquenesses of their networks designed, etc. After the advanced course, then we have a sort of test. It's like a week long. When I went through, it was a mix of part in the classroom and part in the field, where it's all scenario based. So you, for instance, you'd be like a kidnapping scenario. Like, hey, this child was abducted. Your job is the asset going through to try and use the records to develop a search location and say, hey, I think that we need to go here to try and recover the child. You do a portion in the classroom, you do a portion in the real world where they have test rooms set up at different locations, and you validate the results right there. So you either find the person or you wouldn't. And at the end, you either pass or fail. So I passed, and I was allowed to continue to the certification course, which is a 4-week course. The first 2 weeks are very academic. We have a week that's basically a semester's worth of material condensed into a week. It's put on by professors from the Florida Institute of Technology. We bring in representatives from all the major cell phone providers in the U.S., both their law enforcement relations and records custodians personnel. We talk about these are the types of records that we keep in our specific record, or our specific company. We also bring in personnel from the network engineers, so the people who build the network, who design it. We go to infrastructure, so like the Sprint Network Operations Center, where they oversee the management of the whole network across the country, etc. And then at the end of that, there's a test, and you either pass and are certified, or you don't.
Okay, so Special Agent Collins, are you certified in cast analysis?
Yes.
How long have you held that certification for?
I got certified in September of 2018.
Is there continuing education or recertification that's required?
Yes, so to keep your cast certification, every year you have to attend a recertification course.
Okay. Is all of the training specifically from the FBI?
No.
What other agencies and I guess companies do the training for you?
Yes, we have partnerships, or not partnerships, but we'll bring in educators from a lot of different companies. So obviously the different telecommunications companies are critical. So we have them come to the recertification conference every year. We've had a range of other people. We've had Apple, Qualcomm, Oracle, people in the field of GPS, cellular engineering, vehicles for vehicle telematics, and anybody that's sort of involved in that ecosystem.
Okay, so you mentioned Apple, Qualcomm. What are those?
Those are different manufacturers.
Is there also specific as to cellular technology and how it works, training on that?
For what?
In terms of being a CAST certification?
After recertification?
Yes.
Yes.
Okay. How long have you been specializing in call? Detailed records analysis. Further, I'm going to give your Honor a copy of the order that was discussed about the report that was done by Judge Siegel. This was signed on April 4th of 2023. Sure.
Are you intending to seek to admit the report?
Yes. And that's what that.
Admit the report?
Yes, and that's what that.
Should we just object now that the report's already admissible?
I don't know what you're speaking of.
I don't think we admitted to admitting the report. We said we would
Excuse
agree.
me, I only want to hear from one. Whose witness is this going to be?
This is my witness, Judge.
All right, so you make the objection. So this is an order on the admissibility of expert witness testimony by Federal Bureau of Investigation Special Agent Brendan Collins. Let me read it. This is your order to the judge. Says your defendant stipulated to the admissibility at trial of the expert testimony of Special Agent Brendan Collins in the area of cellular phone forensics. This stipulation includes Special Agent Collins' testimony regarding the cellular analysis survey team CAST report, and based upon the defense stipulation to the order and judge and Special Agent Collins' expert testimony in the area of cellular phone forensics and on the CAST report is admissible at trial. What's the issue?
So I believe counsel is trying to state that we are going to object to the admissibility of the CAST report. We had stipulated to his testimony after deposing him. And then I will also bring to the record, she's trying to bring in 3 different CAST reports when we had deposed Agent Collins. We only had deposed him as to one CAST report. We had extensive conversations about whether the state would be bringing in the additional CAST reports. We had agreed at that time, if they were going to bring in those reports, she would let us know and we would depose him again. That never happened. We were always told it would be the one report of the 2 phone numbers. and which we are objecting to the admissibility of those reports based on hearsay. Also, they are misleading, and also the information in those reports have not been properly validated by an engineer.
Okay, so as of April 4th, 2022, what report was in existence as far as Special Agent Collins?
So the first one that was with regard to Anthony Williams' cell phone, as well as Mr. Demon's cell phone. That one was
What
done.
other reports are out there?
The other ones were generated in May of 2022 and immediately turned over to Defense Counsel, and I have a very different recollection of that. This was listed at the same time as Mr. Zeller that we just had, so there was never any additional request to depose this witness. But Special Agent Collins has been available for the last however long if they so chose to do so.
And Judge, I would just for the record make an objection to her characterizing that particular phone that is actually registered to David King as Mr. Demon's phone. I don't believe that has been established.
Thank you. So, what is the report?
Judge, I'm sorry, I didn't hear what you said.
I asked for the report. I need to know what the report says. I'm not familiar with it.
Yes, sir. So they're all substantially similar. They do different cell phones at different times. That one is the one of Mr. Demons and Mr. Williams, explaining how the cellular...
Objection again.
Explaining how...
I don't understand. I'm asked for what the report is. I want to see it, and you say objection again. What's your objection?
My objection is to the characterization of that it's Mr. Demon's phone and Mr. Williams' phone, actually.
Yes.
Do you have another copy of that report?
First emailed it to Ms. Liberty.
I'll get it from
Thank you.
So what is Agent Collins going to do?
Agent Collins would testify as to how he does the analysis, how he generates those timing advance bands, and what it means as to the location of the cellular devices based on the records, which is all done as a product of the accuracy of the records and the fact that the cell phone communicates in a consistent way based on the laws of physics with a cell phone tower.
see, in here, it talks about the phone 772-713-9807. T-Mobile says Jamel Demons. This route goes below 954-248-9081. T-Mobile Anthony Williams. And it has the date of the report being May 12, 2022.
Yes, Your Honor.
So this report date is after the order date.
It is. That is the second. It's the same one. It was all done at the same time. I believe, if I'm not mistaken, there was a typo that had to be finished on the spelling of the defendant's name, which is why it was generated at a second time on that point.
May I respond to this?
You respond, you say what you want, counsel.
I would just say the simple fact that it has Mr. Evans' name on it, Mr. Williams' name, that needs to be stricken along with the other three reports, which were actually filed after we deposed them. It is my recollection that we were told in court that they would not be used. There was a question if James and Francois' CAS report would be used. She didn't give us a definitive answer. We finally rested on the fact that she was not going to be using Mr. Francois' phone. So it is a little bit of surprise that is now being introduced at trial. And the other one, I believe, with Withers, we never ever discussed it.
Hold on.
Yes, Judge.
Hold on.
Yes, sir.
I don't fully understand this order dated April 22nd. It says, ordering the judge of Special Agent Collins' expert testimony in the area of cellular phone forensics and on the CAS report. So he's going to testify. I wouldn't normally admit a CAS report. I don't see why it would come in here. I don't see this specifically saying it's admissible. I see it's saying Special Agent Collins' expert testimony in the area of the cellular phone forensics and on the CAS reports in this lawsuit. He can testify. He's here. You can ask him questions that you want, but I don't believe I'd be letting this into evidence. It's just, he's here. His testimony is his testimony.
And so, with regards to that, the necessity of the maps is that the Special Agent Collins is going to testify in terms of latitude, longitude, and distances on that. Without a map, and using that for the jurors to be able to understand where this is being placed on the actual map, that's going in a vacuum.
He can show it as a demonstrative aid if that's going to help him illustrate his testimony. I don't have an issue with that. That's a different question for me. Typically, we don't just admit an expert's report. The expert's here is going to testify.
Yes, sir. Sorry.
And it's not clear for me from this order that that's what Judge Siegel anticipated, that the report was coming in. I don't have any issue regarding his testimony. They're not even, the defense indicated they're not even going to hire him regarding his qualifications. So, he's able to testify. But as far as the report coming in, I don't read your order that way, respectfully.
Understood. So, Your Honor, then if I can show the admissibility of the maps with that on there, then you would evaluate them as their offered individual.
I don't have an issue. I mean, if he's able to identify them and talk to them, that's a different issue. You're wanting to admit the whole report in as the way I understand it, as substantive evidence. And typically, that's not the way it's done. I mean, the testimony is the testimony of the witness. Not the report, otherwise it's cumulative, it's duplicative of whatever he was going to testify to. I don't see, the order talks about a date in April. This report was given after that date. I don't know if this is what the judge intended. You said there were some amendments. I don't know what the amendments are. I don't know if they're approved by the defense. They're saying they're objecting to it. Typically, that's just not done the way it's being done, putting in the document.
So Your Honor, there are quite a number of cases on that specific issue, which I'm happy to provide the court.
What specific issue? About a report coming in?
About the maps and the mapping being admissible. So that would be...
I'm not concerned about the mapping. I'm concerned about the report per se.
Well, I just want to make sure we're clear on what specifically. So some of them, this specific items are demonstrative on that. So for example, when, and I can put it up so everybody can see so it's clear. So Special Agent Collins, I anticipate, would testify that, for example, there is cell tower usage and how that would be displayed on that. So that wouldn't be confused with cell site usage. So that's because there could be the possibility that a juror would think, well, this is showing that the phone is somewhere in this purple area, which would not be correct, as opposed to, for example, a timing advanced illustration, which in this case, the witnesses can testify that the phone is somewhere in this band, based on, and then as well as, so in terms of the way the mapping is then done, to make it clear and understand that these red dots are not the specific locations, but rather the towers that are used. I think it's important for the jurors to understand that and have the first part of that analysis there so that there can't be any sort of improper recall by the jurors on that. So then as to the locations on those, then this would be one of the timing advance. So if they don't have the other first part,
Judge, I think it's renewed again.
Excuse me, counsel. I don't think she's done.
Okay, sorry, Judge.
so it's more so the fact that the timing advance data and the way it is done, I don't want there to be any confusion to the jurors to saying that this is overstating the evidence. So if I just put in these particular items without the full explanation, because I don't think it is appropriate to do so without the jurors understanding the limitations of the testimony and what the different maps show. So on that would be the specific parts the state would be seeking to introduce, because the locations of the towers are important to how the math is done.
My understanding is that the defense is objecting to that exhibit. Is that correct?
Yes, Judge.
Does that include the maps?
That does include the maps, Judge.
So they're objecting to it. So I guess you have, in some way, it has to come out how it was done. And you can talk to the witness and see if he can, authenticate it. Originally I was thinking that you were using them as demonstrative, and I would ask him if that helps illustrate his testimony or not. But if you're saying you're not concerned with that, you want to admit them into evidence. So the objection is, what's the objection?
That it's irrelevant. I would also object to the fact that
It's not relevant?
It is not relevant. It's also referring to Mr. Demon's phone. Nobody's established that number was his. It's referring to Mr. Williams' phone. You've got no testimony that establishes that it's Mr. Williams' phone. If we were to go to the other two reports, I don't know how the court's ruling on them. Again, she's referencing phone numbers, assigning them to people. We have had no testimony or evidence before the court that those actual phone numbers belong to those individuals.
Thank you. So I haven't heard any phone numbers being assigned to any individuals.
If I may, Your Honor,
Sure.
that is why the state introduced the phone slip that has been brought in through the defendant's fingerprints, that he endorsed that as his telephone number, and as such the state cannot argue that. As to all of the other individuals, those are coming in from the phone records themselves. For example, Dennis Withers and Chris Thomas, as I went through with the Sprint records custodian.
So let me start. What is the phone number that's on that corner sheet that you're saying is Mr. Demis?
772-713-0999. 9807, and that's why we had the fingerprint analysis done, and they came in and identified that as the fingerprint of the defendant.
Thank you. And what's the next phone number?
The next two phone numbers that are the easiest ones to go through, Your Honor, are the phone numbers of Christopher Thomas, 772-713-2341. And if Your Honor recalls...
713-341. Should be another number.
772-713-2341. And I can bring up here for Your Honor the specific information on Mr. Thomas's phone that was brought in earlier through the Sprint Records custodian. And there's the phone number at the top of the screen, 772-713-2341. Billing address for Chris Thomas.
All right.
Going down in the same records, because they were produced at the same time. In addition, the email address with it is ChrisThomas86. Again, consistent with Christopher Thomas. The next phone number that is on this particular is 954-371-7895. And that is belonging to an individual by the name of Dontavius Withers.
Are there any other phone numbers this witness is going to be testifying with?
Yes, Your Honor. He would also be testifying on the T-Mobile records to the individual by the name of Jameson Francois, and to go to the subscriber information for Mr. Francois's phone. This is related to Miss Adria Scott, which there's been testimony that Adria, or AA, is the wife of Jameson Francois. In addition, that phone number for Mr. Francois, 954-376-9158, is consistently in the phone download of Mr. Demons and is listed as track. And there are plenty of photographs and things of that nature that would show and illustrate that Mr. Jameson Francois, also known as Track, is the owner of that phone number.
But it's actually in his wife's name.
Correct. And if the rest of the subscriber information also says it is a family plan with multiple lines. Rate plan, family, unlimited, 2 lines include them.
On the subscriber information for the first phone that you're suggesting is Mr. Demons, what does that subscriber information look like?
That comes back to his mother, Jamie King.
Let's go back now. What's on I don't know what the exhibit number was. Did you print out anything on these phones? I think there was a printout. They objected to it.
There's multiple printouts on the phone, not all of which have been entered into evidence at this point, Your Honor.
But what's in evidence so far?
I can pull that up and take a moment. This is in State 64.
This is the extraction.
That's correct. For example, 95446. Three 7-6 9158. There are 1,129 messages between the phone owner, Mr. Demmons, and other individuals in which Mr. Prince Law is a participant in those conversations.
So again, you indicated this is Mr. Demon's phone. You just told me the subscriber information reflects that it's his mother's phone.
The plan is paid for by his mother. His mother's phone is in here. She is listed under Brazy, B-R-A-Z-Y, lady, and that is 772-501-6942, which is listed as an additional number subscriber on the phone for Mr. and the phone records from T-Mobile for Mr. Dimmons.
Judge, I just want to point out, she's saying that these are messages between Mr. Demons and various people. This cell rate actually tells you, like she stated, like it's going to track, but it's coming from Young Chaser Howard, and he's registering as the owner of the 9807 phone, which in these reports keep going back to Mr. Demons, but in the cell rate is showing Young Chaser Howard.
And so in further showing as to who owns the phone, we can look at all of the videos and images of Mr. Demmons, of which there are over 1,000 videos on the phone showing he is the user and owner of this particular device.
Judge, again, I have nothing that shows that he's a user and owner. It shows that whoever had possession of his phone took videos of Mr. Demons. They're not selfies. These are actually pictures that appears to be taken by another party.
Well, these are all videos, actually. If you want to go to the selfies, I can go to the 10,963 images to show some of those.
I don't know how she's determining their selfies, Judge, without a testimony section.
So, for example, in this particular image, it's a screenshot of a FaceTime conversation in which the large image is going to be the person who's on the other line. The local device is going to be the tiny picture up at the top, which is of Mr. Demmons. This is just one of many, many examples.
And can you go back to the main subscriber information page?
In terms of this one?
So where does it show who the subscribers are?
This is from the device itself, Your Honor. This is an extraction from Celebrate of that phone in terms of information as to user other accounts that are on this particular phone. You have YNW Melly booking at gmail.com. You have YNW Melly a Twitter account. You have YNW Melly an Instagram account. You have Melly.Montana, the Snapchat account, which the Snapchat is already in evidence, showing that one. You have Jamel.Demons, a Facebook account as well on that. In terms of the content of the messages themselves as well, show that this was Mr. Denton's phone and that he is sending out information and things personal to himself on this. So there are multiple different types of information to show them.
So just to make, if we were to actually go through all of these, as I've informed the court before, you're going to see messages from both of the decedents to their girlfriends, to other people. There is no question that our client had used his phone, but so did all his friends. So this was a phone that they passed amongst each other. I don't think bringing up the Celebrite or a couple of selfies proves that it was actually his phone. For that argument, there's pictures of Michael Jackson on there. So can I say that Michael Jackson is well owned his phone? Based on her argument, that's what she said.
Are you ready for a taste of Wisconsin?
This was 100% possessed only by Mr. Demons. Just picture Melanieking, I guess he shared the phone with future also.
Anything else? State? No, anything else from the defense?
I would just point out that not only is that phone in Jamie King's name, so is the phone that she's trying to assign to Anthony Williams, this is the victim's name.
Well, I don't, the counsel suggested and gave me four phone numbers. One, counsel indicated was Mr. Demon's phone. That's the 713-9807-772 area code. Then she had, there was one that was listed as a Christopher Thomas phone, another one as a Mr. Withers phone, and another one as Francois, also known as Track's phone. I haven't seen one as being on Mr. Williams. Am I mistaken?
Yes, Your Honor, there was one on Mr. Williams that was on the initial report. That is the 954-248-9081.
954-248.
9081.
And that's Mr. Williams, one of the students? You said it's his phone?
Correct, that phone, and defense counsel is well aware of the fact that the phone that Mr. Williams had at the time of his death was recovered, and a full file system extraction was done from that phone that shows it was his phone on that, and as well as the fact that the Celebrate extraction that we just went through also has Mr. Williams saved under the name of Twin in the phone of Mr. Demons, in which there's discussions back and forth that identify the 954-248-9081 phone number as that of Mr. Williams. And that there's discussions, for example, that they have gone on trips recently. They've gone to Detroit. And there's then again photos of Mr. Williams on the phone of Mr. Demons in Detroit that are sent back and forth on that.
Regarding this witness, is he going to testify regarding Mr. Williams' phone?
He's going to testify to the locations of that particular cell phone, yes.
And they're going to be identified by phone number?
At both.
Anything else?
No.
Anything else?
Just, if you're going to let it in for demonstrative purposes, I would say at the very least that the names are stricken from the reports and redacted, sorry. And we refer to only the phone numbers, not to the individuals.
Thank you. So we're going to bring the jury in now. As far as that demonstrative, I'm getting conflicting information. I don't want something going before the jury about this is Mr. Devin's phone or this one's phone. There's circumstantial evidence to that effect, but I'm not putting that in evidence that way. Just show the portion that shows the maps, and you can talk about the maps and the other things, but leave out the portion that has at the bottom, or I forget if it's the bottom or top, that identifies Janelle Devin's phone. Just use it by the phone.
Use it by the phone number. Okay, that's not a problem. So I think I would need just a couple of moments to adjust that.
Go ahead.
Okay.
We're in recess.
Thank you, Judge.
Gang, gang. Court is in a brief recess. All right, court is in a brief recess, gang. Shout out to everybody that's in the crowd right now. All right, appreciate everybody coming in for this trial. We definitely watching the trial. I got some other shit I'm doing, but I'm checking it out. If you want to come to the platform, the link is dropped. I think it's already pinned to the top. But if you want to come to the platform to discuss this trial, let me know. The StreamYard is dropped. Let me see. I don't think a lot of people came over from the other live, but we do got some people over here for the trial. This is ridiculous. As a matter of fact, y'all, we are definitely, I think, 7 hours in. Let me check I think we've already been 7 hours in. So this is going to last a while because they started late. I don't know if they substituted out a juror. Do anybody know if the other juror came from the hospital? But remember, it was a juror that had got sick, the reason that they started late. Now, the woman that's up right now, y'all, the person that's defending, this is her mugshot, which only reason I'm showing y'all this is because she's fresh out of jail, and it's kind of crazy how she's representing a murder trial, because this is literally a double murder trial, but she's representing this murder trial fresh out of jail. Do y'all think she's doing a good job or not? I really don't know. All right, I really don't know if she's doing a good job or not on this trial. I'm watching in and out. We just finished a big live over on the jackyje case. Shout out to everybody that came over to come check out the jackyje case. And now we back at this trial. Now, when they say a brief recess, I don't know what they mean by that. All right, because when the judge get up and walk out, you see what I'm saying, he's definitely gone for a minute. All right, let me see. Princess Israel says, hell no, she is not doing good on this trial. Shit. I don't know. This is a death penalty trial. I wouldn't trust her with my life. But that's what's going on, gang. He's definitely trusting her with his life. And like somebody said earlier, this dude is young, dumb, and stupid. Watching this trial, he is very young, dumb, and stupid. And he killed his friend. But we was looking at the paperwork earlier, and we was reading over what was going on with it, with what he had going on, which was some fuck shit. But that's how it's playing out. It's really playing out pretty ridiculous, but that's what's going on, gang. It's playing out very ridiculous. Let me see if I can pull up that paperwork. Let me see. Actually, we do got some more. Y'all know he was denied the dentist. I showed that earlier. Ordered to only wear 5 suits. But what y'all don't know is that, let me see, y'all don't know about this one. All right, y'all don't know that Fredo is supposed to be testifying for the prosecution. All right, now that's very weird, but that's the truth. That's some weird ass shit, but that's the truth. All right, somebody say, why he ain't laughing now? Shit, they told him to shut the fuck up, because he been laughing the whole damn trial. But before they come back, because they got a little brief session, before they come back, let me show y'all this paperwork right here, gang. All right, let me show y'all this paperwork right here. For y'all that don't know, Fredo, Mr. Fredericks
Givens is supposed to be testifying. I've already showed paperwork that he would be testifying, but this particular paperwork is the motion that they did in order to get him to testify. All right, so it says notice of hearing for Frederick Givens. So ever since June 2022, they've been knowing that Fredo is going to testify. And I think that was one of the questions the other day I was asking. Do y'all think Fredo is going to snitch? Do y'all think he's going to snitch? All right, you know, Fredo supposed to be gangster shit, but look what it says. It says who's purported to be a witness. He is on the witness list to testify in this case. Now, you know they like to play divide and conquer. They like to divide you up and conquer you. That's how you do divide and conquer tactics. So we don't know if Fredo is going to snitch or if he's going to get on the stand and plead the fifth. He may snitch a little bit because they will fucking throw his ass in jail if he doesn't tell what he knows because he has been drugged into this. All right, they're going to fucking throw his ass in jail. But I wanted everybody to look at this piece of paper right here because Fredo is most definitely supposed to testify. All right, shout out to Young Clo said Boosie free. We definitely going to be looking at that. Shout out to Young Clo. I'll be looking at that since Mr. Boosie is free and seeing if we can see what's really going on with Mr. Boosie. All right, but remember, gang, Frederick Givens, a.k.a. Fredo, is supposed to be testifying in this particular case. All right, now that's the divide and conquer tactic, but at the same time, that's exactly...
One Medical is the modern doctor's office for everybody in every lifestyle. Get 24/7 on-demand virtual care and in-person care at offices nationwide. All from doctors you'll love. This is no ordinary doctor's office. This is One Medical. Click now to learn more.
All right, gang. I'm back. I had to take a phone call. Shout out to the game, man. Yeah, they say he's pleading the fifth. They saying Fredo's pleading the fifth. Yeah, right. I think he gonna plead the fifth too. Well, if they've already got him prepped up, he may not can plead the fifth unless he surprises them. If they got him prepped up, then he may not can plead the fifth. All right, he may not can plead the fifth. All right, hold on 1 second, guy. Yeah, usually when the prosecution put you on the prosecution list, they don't have it. Like, if he was on the defensive list, he may can plead the fifth, I guess. But usually when you're on that prosecution list, they already got you prepped up where you can't plead the fifth. So I think it's going to be pretty hard for him to plead the fifth. You see what I'm saying? If he's on the prosecution list, which I showed y'all, he is on the prosecution list. So it's going to be pretty hard for him to plead the fucking fifth. All right, it's going to be almost impossible for him to plead the fifth. All right, because he's definitely on the prosecution's list. Let me pull up the prosecution's witness list. I just showed y'all the motion. Let me see. Let me find the prosecution's witness list so I can show y'all Fredo on there. Because he's definitely on the prosecution's witness list. And like I said, usually when you're on there, it's almost impossible to plead the fifth. Let me pull that up for y'all real quick, gang. Shout out to the game, man. All right, so look, this is the prosecution's witness list. All right. And as you can see, Frederick Givens is right there. All right, he's right on the prosecution's witness list. All right, gang, so usually when you're on the prosecution's witness list, it's almost impossible to plead the fifth because they're not finna bring you in there and embarrass them by you pleading the fifth. Since Fredo is on the prosecution's witness list, I don't even think he can plead the fifth. I don't even think that's an option. Somebody say, you sound tired, you need some rest. I'm gonna get you, my nigga. I'm ready to, hey, this trial is exhausting. Shit, usually when I get out of my live, I go to the bank and go do some shit, but shit, not today. I gotta sit up here and do this trial, but I'm gonna get you, my nigga. Nigga say you sound tired. Hey, y'all, do I sound tired? I may be tired. Hey, let me just fall asleep on this damn live. How about that? How about I fall asleep on this live? All right, giving out the knowledge out, this drain of energy. Yeah, I'm running 2 shows, man. Shout out to my boy Blaze Your Face Durante, man. I love you, my nigga. Appreciate that, my nigga. Oh, shit. Let me see. He's not as energized as this morning. You know what's the... You motherfuckers. Oh, my God. Oh, my God. Yeah, I'm tired of calling people. You right, Mr. Jones. I call like 30 fucking people. Nobody answer the damn phone. Yeah, I'm tired of calling people. Shit, I was energized this morning, shit, because, shit, I gave y'all all that damn energy. I ain't got no more fucking energy. Goddammit. All right, I done dropped the damn link and nobody ain't came up, so I got to run this bit by myself. Appreciate that, D. That's the fake lady D, man. We love you, fake lady D. Shit, we doing our thing, goddammit. Maybe I can get some energy. I have some energy tonight, though, I'm finna get ready to go to a restaurant a little bit, give me something to eat. Shit, I'm about to go to a restaurant and get something to eat. I'm glad my boy Blazo Durante, he say he with me. I'm glad you thinking about me, man. I love you, my nigga. Shit, because we definitely in this bitch. Zakai, man, you know I love you, Zakai. Shit, it's going down, man. Zakai been doing her thing, doing that research, getting it going. Yeah, ain't nobody answer the phone for me today, man. They done got, motherfuckers. I'm finna go change my number too. I told y'all I'm gonna have a brand new fucking number. I'm gonna change my goddamn number. Everybody gonna answer the phone when I change my number. I'm on an Illuminati blacklist. They on my ass, y'all. They like, they out on the phone with each other. Do not answer paperwork. This nigga right here. Do not answer paperwork. Yeah, hey, I'm finna get some sleep. Shit, I'm gonna go to a restaurant, give me something to eat, and give me some goddamn sleep. Yeah, it's been a long day, Lady J. How about you bring your ass up here and narrate the show? Lady J, it's been a long day. Yeah, right. Your ass sleep. Lady J said, fuck that nigga. Your ass is sleep. Yeah, I'm gonna get you, Lady J. Uh-huh. Lady J, hey, Lady J supposed to be up here narrating, y'all. Talking about I tried that earlier. Oh, yeah. Good job. It's my girl, Lady J, man. Y'all know we been at this shit all day, man. Y'all know how it is. We got the morning show going and shit. You see what I'm saying? Y'all know how it is. Oh, they back. Thank God these bitches are back.
Apologize if you resolve those issues before we go further. Approaching traffic out and you resolve it. I'll see you all back tomorrow morning. So remember your admonition, do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case because there's certainly no research about the case, all right? You hear that every time you break, I tell you that, and it's very important. So, ladies and gentlemen, so I believe we need to see you back tomorrow. Thank you.
Tomorrow morning, 9 o'clock. Appreciate that, Judge.
Thank you, everybody. Anything further to discuss, Johnson?
I don't believe so.
If there's any emergency or anything else, contact my office, so there's a message me, so that you're calling for record of that.
Understood.
Thank you.
All right, thank you all, appreciate it.
Thank you.
We're adjourned.
Thank you. Danny.
All right, gang, court is adjourned. We will see y'all back tomorrow morning for the YN Melly case. That'll be 8:15 Central Time. It'll be 9:15 Eastern Time, I believe. And remember, gang, do not forget the morning show. All right, 11 a.m. tomorrow, we'll be back for the morning show. We'll be talking about jackyje once again. Y'all know the headline news is definitely going down on the morning show. You see what I'm saying? I'm about to get the fuck up out of here, gang. Y'all say I sound sleepy. Let me go lay my ass down. Let me go to the bank and go fan my face with some of them federal notes. All right, but be sure to bring your ass back tomorrow for the case. All right, 8 a.m. early in the morning, gang, for the trial. Also 11 a.m. for the morning show. All right, I will see y'all tomorrow, gang. I'm about to get the fuck up out of here. All right, I will do a wig on, wig off, but let's go ahead and do the theme song. It's going down, gang. I love y'all. Let go. What's up, paperwork party? Gang, 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 gang. It's paperwork party, paperwork gang, gang, gang. Hit the like button. Let's go. When you come in, let go. Hit the like button. Hit the like button. Hit the like button. My likes should match my views. Right, man. Hit the like button. Hit the like button. Hit the like button. My likes. So when you come in, hit the like button. What's up? My likes should match my views. Hit the share button. My likes should match my views. Hit the notification. Let go. Let go. My likes should match my views. Come on, y'all. Yeah. My likes should match my views. Let go. Hit the like button. Hit the like button. Yeah. Hit the like button. My likes should match my views. Hit the like button. Hit the like button. Come on. Hit the like button. My likes should match my views. Let go. Let go. My likes should match my views. Let's go. My likes should match my views. My likes should match my views. Let go. Let go. My life should match my views. Hit the like button. What's up, paperwork gang? Gang, gang, gang. Hit the like button when you come in. Hit the like, notification, man. Cash out, let's go, y'all. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out. Let go. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out. Let go. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out. Hit the cash out. Hit the cash out. Hit the cash out, or get your ass out. Come on, y'all. Or get your ass out. Hit the cash out, man. Or get your ass out. And just get out, man. Come on. Or get your ass out. Donate to the channel. It's going down. Your ass out. Hit the cash out. Hit the cash out. Hit the cash out. Or get your ass out. Hit the cash out. Come on, y'all. Hit the cash out. Hit the cash out. Or get your ass out. What's up, paperwork party? It's paperwork party. Paperwork gang. Hit the like button when you come in. Let go. Hit the likes or get the hell off my page. Paperwork party. I done stepped up on the stage with no script laid. Come off the fade on this page. Riding with a 12 gauge. I'm spilling the lemonade. My helicopter got blaze. A condominium with base. They ask my real age. I'm chilling with Dennis Quaid. Hit the like button. Hit the cash app. Donate. Don't hate. I'm in Mexico sitting on wait. Hit the like button or get the hell up off my page. Paperwork party. I done stepped up on the stage with no script laid. Come off the fade on this page. I'm riding with a 12 gauge. I'm spilling the lemonade. My helicopter got blades. A condominium with maze. They ask my real age. I'm chilling with Dennis Quaid. Hit the like button. Hit the cash out. Donate, don't hate. I'm in Mexico sitting on wait. What's up, paperwork gang? Gang. Hit the like button when you come in. Hit the share notification and hit that cash out. Let go. Hey, yo, hit the cash out, man, or get your ass out. Let go. Hey, hit the cash out, nigga, hit the cash out, or get your ass out. Let go. Hit the cash out, nigga, hit the cash out. Hit the cash out, or get your ass out. Yo, hit the like button. Let's go, man. Hit the like button. Hit the like button. My likes should match my views. Hit the like button. Hit the like button. Hit the like button. My life should match my gonna just get out, man. Or get your Come on, donate to the channel. It's going down. Yay. Hey. Hit the cash out. Or get your ass out. Yo.